those that I haven't had an occasion to work with. The senior judges have an open door policy. You can go to them if you need to maybe bounce something off of them or just get some guidance. I've done that a number of occasions where I am not certain whether I'm on the right track, and those measures have all assisted and fortified me with the reassurance that there is collegiality, there is some type of fortification, and amongst the acting judges, we've also have a support network that we've developed so that we can try and pull each other through the very difficult days. And sometimes there are days where you just feel overwhelmed, but we get through it.
As mentioned earlier by the Chief Justice, you have written some complex judgments. It appears as if you have certain strengths in the area of family law.
Yes. When, as a practitioner that started out in the 1990s, I think most of what we were exposed to those years back was premised on family law and criminal work because that was our bread and butter. And then, of course, I expanded in my thesis on international family law and children's rights for that very reason, because I have a passion for children, I have a passion for the vulnerable, I have a passion for women, and for all of the people who have really been affected in ways that I can say family-related issues. That is real. It is things. It's about things that happen on a daily basis in the community that we need to be alive to. Having said that, as judges, I believe that we need to be grounded and we need to understand the plight and the heart of our community. And so, even as a magistrate, the family courts were part of what I did, and seeing the need and the hurt and the pain of our community really made me feel that that was where I needed to invest.
So the judges in the division, there is a need to appoint some judges and designate them as Hague Convention judges. Should you be appointed, would you be able to contribute in that regard?
I certainly will, AJP. The strength, I would say, that I would bring to the bench would be in that area, because that is what my studies were centered around, and my mini thesis focused on links between international child abduction and relocation disputes. Other areas of my coursework provided me with the understanding of international surrogacy laws, international inter-country adoption, international children's rights, conflicts between rights of the child and other rights enshrined in the Bill of Rights, child-aided households, and the base of my studies was predicated on the Hague Convention and the Africa Charter on the Rights and Welfare of the Child. So, absolutely. Yes, AJ.
You were involved in SAJE training. In which areas did you assist SAJE in the training of magistrates?
I was involved on an ad hoc basis, but as regional court president, that is when I needed to really step up to the task. The aspirant regional court magistrates needed training, and so my input centered around the civil component, family law, family advocates input. So where my strength were, as well as obviously hearsay in light of the judgment that I'd written in that regard. Then I also, as acting regional court president, introduced a course to aspirant regional court magistrates who are aspiring to be appointed. And it was the first of its kind that I collaborated with Sergey on. And so we vetted a pool of eligible practitioners from all areas of the legal profession. And I then sourced other peers and magistrates and judges of the KwaZulu-Natal High Court to assist with that training.
And then lastly, can I just get clarification? I made a note here that you said that none of your judgments have been overturned to date. Is that the position?
That is correct.
Thank you, Chief Justice.
To my knowledge.
Thank you, Chief Justice.
Thank you, AJP. Mr. Boshoff?
Thank you, CJ. Morning, Mr. Andrews.
Good morning.
Given the location of the division and the fact that Parliament is in the province, obviously the provincial government, the metro and various municipalities, administrative law makes up quite a large part of the caseload in this division. So I'm just going to ask two kind of technical questions on the subject matter, and then please, it's not to catch you out or anything. I'm going to be asking it of all the candidates.
Very well.
So there's the so-called, I suppose, colloquially termed Part A and B applications, where Part A is for interim relief pending the final application in Part B. What is your understanding of the reliance on a general right to review or a general right to fair administrative action as the basis for establishing the prima facie right component of interim interdicts?
Well, as a starting point, the exercise of all public power is subject to judicial review, and judicial review is a mechanism for keeping public authorities accountable to uphold the rule of law. So when we are dealing with the principles of legality, it is derived from Section 1C of the Constitution, which is the incident of the rule of law, which is the principle of legality, which holds account the exercise of all public power and for the performance of a public function, reasoning, and it aligns with the transformative constitutional agenda, which speaks to the principles of accountability, transparency, responsiveness, and openness. The exercise of all public power needs to be justified in order for it to be lawful and valid. And so in terms of, and I'm predicating my answer just so that I can give you the assurance that I do understand the nuances between the principle of legality and when PAJA is invoked, and that when we look at it, we look at it through the lens of the cases such as Fetch or SAFU, as well as the pharmaceutical matter, where they interpreted legality to be an act reasonable and to give effect to reasonableness. In SAFU, it was the good faith consideration. And in fact, pharmaceuticals...
Sorry, Chief Justice, I really apologize that I have to intervene, but this is going to really be long.
Sorry.
But so I would really like to just refocus the question. It's two components. Yes. An applicant brings an interim interdict.
Yes.
What they say in the interim interdict is that for the prima facie part, we are relying on the general right to fair administrative action, which is in Section 33. Now, can they do that to secure an interim interdict, or do they need to show something more?
Thank you, Commissioner. And if I can perhaps be of
Yes.
further assistance, are you familiar with the case of National Treasury versus Outa, in which the Concord dealt with this very question?
Yes, as far as I am, are you talking about an interim interdict?
Yeah, so we're going to court. Let's
Yes.
say we've lost out on a tender.
Yes,
We go to court, we want to stop the implementation of the tender, and our reliance for ticking the first box of the interim interdict is to say, we have a right to fair supply chain systems or procurement in terms of Section 217 of the Constitution, and that is the prima facie right we're relying on to satisfy that part of the interim interdict requirements.
yes.
And courts have engaged with this quite a few times, and in the last month, there have been 3 judgments on this very issue, where the courts have engaged with this on the basis of the outer judgment. And I just wanted to test your understanding of that. And please, if you're not familiar with it, it's fine. We can
Yes.
move on. Really,
No, I'm not 100% familiar, but I would be able to navigate that. I haven't been given many matters dealing with administrative action where these complex issues have been raised, but I have a good understanding of what the requirements are for an interim interdict and for final relief. And so I would build around that, and I would certainly know how to research. I would back it up, and I think from the manner in which you see me approaching a judgment, I would look at it from an academic lens. I'll look at it from the reported case law, and then I will be able to give you an outcome based on that. Thank you.
Thank you. And then the next one, just what is your understanding of the concept of collateral or reactive challenges, and can organs of state raise them?
I'm not certain.
Okay, thank you.
Thank you.
Nothing more, CJ.
Commissioners? Commissioners on the virtual platform, do you have questions for the candidate? Professor Marumachai?
Thank you very much, CJ. Good morning.
Good morning.
Can I please take you to your documents of evidence?
Yes.
In page 58, and I think it's paginated page 57.
Yes.
Yes. There is a judgment there, which is a reported judgment of Boysen versus Stander.
Yes.
In that judgment, you had 2 people. One was relying on, they wanted to share a property and some of the assets
Yes.
in their partnership.
That's right.
And one was relying on a common law remedy of actio communi dividundo, and the other one was relying on universal partnership. When I read this judgment, first and foremost, you start by detailing what each party's case is. And only at paragraph 42, you tell us what the main issue that needs to be decided on the case is. Now, that is not what I want to ask you about. That is obviously a challenge, but that's not the point.
Yes.
Then you state what you believe the relevant law is. After doing that, then you go to what you term the discussion. But in the discussion, it doesn't seem like you are actually dealing with the common law remedy and the universal partnership. And after 4 or 5 short paragraphs, you come to a conclusion. So now, what I'm confused about in this judgment is what led to you adopting the fact that the plaintiff was right on the common law remedy and that the defendant was wrong on the universal partnership. That doesn't come out clearly. I just want to understand your reasoning
Yes.
in the judgment.
Thank you, Commissioner. The judgment was written when I was still quite new on the bench. And obviously, I wasn't comfortable in writing judgments of this complexity. I acknowledge that there is room for improvement, and I believe that with time I am able to grow. The common law remedy or consideration was based on the evidence that was provided by the litigant. This I weighed up in terms of all the other probabilities, and it doesn't come through very clearly in my judgment. But I can give you the assurance, Commissioner, that I do understand what the considerations are in terms of the manner in which an action proceeding is to be dealt with. And then, of course, with my insight into how to approach matters in general and how we are meant to develop the common law through the constitutional lens, certainly going forward, I will take to heart the critique and apply it.
Okay, no, that's fine. My second question is, assuming that on this particular judgment, the plaintiff is not happy with the order, and they want to appeal the order, what is the test for the application for leave to appeal? In other words, what would satisfy, what they ought to do to satisfy you to grant them leave to appeal?
Yes, that would be born out of Section 17 of the Superior Courts Act, which sets out what the criteria is, and in the main, it will basically be predicated on whether or not another court would come to a different conclusion.
Is that the test?
The test.
Yes. I'm just saying, is that the test that they need to satisfy? Okay, no, that's fine. Let's leave it there.
Okay.
Thank you very much, CJ.
CJ, may I just follow up on the question relating to the judgment that the professor asked about? Good morning,
Good morning.
ma'am. Following up on the question that the professor asked you about this judgment, JS versus JHS. Well, first, let me commend you that it is a good judgment, and it deals with the practical and the lived experience of women who more often than not find themselves in unequal power relations in their affairs. But then, as I read the judgment, I was also as confused as the professor was in your attempt to distinguish between actio dividendu and the universal partnership. But then there is an importation of just an equitable remedy that you brought into the judgment, which is ordinarily not a consideration when you deal with universal partnership. And I thought I should ask you, what actually motivated you to break away from the principles as outlined in universal partnership, the requirements of a universal partnership? So why didn't you just stick to dealing with the case as a partnership between life partners and not bring in the just an equitable remedy?
Obviously, with the benefit, thank you, Commissioner, for the question. Obviously, with the benefit of hindsight, looking at it through a different lens, I think one could look at it or have those concerns. For me, it was more about taking a step back and doing what was needed for the litigants being steeped in the atmosphere of the trial. It was clear that they both needed to share equitably. And maybe my reasoning wasn't clear in the judgment, but my thought process was that they needed to have there had to be some equitable division so that each of them would be able to share in the estate that was built up over quite a number of years in the union.
Thank you, Chief Justice.
Commissioner Ngoito?
Yes, thank you, Chief Justice. The problem, Ms. Andrews, that I'm grappling with right now is I just don't know how to assess your candidature and your knowledge of the principles of administrative law. Because on the two administrative law questions that were asked by Commissioner Boshoff, you didn't do well. So I just want to re-ask those questions in a practical way, not in an exam type way, and just test what your grasp of these principles is, especially because you're trying to become a judge in Cape Town, which is basically the seat of Parliament, where probably 60% of civil cases are public law cases. So let's start with the first one, which is the outer one. Let us assume that you are preparing to come to your interview here at the JSC, and a political party brings an interdict to stop the JSC from interviewing you. And we know that the process of interviews is provided for in Section 178 of the Constitution, in terms of the 174 of the Constitution, 165 of the Constitution. So when the JSC is interviewing you, it's exercising an original constitutional power. And somebody says, I want an interdict against the JSC from interviewing Ms. Andrews. What do they have to show on the outer principles in order to succeed? And the case came before you. What would you require the applicants to show in order to succeed?
The applicants will have to show a clear or prima facie right, that they would have to show that there is irreparable, potential irreparable harm, as well as the balance of convenience that needs to be in their favor, and that there is no alternative remedy.
No, I'm saying in outer.
In outer.
Yes, what would they have to show? That's Webster versus Mitchell. But we're talking about an interdict against the exercise of a constitutional power.
I'm sorry, I've just drawn a blank.
All right. Now then we look at the second issue, and it was phrased in technical terms as collateral or reactive or defensive. But let us assume that an organ of state has given a tender to party X, but it no longer wants to carry out with the tender. And then party X comes to court and they say, I want to enforce my tender. And the government now says, no, no, no. The way in which we gave you this tender was unlawful. That is their defense. How can they raise that defense between PAJA and legality?
In terms of PAJA, that would be based on the administrative action, which then would invoke the provisions of PAJA, and then you would have to look at the grounds set out in Section 6 of PAJA to see whether that is, it fits that requirements.
And then if it's an organ of state and then they say, no, we want to set aside our own decision, can they rely on PAJA?
The administrative action, in my view, is there just for the administrative the administrative action has to be defined within PAJA.
Yes, now I understand.
Yeah.
Let's not go to the definition.
Yes,
It
and
will
it
take us a
applies
long time.
whenever,
I just
yeah.
want to know, if I'm an organ of state, I've given
Yes.
a tender, I don't like it, can I rely on PAJA to set it aside?
An organ of state will have to rely on the principle of legality.
Yes, and then PAJA will be applicable or not applicable.
That is where there's a gray area, because in some instances, if PAJA covers it, if you look at Beta Star is the authority that says that if it fits within the PAJA definition, then that is how it should be adjudicated.
So as far as you understand, an organ of state has a choice between PAJA and legality
An
to
organ, no, an organ of state would then be on the principle of legality. PAJA is for administrative action.
Now, I understand. Well, I'm saying, can an organ of state say, I want to go to court to challenge my own decision to award a tender or not?
It has happened.
I know, but
yeah.
I'm asking what the law is, because now you are the judge and I'm coming to you, I'm saying I'm acting for Transnet. We've just given this tender, we don't like it, we want to say, and I've got an application, and you look at the notes of motion, it says in terms of PAJA.
Commissioner, I'm not 100% sure.
All right. No, that's fine.
But I would, obviously, when a matter like that serves before me, I would double check to see whether or not it falls within the PAJA Act, or whether or not they have missed the application requirements, and maybe it should have been brought with under the principle of legality. And because if one looks at it, it is the rule of law is what the principle of legality is based on.
All right. No, thank you very much. Thank you, Chief Justice.
Thank you.
Judge President Mlambo.
Thank you very much, Chief Justice. Good morning, Ms. Andrews.
Good morning, JP.
I just need clarification. In your extensive acting stints, you mentioned 81 weeks. These are all in the Cape Division?
Yes.
In what areas have you acted predominantly? Is it criminal or civil?
In both areas, but predominantly in the civil pool,
Predominantly it's?
in the civil component.
Uh-huh. Okay. Thank you very much, TJ.
Thank you.
Thank you, JP. Ms. Andrews, we've reached the end of your interview. Anything you want to ask us?
No,
Solicitors?
Chief Justice, I'm covered, and I'd like to thank you for the opportunity to present, and I'd like to thank the commissioners for the opportunity as well.
Thank you for
Thank you.
making yourself available. You're excused. Good morning, Ms. Holderness.
Good morning, Chief Justice. Good
It's an
morning, Commissioners.
unusual name. I've never heard of this name before.
It is an unusual name, Chief Justice. I understand there's only a few of us in the country.
Really? Does that not feel lonely? How are you?
I'm well, thank you, Chief Justice. How are you?
I'm fine, thanks. Okay, let's do this. You are a member of the Cape Bar.
I am.
Have been for about 20 years?
Yes, approximately 20 years with a very brief sabbatical, Chief Justice, but otherwise uninterrupted for 20 years.
All right. But before you joined that bar, you did a number of things which start with your academic career. You have 3 degrees,
I do.
2 from Rhodes, 2 legal ones from Rhodes, and an MBA.
That's correct.
Why did you decide to study for an MBA?
Chief Justice, I did my articles and 1-year post-articles at Buchanan Boys. I always had a vision from a very young child to be on the bench, and I found myself somewhat disillusioned with the attorney's profession, and I felt that I needed to have a little bit of distance and different experience before I joined the bar. So I decided to do an MBA to gain commercial experience, and thereafter just to work in corporate briefly before taking up chambers at the bar. So that was really my thinking at the time.
All right. Well, your CV reflects that after you did your articles, you worked in the magistrates' court in a few districts in Cape Town. For how long was that?
Chief Justice, I didn't work specifically in the magistrates' court. I appeared in most of the magistrates' courts throughout the Cape Town as a candidate attorney, but I didn't take up any role as a magistrate.
Yeah, I found that a bit confusing. Okay. So you went on to become a professional assistant, but then you say you became disenchanted with the sidebar.
Yes, indeed.
And left.
My
Okay.
vision was always go to the bar and ultimately to, if circumstances permit, be elevated to the bench.
You were a management consultant for KPMG Consulting,
Yes, in Johannesburg, Chief
but for a
Justice.
brief spell. Was it a year?
It was approximately a year.
Okay. And then you volunteered at the Red Cross Children's Hospital.
I did.
Very commendable.
Thank you.
And then you did your pupillage and went to the bar.
Yes, Chief Justice. I did my pupillage in Johannesburg at the Bridge Group in Sandton.
What kind of practice have you run as an advocate?
Chief Justice, I first started off with motion court work. I think I was involved very briefly in one pro bono matter, but by the time I started in 2004, pro bono work wasn't something that people were starting out with. So I found myself mostly in unopposed motions, and I was fortunate to build up a fairly busy motion court practice, which then developed into also dealing with a number of opposed motions and civil trials. So it was a generalized practice. I think I was hoping with some commercial background that I would be brought into commercial matters and big junior briefs. That didn't quite materialize, so I tended to run all of my own matters. And I realize now that it perhaps would have been much better in the long term to try and follow a track of more public law work, but that wasn't the path my practice took. I found that I was doing increasing amounts of family law work, which is engaging and stimulating work, but I was hoping to not let that be kind of the main thrust of my practice, but that ended up being towards my later years at the bar, much of the work that I was doing, curatorships, family law, and then some civil trials, general commercial work, property law.
Okay. Well, you've achieved many other skills. You were an arbitrator with AFSA since 2016.
Yes, Chief Justice.
And with the Commercial Property Tribunal.
That's correct.
What happens there? What's that about?
Chief Justice, I was invited, I'm not sure of the exact year, I do have notes here.
Well, your CV say 2016?
2016, yes. So I was informally approached and asked if I would be interested in joining the tribunal. I then had to pay for my trip to Johannesburg and do, I think it was a 5-day course through the University of Pretoria to qualify as a commercial property arbitrator. I was only ever approached to be an arbitrator on one occasion, and that matter didn't run. So unfortunately, it didn't bear fruit. I did do the course, and I am still part of the tribunal, but I've never had a full arbitration over which I've presided. In respect of the Commercial Property Tribunal, I have resided as an arbitrator in other matters, and in fact, I'm presently on a tribunal panel with a retired judge of the SCA and a female silk from Johannesburg. So I have been an arbitrator in other matters as well, but
All
not for
right.
the Commercial Property Tribunal.
All right. And you are also an accredited mediator.
I am Chief Justice.
Okay. You have undergone the aspirant women judges training course run by the South African Judicial Education Institute,
Yes, I went
the advanced course.
the advanced aspirant judges training through SADJ. And then I also, prior to my first acting appointment in 2015, I went to Johannesburg to attend the acting judge workshop run by, or it was convened by Les Morrison SC.
All right. You have also acted as a small claims court commissioner
Yes.
for 3 years. Okay. When did you start acting as a judge?
My first stint was in 2016 in the 4th term. I then did 3 consecutive stints, Chief Justice. So I did the 4th term of 2016, and then the 1st and 2nd terms of 2017. Sorry, if I could just check my notes. And then my next stint was in yes, the 1st and 2nd term, and then the 1st term in 2018. When I finished my 3rd term in 2018, Chief Justice, I had a long-running criminal trial, and I unfortunately don't have a record of the number of weeks that I sat as an ad hoc acting judge in that criminal matter in order to finalize it. It ended up being, it was in the media, it was a considerably more complex trial than perhaps I envisaged, but I don't have a record, but I know that that was several weeks. Thereafter, I acted in 2023 in the 4th term, and I was invited again to act in 2024. That was for 2 one-month periods, and then for a further 3-week period in June 2024.
And during those acting stints, one says from your judgments that you've sat in a wide spectrum of cases.
I have, Chief Justice, yes.
And you've written about 58 judgments.
Chief Justice, I made an error here, and I have sent through to the JSC, and I apologize, only on Sunday. When I was going through my judgments in preparation for my interview, I realized that I'd actually written quite a few more. And I made a table of a full list of the judgments, which included the judgments which I've handed down subsequent to my application in June. On my calculation now, the number of written judgments I've handed down is 73. That does not include any leave to appeal judgments. I didn't understand that those should be included. If those were to be included, they would probably be approximately 15 to 20 over the course of those 60 or so weeks that I've acted. But my full written judgments, excluding extempore judgments, obviously, which I haven't included, and leave to appeal, are now 73.
Okay. And at least 3 of those judgments have been reported.
That's correct, Chief Justice.
And in respect of those that have been taken in appeal, you were upheld.
Yes, I was. So none of them have been overturned, Chief Justice.
Okay. Acting Judge President Goliath, do you have questions for this candidate?
Thank you, Chief Justice. You have acted intermittently 2016, 2017, 2018, and then you went back to your practice, and then you came back 2023 and 2024. How did you find your growth as an acting judge, having started in 2016 and where you are now?
I think every acting stint, acting judge president, has been different. I certainly feel that I have grown as an acting judge in terms of my command of the courtroom, my confidence in my abilities as an acting judge. In my initial stints, I did fairly long-running criminal trials, and those were a great experience for me as an acting judge, but because acting judge president, you decided not to allocate criminal trials at this stage to the new acting judges. Certainly when I was appointed, I was then privileged to have a number of very interesting and somewhat complex civil applications and civil trials. I think on my calculation, during the period in which you appointed me in 2023 and 2024, I did approximately 6 or 7 civil trials. So I was able to do a number of civil trials, which I hadn't done nearly as many in my initial acting stint, so that was a great experience. I had more time in the motion court, more time in the urgent court, criminal appeals, so I feel that it's really broadened the experience which I've had as an acting judge.
So where exactly, what exactly are your strengths in adjudication? Is my understanding correct that it would be commercial law?
Certainly, Acting Judge President, I do believe that I do have strengths in commercial law, both from my MBA and from my experience in civil matters. I certainly have strength in family law matters from my time at the bar. And I have a keen interest in criminal matters, although not wide-ranging experience other than the appeals that I've done and the 2 criminal trials that I've done. But the criminal trials which I did do were both very serious criminal trials resulting in life imprisonment, rape and murder matters. So I feel like I gained a great deal of experience in those matters too.
The workload is quite heavy in the Western Cape High Court. How did you cope with that workload?
I found that, for me, preparation was key, Acting Judge President. So what I would do is, as soon as I received the file, if I wasn't in court that day, is I would go through the papers carefully in the authorities, try and prepare a chronology, so that by the time I was in court, I was often optimistic and thought I could hand down an ex tempore judgment, but I think particularly in your acting days, that takes a fair deal of courage. So even if I didn't end up handing down an ex tempore judgment, also because once you've heard the oral argument, your kind of prima facie view is often disturbed, I then was well prepared to start drafting the judgment when it came time to doing so. So that was how I would handle the pressure. It certainly is a case of just putting in the long hours. I do recall in early times of my acting judge when my youngest daughter was only 4, and she said to somebody, "I used to have a mom and now I only have a judge." And that was what the long hours involved.
How did you find the Western Cape, the environment in the Western Cape High Court as an acting judge and support provided to acting judges by permanent judges?
I've always found it to be a collegial environment. When I first acted, the tea room was still open and judges were sociable, met at tea time. I was always struck by the fact that acting judges were treated entirely as equals by the permanent judges. Once you were an acting judge, you were a judge and you were treated as such. By the time I returned in 2023, it was good to see that the tea room was back. I tried to go as much as possible and socialize with colleagues, many of whom I still knew from 2016. So I found it to be a collegial environment, and I've always enjoyed acting there. I've also found very much that it's an open door policy. If one needs advice or to bounce off a view or a judgment, that colleagues' doors are always open. I've found that always to be the case.
It appears that you are an experienced mediator. Is there a role for mediation in the adjudication of matters in our courts, specifically the high courts?
I think there is, Acting Judge President. The one thing I'm never certain of is how the judge's role fits into this. I think the judge is not there to act as mediator, but I think the judge certainly has an oversight role to ensure that parties and their legal representatives don't merely pay lip service to Rule 41A, and that they comply with the prescripts of that rule and make sure that genuine attempts are taken to resolve matters prior to resorting to litigation, so that litigation is the last resort. And my sense at the moment is that litigants not litigants, but legal representatives aren't taking that rule seriously. They are not doing what they should be doing. And certainly it would be in the interests of the judiciary in terms of workload and in the interests of litigants that matters are properly mediated, or that proper attempts are made to mediate matters before they end up in court.
Is there any specific areas where you feel you did not get sufficient exposure in during your acting stints?
Not so far, Acting Judge President. I've been I was trying to think about which matters I haven't been in. I've been in matters involving competition law, administrative law matters. It's not my specialty at all, but I have been in a number of administrative law matters, criminal appeals. I think the one type of matter I don't recall doing, unless it was very early on, is a bail appeal. But that was really about all I could think of that I haven't done in terms of, and I haven't been involved in a tax or shipping matter. But otherwise, I do feel that I have had broad experience of the various matters that come before the court.
Thank you, Chief Justice.
Thank you, AJP.
Thank you, Acting Judge President.
Commissioner Boshoff.
Thank you, CJ. Good morning.
Good morning, Commissioner.
So given its location in the Western Cape with the seat of Parliament there and obviously provincial government, the metro and the various municipalities, administrative law makes up quite a heavy part of the civil caseload in this division.
Indeed.
So I'm going to ask you two technical questions regarding some common themes that I'm becoming more familiar with just from my own experience in my role. So what we're seeing these days is a growing tendency in these so-called Part A and Part B applications, where Part A contains an application for an interdict or an interim relief pending the hearing of the Part B and final relief, where the Part B deals with a judicial review application. Applicants are increasingly relying on a general right to review or general right to fair administrative action or a fair procurement process in terms of Section 217 as the basis for establishing a prima facie right in terms of interim interdicts. What is your understanding of that reliance, and is it appropriate? And if so, why or when or why not? You just mind engaging on that?
It's a complex one because I think it's touched on in Tasima and Outer, but I think parties believe that if they meet the interim, the ordinary requirements for an interim interdict, the first being a prima facie right, I think there is a perhaps misplaced belief that if they can show that they have a prima facie right to review an administrative action, that is sufficient to establish the requirements for an interim interdict. And my understanding of the case law is that that's not necessarily so.
Sorry, can you just speak to the microphone? We're struggling at this end.
My apologies. My apologies. Thank you, Commissioner. Sorry, my understanding or the complexity in this is that I think parties perhaps in review matters mistakenly believe that in order to satisfy the requirements for an interim interdict, it is sufficient to show, in order to prove the first requirement that they have a prima facie right to the relief they seek, to show that they have a prima facie right to review, and that isn't sufficient. They would need to show that there would be irreparable harm were that interim interdict, so the Part A of the application, were that not to be granted, that the right to review would not suffice, that there would then still be irreparable harm. And my understanding is that that's a separate requirement. It's not sufficient to merely show that they have a right to review. They must also show that that right would be irreparably harmed were the interdict not to be granted, assuming that the other requirements for an interdict are satisfied.
Yes, and I mean, as Outer dealt with the so-called clearest of cases where the infringement is so blatant and gross, or perhaps there was fraud involved, etc. Yes. Okay, thank you. And then the second question is just the concept of so-called reactive or collateral challenges. What is your understanding of them, and can organs of state rely on them, or raise them, rather?
Thank you, Commissioner. Not being an administrative law expert by any means, my understanding of a collateral challenge would be where they raise a challenge to administrative action which is not before the court. And the difficulty with that then is that the court it's not seized as it would in a Rule 53 review matter. It would be seized with a record. It would have the correct parties before it. Now it's required to determine a collateral challenge, for example, in criminal proceedings where an accused is challenging the validity of a statute. They would then be required to determine that almost on a review basis without the review being properly before the court. I understand it to be permissible in very certain circumscribed circumstances, where the court would then have to look at, for example, if it was the organ of state bringing this challenge, that it's a full explanation, and obviously within the peculiar circumstances of that case, but there's a full explanation as to why they did not bring a full or ordinary review application to challenge that impugned decision in the ordinary course, so that the court then was in a position to determine it properly as it would in a review. So, to answer your question in a rather long-winded way, I believe it may be permissible in certain circumstances on the basis of, for example, Tassima, but the court would have to very carefully consider if the circumstances were such that the organ of state were justified in bringing a collateral challenge without the benefit of the necessary documents and review record.
No, thank you very much.
Thank you, Mr. Brasher.
That's all from me. CJ.
Thank you, Mr. Bishop. Commissioner Matolo-Lebu.
Thank you, Chief Justice, and good morning, Advocate Holderness.
Good morning, Commissioner.
From your questionnaire, you seem to have been lucky in doing all the matters, the commercial matters, insolvency matters, that's what you said, property matters. And you indicated that you have been working with highly respected senior counsel, and you named them. But besides you being a small claims commissioner, I don't see any mention of your participation in transformation and skills transfer. Or in all these matters, have you ever roped in black juniors, black female juniors? I don't see that. Can you just advise me of that?
Thank you for the question, Commissioner. Commissioner, the nature of my practice has been such that I haven't brought in juniors, full stop. I've run a practice, so up until the time when I first started focusing on trying to secure acting appointments, I'd only been at the bar in 2015 then for about 11 years. At that stage, I didn't have a practice where I could rope in juniors at all. I didn't work with big firms. I've not yet to have a state attorney brief in the history of my practice, despite having my name on the panel. And the matters that I had were from small to medium firms, often matrimonial law or smaller civil matters, and I didn't bring in juniors. It is not a case that I brought in white male or white female juniors. I simply didn't have juniors at all. I'm aware of this as a shortcoming, and I sought to get involved in training. So I trained pupils for a number of years in the law of evidence. I also was involved as an adjudicator in the UCT moot competitions. And when I realized that I certainly hadn't and was not really in a position to meaningfully assist in the transformation of the bar, other than through mentorship, and I have included in my application, I hope the commissioners have had sight of a number of letters of black female attorneys and advocates and black male attorneys and advocates that I have mentored informally from my very early days of practice. I then, when COVID hit and things slowed down a lot, became involved as a founding director of Flamingo Sanitation. And my thought there was, whilst it has nothing to do with the legal profession, is that transformation in South African society is required at all levels of society. And Flamingo was something where it had the potential to transform the lives of the poorest, specifically women and children in our community, by providing a sanitation solution which would keep them safe, which would provide them with dignity, and which would also improve the environment in which they live. It's an NGO, there is no profit involved at all. I've contributed my own money and hundreds of hours of my time going into the community at Joe Slovo, meeting with people on the ground, learning about what their needs are, and developing a prototype toilet, which we are now seeking to pilot. September last year, I presented at the Africa Climate Summit on Flamingo Sanitation in Kenya. So it's a project that I hold very dear to my heart, and it is the active manner in which I have tried to contribute to transformation, albeit not through the legal profession.
My problem is that from your questionnaire, you seem to be having done good work. And in a South African context, especially from a woman, I would have expected you at least to rope in some black juniors to be part of these matters that you are doing. So I'm actually quite disappointed. Your transformation initiatives don't talk to the transformation of the legal profession. I just wanted to mention that.
Thank you, Commissioner. That's well noted. Thank you.
Follow-up,
Follow-up?
CJ.
Mr. Boshoff?
I thought it was a draw. All right. Sorry, just to clarify and follow up on that question. So I understand what you're saying is that you've never been in a position, you've never led juniors,
No.
full stop. And who would normally make that decision to draw in a junior when you are briefed yourself as a junior advocate?
It would be, because I haven't done it, it's a difficult one to answer. It would often be the decision of the attorney because, of course, they would have to determine if there were sufficient funds to draw in a junior if it were not a pro bono matter. I suppose if a senior junior felt that a junior was necessary, they would try to motivate it to the attorney and say, I do need assistance. But the nature of the matter is the trials I've run, I ran them myself and I didn't require the assistance of a junior.
And if I understood your engagement with, I can't remember if it was the Chief Justice or the AJP, but I mean, I also got the impression that you yourself have very seldomly benefited from being drawn in as a junior by a senior in Silks.
Yes.
All right.
I haven't.
Thank you.
Thank you.
Commissioner Ngweto?
Thank you, Chief Justice. I will ask you about transformation in a moment, but I need to first deal with administrative law. Your outer answer I've got no problem with. I think it's actually correct. But I was very confused with your collateral challenge answer. So maybe let me ask it differently. If an organ of state granted a tender to a company and then it then decided that it doesn't like the way it went about it, it wants to set it aside, what is the legal basis on which it can do? It can do so. There is an administrative challenge under PAJA, which is available. There is a rule of law challenge under legality. How would they go about it, and how would you look at it as a judge?
Commissioner, am I understanding the question correctly that it would be the organ of state which is seeking to set aside its own administrative decision or tender decision?
Yes, it has made an administrative decision to grant a tender. It doesn't like it anymore. It wants to get out of it. What I'm asking for is the pathway.
My understanding is that it would not be entitled to do it under PAJA because of the Constitutional Court's decision in Gajima. It would have to go...
No, you don't need to go further. That's sufficient. Now, the issue of transformation is raised by AFT.
Yes.
They're saying, we must ask you, what have you done for transformation at the bar? There are many ways of doing transformation. One is to bring juniors. You've explained that you didn't have a chance to. That's fine. We're not going to hold that against you. But there are also other ways, participating in committees, promoting the broad interests of the black membership, female members at the bar, etc. So have you been involved in those types of transformation initiatives?
I recall I was involved in subcommittees in my earlier years of the bar. I sat as a member of the Bar Council in, I think it was 2018. So that I have done, and then the training which I've mentioned. I've been passionate, not in a formal capacity, Commissioner, but certainly in promoting black females at the bar, a number of which I know and am friendly with. So an example would be, and perhaps this doesn't raise to the bar which you've set, but whilst I've been acting, and then once I'm off the bench, I will say, so-and-so, a black female junior, appeared before me in this business rescue matter. And I'll approach white male silks who are doing the majority of that type of work. And I will give them a list of the names of these people who appeared before me, or these women, who have been excellent in terms of their written argument, their oral argument. Because a lot of the, sorry.
Now, you see, the reason I'm asking is because when I look at your letters of support, it's actually quite an impressive list. The first one is from Karisha Pillay, who's a senior counsel, black female from Cape Town. Then there is a Mr. Unati Shasha, who works for the government but speaks very highly of you. And then there is, I think, Mbebe, attorneys, Unati Mbebe, also speaks very highly of you. And then there is a fellow from ENS, a black attorney from ENS,
It's a female.
Is it a female?
Mame Moateng, yes.
Amoateng.
That's correct.
Also speaks very highly of you. A black advocate from the Cape Bar, Gugulethu Samkange, who also speaks very highly of you. So it does look like at an individual level, you actually pay attention to individuals and you try to support them and to promote them.
I endeavour
It
to
may
do
be
so.
that at an institutional level you are lacking, but I think individually you pay attention.
Thank you, Commissioner. I endeavour to do so, but I accept that I, at an institutional level, could have done more. I accept. Thank you, Commissioner.
CJ, may I follow up on that transformation question? Good morning, Ms. Ordinance.
Good morning, Commissioner.
Yes. You've had a discussion about your inability to use your position at the bar to support juniors, female, black. Now, the point, at least for me, about inquiring about your transformation background and credentials, if you like, is to try and determine what kind of judge would we be recommending or advising to be appointed? Who are we putting onto the bench? And is there anything in your judgments? You have quite an impressive list of judgments since you acted, about 79, I think you say. Are there any particular judgments which would say that you're happy to discuss with us, that you would say reflect your views about transformation, not so much of the profession, but even the law itself?
Thank you, Commissioner. I've endeavoured in my judgments to, and perhaps it's transformation within society, to be very mindful of the constitutional values which all judges are required to uphold. So from the very start, for example, in the first criminal matter, which I did, I investigated prior to that matter, or it researched to quite a great degree prior to the matter, the principles of restorative justice. And my thinking, and I applied those principles in that criminal trial. And my thinking there was to try and, based on our constitutional values, let there be some peace and closure for the parties, both the accused as well as the victims' families. Similarly, in eviction matters, which I've dealt with, I've tried very hard to craft orders that, where it has been necessary to follow through with an eviction order, the rights of the occupiers subsequent to the eviction are protected as far as possible, and their position improved as far as can be allowed within the prescripts of the law. In matrimonial matters, similarly, I've tried to be as proactive as possible in ensuring that the rights of the children, in terms of Section 25, are adequately protected. So in terms of transformational at a society level, I'm very mindful of that, because I think that it's a sacred position that a judge holds to uphold those values. And it's not a question of activism, it's a question of making sure that you do what is necessary to protect the litigants who appear before you, particularly when it's unrepresented litigants, and to fulfill your mandate of upholding those principles to the best of your ability.
Thank you, Ms. Ordinance. Thank you, CJ.
Thank you, Commissioner.
President Molamero.
Yes, thank you, CJ. Good morning, Ms. Ordinance.
Good morning, Commissioner.
I'm over here.
Oh, there, sorry.
Yes. I see that you attached only one judgment on criminal law, and it's a judgment on sentencing. Is that correct?
That's correct, yes.
I don't see anything on the merits, in other words, relating to the verdict. Was this a plea of guilty?
Sorry, no, I should have, Judge President, I should have annexed it. No, it wasn't. It was there was a very lengthy judgment on conviction. So that was for the first, the one judgment. It was a rape and murder of a 14-year-old boy. It was a full trial, and then there was a conviction, and life imprisonment was imposed. But I wasn't certain how many judgments I could annex, and as I recall, that judgment on conviction was close to 100 pages. So I specifically annexed the judgment on sentencing because of the application of restorative justice principles, but in hindsight, it perhaps would have made sense in that matter specifically to also include the judgment on conviction on the merits.
Yes, you'll accept that not including the judgment pertaining to the verdict deprives us of assessing how you arrived at the decision in terms of the reasoning.
If it would be at all possible, I could certainly place that before the Commission, but I realise just how time restricted the Commission is. I apologise for that oversight, Commissioner. I should have placed it before the Commission.
Yes, I think earlier on you indicated to the Chief Justice, or was it to Judge Goliath, I don't remember, that you did you conducted two criminal trials.
That's correct.
And the judgment in respect of the other matter?
That was also a full judgment on the merits, Judge President. It was also a conviction that was on murder.
Yes. As I understood your responses, it would seem that your practice was mainly civil.
Yes,
in
indeed.
nature.
And I recall, if I may, prior to first acting on the bench, I consulted extensively with colleagues and retired judges to try and get as much information on criminal procedure as possible prior to starting my first trial, because I hadn't done any criminal work at the bar at all.
Yes, okay. So you haven't done any criminal work at the bar, and during your acting stint, you conducted two criminal trials?
That's correct. Sorry, if I could just say, I did briefly do a pro bono matter right at the beginning of my time at the bar, but it didn't actually run. So I became involved in it briefly, and then I didn't continue with it. And after that, I didn't do any criminal matters at all.
All right, thank you. And did you sit alone or with assessors in this matter?
No, we were not appointed assessors at that time, Judge President, so I sat alone.
Okay, thank you very much. Moving on now to the civil aspects, have you had occasion to consider an application in which an anti-pillar order is sought?
Yes, not recently, Judge President. I think that I had one in Chambers in about 2017, so in one of my first acting terms.
Yes, and can you tell us about the requirements that an applicant has to satisfy?
I don't recall them entirely offhand, but as I recall, they would have to, of course, satisfy the requirement of urgency. They're granted invariably in chambers and ex parte, so they would have to satisfy that if essentially the purpose of it is to preserve evidence, and that if the order were not granted ex parte and on an urgent basis, there's a reasonable apprehension or real possibility that the evidence would be destroyed and that the matter could not be decided. And then they would need to also make provision for a supervising attorney or somebody similar to execute the order. So that's as best as I can recall, Judge President.
Is that the kind of order that you granted
Yes,
at the end of it?
Yes, it was. And I can't recall specifically what the evidence was. I think it was all electronic evidence or hard drives. But yes, that was the order that I granted in chambers.
Okay, thank you very much, Ms. Soldenis.
Thank you, Judge President.
Thank you, CJ.
Thank you, Commissioner Moiman.
Thank you, Chief Justice. Good morning.
Good morning,
Yourself and the commissioners. Good morning.
Good morning, Commissioner.
Just one question from my side, because in your questionnaire you raises your areas of interest and a range of matters where you have traversed, which speaks to areas like criminal law, commercial law, public law. It's silent on constitutional law, so I just needed to get comfort that when matters that are constitutional are brought before you, you'll be able to know what are the powers of the courts when it comes to constitutional matters.
Yes. Thank you, Commissioner. Yes, it certainly is a gap in my experience as an advocate, and as I mentioned earlier in the interview, it's a regret that I didn't pursue that field of law because it's a fascinating one. I have done a number of matters. I think one of the judgments I included was Abet versus Petro SA, which was a procurement review. I've recently sat with Justice Saldana in a valuation appeal board matter, which was, we had the top advocates in the country, some of the top advocates in the country before us in very, very complex valuation appeal board review. I suppose in a number of matters, any matter involving a child, evictions, they all have constitutional themes in them. So I certainly feel that where I have shortcomings in experience, that I'm able to do the necessary research to get my head around the facts fairly quickly, and always to seek the advice of those who are more experienced in these matters than I am, where I feel that I'm not quite, or I'm out of my depth. So I'm not scared of doing the hard work that's required to bring myself up to speed with whatever act or statute applies, to read vast volumes of records, and to do what is required. I do believe that I have the ability to do so and to handle matters of that nature.
Thank you, Advocate. Thank you, Chief Justice.
Thank you, Commissioner.
Commissioner Marumokge?
Thank you very much, CJ. Good morning, Advocate.
Good morning, Commissioner.
I think sometimes when one looks at some of the judgments that are coming out in South Africa, especially by some of the acting judges, it appears to me that perhaps maybe the issue of the rules are not taken as seriously as they should. And I'm asking this question on the basis of that, and I'm not accusing you of not having had taken any rules seriously.
Yes.
There are times when somebody applies to appeal or notes an appeal and that they are granted leave to appeal. And on the eve of the appeal being heard, or in preparation of the appeal, evidence that did not serve at the lower court surfaces, and they want to rely on that evidence. Under what circumstances can they be permitted to lead that evidence, if at all?
So I think the paramount consideration would be the interests of justice, and to ensure that there's a full hearing of the matter on appeal. It would only be my understanding is it would only be in exceptional circumstances, and there would have to be a full and adequate explanation as to why that evidence was not placed before the court of quo. And the appeal court determining whether or not the application to admit further evidence should succeed would look at that and the reasons for why that evidence has only come to light just before the hearing of the appeal.
Thank you very much. Thank you very much, CJ.
Thank you, Commissioner.
Thank you, Prof. Commissioner Trollip?
Thank you very much, Chief Justice. Advocate Holderness, Commissioner Ngukai Topi said we won't hold it against you for not introducing juniors into your cases against an explanation of a developing practice that didn't have the scope and capacity to do so. And then he made mention of a list of commendations by black attorneys, which speaks of transformation in action and empowerment in action. But you did say that you accept that you could have done more at an institutional level. What do you plan to do once appointed as a judge at an institutional level regarding transformation?
Thank you, Commissioner. I think that when it comes down to brass tacks, it's all about briefing patterns, Commissioner. And unfortunately, in our division, as I'm sure in many divisions in the country, despite numerous efforts by the bar councils and by associations such as NADEL, BLA, AFT, it seems the briefing patterns are still very much skewed, particularly in bigger matters, towards white silks. I often have matters where the parties before me are represented by a white male senior and a white male junior, and there's not even an attempt at transformation. It's a difficult issue as to how the bench can actively become involved in changing this. There has already been the matter in Johannesburg, the Perry-Ford matter, where there was a degree of judicial activism, and perhaps some form of judicial activism is now required in more matters in order to ensure that there is sometimes an explanation for why parties are briefing the same male white silk advocates and the same white juniors over and over. Because it's certainly, despite all the attempts and by the Bar Council, there doesn't seem to be marked change. It is encouraging, however, to see, particularly in our division in the motion court, there are a number of black females who seem to be getting a lot of the motion court work and the bank work. But that needs to transform beyond the 0 to 5 years so that those black females are retained and can build practices where they will reach silk status and hopefully eventually some of them be elevated to the bench. So I think it's something that the bench needs to be aware of. The bench needs to engage with the various organizations, engage with the attorney's profession, and find out what steps or measures can be taken in place so that there can be real on-the-ground transformation of who receives briefs. And of course, the state attorney is included in that, but there's now the tender process, and that's something quite different. But I think certainly the bench has a role to play. How that role may pan out remains to be seen, but it is something I certainly would be passionate in becoming involved in.
Thank you, Chief Justice.
So, Chief Justice, I do want to follow up this point. You see, the problem, Advocate Holderness, is the question is, what do you plan to do at an institutional level, you yourself, now that you're going to become a judge, and that is a very, very big position? There are many things that judges can do to promote transformation. On the extreme side is Judge Motta, who basically refuses to hear a case until a black person appears. Yes. And then on the other side of the spectrum, something I used to do when I was active, both teams come with all white males, and maybe there is a black female on the margins. But to ask the attorneys and the advocates, why are there no black people in the teams?
Yes.
Often, by asking the question, you bring shame to the team, and when they next appear before you, there is in fact a black person. You can do that without spectacle. You can do it privately. You can do it at a pre-hearing meeting. But I find many judges don't do that. They just accept all white teams. And then they come to the JSC and they protest about a lack of transformation.
Indeed.
And a sense of disempowerment on their side. So maybe if you can just give us 2 or 3 things about what you will do. If you're going to follow Judge Motta, fine. If you have a different strategy, outline it.
Thank you, Commissioner. One of the things we do have available to us is, in our division as in the others, is that prior to hearing a matter, the parties file a practice note which sets out the names of the counsel and the attorneys. So if one of the things I would certainly consider doing then is prior even to the matter presenting in court, one could call a meeting with the practitioners appearing. And if it is in case of an all-white team appearing in a matter with no black juniors, call the counsel in and say, it appears to me that the racial composition of these teams is unacceptable. And this is something that I would seek be addressed prior to the hearing. Because once the hearing has already started, it's very, very difficult, even at least in the early allocation matters. One has some time then, potentially, to bring in a black junior who could then become actively involved in the matter and not just be there for show, but be somebody who is assisting. By then, of course, the heads of argument are filed, but they at least would be gaining the experience of that. And the leader would be then getting to know them and then potentially bringing them in at an early stage in other matters. So I think that potentially could certainly be one of the steps which could be taken. But I think perhaps also is figuring out how engagements, formal engagements, could happen between the bench and the profession, in whatever form that may take. And by the profession, I mean both the bar and the sidebar, to find out what is, in my view, the larger firms in particular. I mean, they hold the vast majority of the commercial work. The junior black females are getting some state advocate work, they're getting some unopposed briefs. They're not getting, as far as I can see, the bigger commercial matters. If they do, they are there as juniors, but they need to get to the point where they will become the silks. They will become the black female silks leading juniors in the bigger matters. And I think that is where I would try to ensure that that sort of engagement takes place at a level where there's then accountability by the profession and measurables. Because as I see it, as far as I'm aware, that's not happening.
Yes, there is another idea, given that you are now where you are and you may be recommended. In England recently, they require the advocates, when they submit a practice note, to set out which part of the argument will be addressed by the junior.
Yes.
Which forces them to allocate, not just to have it for window dressing,
Exactly.
but to allocate a substantive role to the junior.
Thank you, Commissioner. If I may, just on that, and I think that's a very valid point, and I can recall in one of the very few junior matters where I appeared in Kimberley, I was asked to argue, and it wasn't arranged beforehand, but because I think I was jumping up and down during my silks argument so much, she said, would you like to argue the reply? And I said, certainly I would. and I did. And it's exactly that kind of experience which black juniors need, that they argue, that they don't just sit there and take notes and point out things in the record, they actually get on their feet and get to argue matters. That to me sounds like a very sensible initiative. Thank you, Commissioner.
Commissioner McDonald-Lebo?
Just a follow-up, Chief Justice, I'm very passionate about transformation issues. Were you not part of the GCB when they wanted to kick out AFT in your back?
Pardon, Commissioner, I didn't hear the rest of the question. Was I part of the GCB when?
I'm saying that in your meeting with the GCB, you wanted to kick out AFT. Were you part of that?
Did I attend it or did I
Yeah.
vote for it?
Yeah.
I recall attending it. I don't recall I certainly didn't vote for it.
Okay.
Thank you, Commissioner.
But what is your opinion on it?
I did not support it, Commissioner Gutsobi.
All right. We have no more questions for you, Ms. Holdenes.
Thank you, Chief
Unless
Justice.
there's something you want to raise with us, you are free to go.
Chief Justice, there was just one further element which I wish to raise. On my list of reserve judgments, all of my reserve judgments have been delivered, and this is perhaps something which I should have raised with the Acting Judge President, but as you've asked now, it just came to mind. All of my judgments have been delivered within 3 months, save for one that was, I think, a week over, and on average within 2. Shortly before coming for my interview, there was one matter which I record hadn't been finalized. It was a very brief RAF trial. I couldn't find the file at first, and I did find it, and I saw that there were not heads of argument. It hadn't been placed on our reserve judgment list because it hadn't been finalized. I was awaiting the transcript and heads of argument. I didn't have a registrar. I had several registrars over my acting stint, recently I think 5, and I then had to email the parties to find out what the status was, and they informed me that heads had been sent to a prior registrar who had not forwarded them to me. So that matter will now be added to the reserve list, and I will ensure that the judgment is delivered within a week. But I just didn't want it to be that I hadn't disclosed that there was that outstanding judgment. That is the only outstanding judgment, and it will be delivered shortly.
Thanks for that.
Thank you.
It is a good addition.
Thank you very much. Thank you, Commissioner. Thank you.
Thank you.
Thank you, Chief Justice. Thank you, Commissioners. Without.
Good morning, Chief Justice.
How are
Good morning
you?
to the commissioners. I'm fine, Chief Justice.
And how's your aunt?
Oh, she's well, thank you. Thank you for asking.
All right, you've been here before, so
Certainly, Chief Justice.
you have an idea how this goes.
Yes.
And you won't be as nervous as someone who's never undergone this process.
Absolutely, Chief Justice.
Okay, you have 3 law degrees, 2 a BUris and LLB from the University of the Western Cape,
That's correct, Chief
and
Justice.
an LLM in labor law from UNISA.
That's correct, Chief Justice.
You came through the ranks of the NPA,
That's correct, Chief Justice.
started there in 1999,
That's correct, Chief Justice.
and rose to the position of senior state advocate by 2007.
Correct, Chief Justice.
And then what happened? There seems to be a gap according to your questionnaire, because you joined the bar in 2009. What did you do in that intervening 2 years?
2008, I did my pupillage, which I had to do again in 2009.
All right. Then you joined the Cape Bar,
That's correct, Chief Justice.
and you've been with them since.
I've been with them until 2020, you'll note, Chief Justice, 22. Let's see where we are now. Yes. I'm now with Papasa,
Oh, I
practicing
see.
in Cape Town.
And you focus mainly on criminal work, you say?
At the beginning, yes, that's correct, Chief Justice, but
Or have things changed?
well, since working with a state attorney, I've mentioned you get various briefs, at least civil matters from the various departments, mainly your Minister of Police matters, a little bit from the correctional services. Yes, so it hasn't been just criminal matters.
Okay. But still, the only civil work you get is from the state attorney?
That's correct, Chief Justice.
You started acting in 2016,
20,
was it? Yeah, I think it was in 2016, your form says.
yes. Yes, 2016.
2 terms then, another 4 terms in 2017, another 2 terms in 2018, 3 terms in 2020. And then you interviewed for a vacancy in this same division in 2021.
That's correct, Chief Justice. I seem to have, if I may just be given a moment, I want to highlight, I've noted perhaps on paragraph of the Form 9, I'm trying to get it on your bundle of documents, I think it's on page, oh, it's different, the application, okay. But I've missed out 2016 and 2017, the 3 terms and 2 terms. In the application form, I seem to have only stated 15, 16, all right, no, there it is, 17 and 18.
Yeah.
Yeah.
So how many weeks in all has that been?
When I calculated, it comes to 72 weeks,
72 weeks.
standing on being corrected. Maybe
Have you had further acting stints since you interviewed in 2021?
I have not had the opportunity, Chief Justice. I probably will address that, but I have requested, but I will address that perhaps with the acting JP. But I have requested.
All right, and you were not invited?
I was not invited.
Okay. What kind of matters did you adjudicate during these acting stints?
Variety, Chief Justice. Wow, it was such an exciting period of my life because I was at the time exposed to civil. You would do your criminal, which is what I was used to, but you would be thrown at civil, you'd be thrown at motion court. Sometimes I remember in 2020 I had to do 2 weeks of motion court.
How did that go?
It went well. Chief Justice, you you get used to how to run your motion court, you know. I think, and the reviews I would get from the practitioners who appeared before me is, you know, they enjoyed my you know, sitting as a presiding officer in the motion court. You know, they expect that I studied all my files and I'm ready and I'm proceeding with the matters as expeditiously as I can. So I did enjoy, learned a lot, because you have to, it's either you sink or you swim or sink.
Were you able to produce any written judgments?
I have, Chief Justice, when I calculated, I might be wrong again with the numbers. Written judgments since, during the period of my acting since 2015, close to about 200. Some I've noted on my application were taken on appeal. I've had some upheld, partly upheld, and I think one that I could recall, which I've put in my form, was set aside. So I've had that.
You did mention Boanya,
Yes, that's correct, Chief Justice.
but you said it was upheld, which is not entirely correct.
No, Boanya, a unanimous majority decision.
All right.
As far as, if you want me to talk about it now?
No.
You would, sorry, Chief Justice?
I'll go and check and we'll come back to it later.
Yes, Chief Justice. Sorry, I'm looking at the bundle of documents and I have my own file, so I don't want to...
What are you looking for?
I wanted to check about what you said. I've said that Banya was upheld.
That's in page 13.
13?
Okay, I'm looking at
No, my 13 isn't.
Yeah, it's at page 26, but
Okay.
let's put our finger there. We'll come
Yeah,
back to it.
we'll come back to it. Thanks,
Yeah.
Chair.
So how long did it take you on average to produce your judgments?
Average, when I checked, is just 2 months. I've had one or two which went about over a week, another one about a day or so. But the average is just 2 or just over 2 months.
All right. Well, you said you may want to discuss this when you be questioned by the acting judge president. But I just wanted to ask you, you interviewed in 2021 and you did not go through, and I remember vaguely that the feeling would have been that you were not quite ready. And now you say you have not acted since. So I want to tell you to tell us what you have done in the intervening period that would have, patched the gaps we would have been concerned about when you appeared here before.
Thank you, Chief Justice. I wasn't sure exactly. We don't get obviously the privy to the reasons for not being accepted, but I take your point. Chief Justice, since then, I have obviously, when I spoke with the AJP at the time, requesting to be invited again, I have worked as a disciplinary hearing chairperson in the Department of the Premier's Office. I was appointed for a period of a year since 2023. It ended, that contract ended now in 2024 in May. So I've been writing the awards, running the proceedings, and I've had a lot of those. Chief Justice, I've further been in the panel again for disciplinary hearings for the Legal Practice Council. And there I got also to scribe some of the decisions that we took as a panel in review applications or in challenges to any decisions that are made that the legal representatives or any party that is rather making allegations against the legal practitioners. So I've been writing as well from that space. Yes, that is as far as I can take it, Chief Justice.
Okay. The GCP takes issue with your judgment writing.
That's correct, Chief Justice.
What do you have to say for yourself?
As I've said, I think before, Chief Justice, criticism is good, it humbles one, but in my view, I am open to being obviously trained further. We do not come with the expertise when we come, especially in this profession. Some of us have not been exposed or at least been privileged prior to even venturing in coming to this, to the bench to really utilize your drafting skills. So mine is to say, I am ready and open to being trained. I think an ongoing training for any judge is something that should be recommended. The commissioners must look at all the other requirements as far as my suitability for the candidacy. They should not use simply the fact that there is an issue with, they think that my judgment writing is an issue. I think one of the matters that they highlighted, I would like to also answer that those judgments went before senior judges. One of the cases, Boanya, went before the Constitutional Court. Unless I missed anything, I did not hear the judges attacking my judgment style or writing. It went, one of the cases also, if I recall correctly, it's been to the SCA, Chief Justice. So what I'm saying, whilst I'm not, standing on the way of being trained, I do appreciate their criticism, and I would ask the commissioners to also have a look at other requirements that are required for this position, and also the fact that I have a teachable heart. I do state that, yes, I'm a fallible human being. I have my own weaknesses, which I'm open to be, that they be strengthened.
Have you undergone the aspirant women judges training course?
I have prior to my acting stint in 2015, Chief Justice, July, we had Justice Majid at the time who was training us. The opportunity
in 2015?
Yes. Chief Justice, I think it was 2015, not 16.
You have not undergone the advanced one?
The advanced one I have not. I was invited last year, Chief Justice. And Chief Justice would recall when we were called, when we got the invitations, and then we were told somewhere along the way that now we must pay for our expenses.
Or
which
is
I could
that
not
what
afford.
discouraged you?
Yes, I could not afford at the time, yes.
Yeah, that's something we are working on and hope to fix. Otherwise, the whole program is sunk.
Yes, I'm afraid so, Chief Justice. It's good to hear that is being considered.
Yeah. Okay. I'm going to hand over to AJP Goliath, if she has any questions for you.
Thank you, Chief Justice. Advocate Magona, I have observed your whole profile and your growth as an advocate.
Thank you.
And I can commend you because I can see the growth.
Thank you.
How you have grown, I can see that. So whatever I'm going to say to you or ask you, please don't take it in a negative light, because I am alive to the fact that you have grown and you have moved on.
Thank you.
And that you are a person with potential. Now, when you acted in the division 2016, 2017, and 2018, the Judge President and I, as well as some colleagues, were of the view that you did not do well in terms of the quality of your judgments and even your reserve judgments. Do you have any comment on that? That this is old news. That's why I say don't look at it in a negative way. But 2016, 2017, 2018 did not go well for you. Any comment on that?
Thank you, Chief, Acting JP. It's my first time I'm hearing of this, Acting JP. Mm-hmm. I do wish that you had informed me perhaps prior. And I would have expected then that maybe you as well as the JP then would
That's
have
correct.
assisted
Both of
me.
us.
Yeah, would have
Yes.
assisted me where I was weak on. So, just caught off guard. I've written a lot of judgments at the time. I would have prepared for this question also on time. I've written a lot of judgments at the time. I really never had any negative comments from your side. I do think, sorry,
No
HAB.
problem.
I do think that obviously my writing style got better, and I'm sure, well, I have not heard if there was any written complaints to your side about that. Again, I'm open, HAB, to fall under the training. I understand the systems are there currently that are being taken care of
Yes.
by the division for the acting judges, as it should be. I am certainly open to that. Yes, that's what I would say to that.
Well, during that period, I was appointed the DJP in 2016, so I can assure you that the Judge President and I had discussions regarding the competencies of the AJs, but that is in the past, because I have indicated that I can see that you have made efforts to grow.
Thank you, HAB.
Now, you indicated that you've written quite a number of judgments, even though none of them are reported. You've written a number of judgments, right?
Yes, HAB 1 is reported that I could pick
Oh.
up. Buanya is reported.
I see.
Buanya is reported. Well, the others, you know, your SCA ones, which obviously are not mine, but are
Yes.
reported by the SCA. Yes.
So you have a next 3 cases. The first one I see it's a summary judgment application. The second one is a stay of proceedings, and then it's Buanya's case. But leave Buanya for a moment, because it appears as if that was quite an important judgment that you wrote, and the Constitutional Court ventilated the issue. So I'm not talking about that case. I'm talking about the 2 cases, the summary judgment and the stay of proceedings. I would have expected you to impress the Commission with more complex judgments as a summary judgment and a stay of proceedings now that you have the opportunity to do so. Was this the best that you could present?
You know, Chief Justice, when I made the decision to apply again this year, it was very late. And obviously, you know, colleagues were encouraging me, and I thought, no, maybe next time. So when I collected my judgments, I discovered I do not have the copies of the signed judgments. I have my drafts, which would not be suitable to present before the commissioners. And I also discovered that most of the time between 2015 to the 2018 period, we were delivering judgments. You would recall in person, we would go in court and have them delivered. Parties will be, you know, copies of judgment will be disseminated to the parties. So I couldn't. Now I could recall, after I've submitted my application form, I'm preparing, then I looked, my goodness, you have complex matters that you dealt with. I had a matter that had fishing rights that I had to deal with, constitutional issue. I had a matter, Buanya, I've submitted. I had other matters I should have, handed in. And I still didn't have the original judgments, and I was trying to trace them. Lastly, just last week, I was speaking with one of the senior judges, because I said, I don't know if they will accept, but is there any way that you have this copy? This is one of them, but I couldn't hand it up before the commissioners. It was too late. I didn't want a burden. I didn't want any special treatment. I could only get, and I'm grateful to, it was Judge Ndita. I was with her on the Viking matter, one of the full bench judges with Judge Klute. So she said she will see what she can do. That was last week, and she could only assist me yesterday in the afternoon. I thought there's no way that I can. Now I had that written judgment. That's the one that deals with the little bit about the fishing rights and what was happening at the time. The Marine Living Resources Act was being challenged, the policy. So that I would have handed in. I did look at what oh my gosh, I should have done better. But I didn't have the copies of the original documents or the judgments, AJP.
So you returned in 2020?
That's correct.
Was there any difference between the type of cases you did 2016, 2017 and 2018 and when you came back in 2020?
No,
in terms of the complexity of the matters, etc.?
Absolutely. I think there was. I grew a lot. If I may just... I did a lot of motion court, urgent applications of various matters. Some I had to write judgments on. The complex matters which I dealt with, I recall a lot of matters involving interdicts, but the issues themselves, some involved PRASA and the complexity of the issues, the termination of contracts, etc., etc. Some involved building and construction work that was not done. I think your top stores case, which is there, that I got during that period. Some involved, yes, contracts which were held to be contra bonus mores. I think there's a coup to cap matter. I gave just a list. I really couldn't submit the judgment. I think you might have gotten that list on Friday. Listed it there. Coup to cap matter involved some termination of contracts which were found to be against public policy, etc. So yes, to your answer, AJP, I think I was quite challenged, which I enjoyed, and it exposed me to more complex matters.
Your judgment in Banya, I've read the judgment, and what struck me was that in terms of the structure of the judgment, you elected to deal with preliminary issues, the issue of condemnation and mootness, very far down in paragraph 80, paragraph 111 and 116, you dealt with the issue of condemnation. And then further down in paragraph 125, you dealt with the issue of mootness, whereas those issues should actually, it's considered as points in limine, and you identified it as such. Is there any reason why you decided to deal with it so late in the judgment and not as a point in limine and then move on from there? Because ultimately, if a matter is moot, you must say so early and crystallize the issues.
I think mine was to summarize the facts first, to put everything into context as far as where I would be going with regards to those 2 points. Yes, I agree with you, the AJP, it makes sense. Deal with them right at the beginning so that those 2 points are out of the way and then you get to the crux of the issues. But I think it's one of those, again, matters that one needs to look at when you look at the judgment as a structure to make sure that you get those preliminary issues out of the way.
I'm pleased to hear that you indicated to the Commission that you are trainable. So during my stint as AJP, there were 8 African women who acted in the division, and all of them were sent for judicial training. And I did, in fact, personally recommend you for judicial training, the Sajay training, because I was of the view that you needed further training, more particularly with regard to your writing skills. But you didn't attend that training, and that's why you were left behind.
That's last year's one?
Yes.
Yes, as I've explained to the AJP, sadly, it was the cost effectiveness for me at the time. Because usually those trainings, the department would pay for us. But we were informed, I think, weeks before the time that actually we need, all of us now must, So I compared at the time, could I afford it? I couldn't. And I think I actually waited until very late, being a victim of having to wait for 30 days for payment of your invoices at the time. I waited until I think the very last, if I look at my emails, I'm sure the secretaries can check, that last week before Monday. And I'd even started drafting, if you could find on the archives, because I know we had a password as well as access to submit our judgment. I submitted the assignments, the first one, because I was so hoping that, my invoice would be paid, but obviously state attorney was late. I couldn't afford, but I submitted still my assignment if that was picked up, because I really genuinely wanted to be there. I know this is exactly what I would be asked one day if I were to appear before this commission.
Yeah, that is unfortunate, because had you attended that training, you would have been invited to act in the division just like all the other, particularly women who attended that training.
Yes. HAP, well, I didn't know it would be obviously a requirement. I understand that. But as I've said, I had attended the training prior, not the advanced one. And yes, it would make sense that I would have been invited because it was the advanced one. But HAP, when I spoke with you telephonically to congratulate you with regards to your appointment as a HAP, I spoke to you and showed my interest to you. I advised you that, look, this is where I am. I've left the bar, but I'm with Pabas. I recall that conversation.
I recall that
Yes.
conversation.
And I
yes.
requested you to invite me. I'm still available, HAP. And I had expected that, you would, because I know your heart, and I at least would have expected that you would then invite me. Because I think there was a, let me stop there.
But you do, sorry.
You didn't finish your sentence.
I wanted to obviously, I had expected, being a female judge, HAP would expect that, and for her wanting to empower, as you're saying, African women and wanting more African women on the bench, and having acted before, she knows me, because I've been there for a number of times with my acting stints before her. So I had expected that she would then still invite me without having to go to the advanced training. The advanced training would have been a cherry on top, but it would have given me more opportunities to still utilize and harness my writing skill by acting, but that never happened.
Why would the HAP have been obliged to invite you?
Not obliged, there's no obligation. I think just to raise
you had an expectation.
No, yes, perhaps in a way that I should put it this way, Chief Justice, you raise your hand and you are, maybe hopeful that you would be invited. And that never happened. So, not an expectation. Perhaps that's a wrong choice of word. I was hopeful that I would be invited because I knew I needed, obviously, more time to do a little bit of acting.
Yes, more time would definitely benefit you, but you do understand that I did identify you. I personally recommended you. I was of the view that you could benefit from it, and it appears as if that was then the problem, the fact that you did not present yourself for the advanced training to assist you to strengthen your skills, more specifically in judgment writing. You understand that that became a barrier for you?
No, I don't understand, Acting Judge President. I could not that I did not, I could not present myself. I was so honored to be invited. In fact, I so much wanted to be there. That's why I said I prepared my assignment and submitted it, even though I knew I'm not going to make it. I'd already informed them. Mine would be, perhaps I would answer it this way, HAP. There would still be time to take me on that training, even when I'm a judge. You can, these are ongoing, the training for the judges are ongoing. I'm available to do that. I would ask the HAP to look at all my other requirements to say, if I do qualify, but then let us take you and work with you on this. So that you are not discouraged, demoralized. You are here. You are the kind of person that we do need in the bench. Then internally, you can then take me through the processes of the advanced training courses.
You did not advise my office of the reason why you didn't attend. I'm not aware of those reasons.
AJP, I was only contacted by the Office of the Chief Justice about the training. I was never advised by, your office that I was recommended by you. I'm sure I would have advised you. So I've been communicating with the Chief Justice Secretariat side. They advised me. They invited me. They're the ones who have been updating me of what was happening. So I thought it would be prudent that I only then communicate with them. Because that was the reason. Otherwise, I would have had no problem contacting you.
Yeah, it appears that it's a sequence of unfortunate events. My office did communicate with all those whom I have recommended, and according to my memory, you were included, but I hear what you are saying. You were under the impression that my office was not involved in recommending you, and hence you thought it would not be necessary to convey to me why you didn't attend. I understand what you're saying. That is unfortunate.
IJP, I'm sorry to cut you there. I'm trying to recall if your office ever communicated with me. I really don't have any recollection. I'm not denying it happened, but I really do not have. And I would have had no issues to advise you. I think it's the right thing to do. It's protocol. Deal with the division. If you're AJP, you are the one who advised me in writing that you are on the list, etc. That I would have done without any hassles.
Actually, the procedure is to inform all the candidates when we communicate directly with Sajay. We include the information as well. But look, I don't want to harp on that point. It's just that I need you to understand that I have, in my capacity as AGP, identified you as a candidate. I've put your name forward for advanced training. You didn't attend it, and it appears that there was a lack of communication in terms of the reasons why you didn't attend. I will leave it at that, and I'm not judging you because you are a person with potential. And I did identify you as someone that should be given an opportunity to come back. Now, you say that you are trainable. You are trainable, and you're willing to submit yourself to training.
Yes, AJP.
Now, what can we do better? Because with the Sajay training, I have observed, and based on your explanation, I have observed that the funding is only available to magistrates to attend this training. And it appears as if that was the problem that you had, of which I was obviously not aware. Yes. I thought you didn't attend. I recommended you didn't attend, and you weren't interested, and you've clarified that. But what can we do better to assist people like you who do not benefit from the fact that Sajay only pays for the magistrates to attend that training?
Thank you, AJP. The set period of me having to not attend really affected me. And I was of the view that the Office of the Chief Justice should continue as they were doing before. AJP, you must recall, most of us are, acting and private, independent advocates. And obviously, we depend on our private work as well as the payment system that is flawed. I mean, we can talk the whole day about that and the consequences of it. What can be done? I think, AJP, the times before, I know the austerity measures, the funding here, funding that, each department wants to keep some funds, but it must be thought of us. What about us who don't have these funds? We are going to miss opportunities when they come to us. I think the office should consider that there be a budget that is set aside for this training. When the training is coming, I know already, I'm sure there's an advanced schedule of what will happen in the next 2 years, and they know how much it will be needed and how many candidates will be invited. I would propose that there be budget that is set for it, which includes assisting the candidates who so much want to be in these trainings, that they can access it, because the issue of funds, especially for us as black advocates, is a difficulty, and it can be a career and destiny a stopper. So I do think that there should be, intentionally, there should be funding. I have nothing against the magistrate, but they are employed, they get their salaries on time, 15th or the 30th, they can afford it, but they are being paid for. It just doesn't make that much sense. But
luckily, the minister of Justice is here.
Minister,
You were a
please.
victim of the austerity measures, Ms. Magona. Sajay had every intention of paying the candidates of that program a stipend. And as I understand it, there just wasn't enough money. And it's not just you who fell through the cracks. A number of other legal practitioners who could not afford to leave their practices for an extended period without being, on an income, suffered a similar fate.
Yes.
So these are the things we keep talking about, and unfortunately, we depend on treasury and all these executive structures for money.
I understand, Chief Justice. And these are the consequences. I think the Honourable Minister, now I can understand as I'm speaking it. I missed out the big opportunity, which, and so many others that are here now, that would have benefited me in my professional life. And hopefully in the future, this can be prevented. There's so many young professionals who want to grow in the profession, and they can't afford it. Yeah.
And in this case, we're talking about a division which could do with African females.
Absolutely.
And they are the ones who are worst affected
Absolutely,
by this
Chief
situation.
Justice.
So,
Absolutely.
yeah. I'm glad to have a live example.
Absolutely. I'm here. I am the one.
I'm sorry I interrupted you.
No
AJP.
problem, Chief Justice. I just want to reassure Advocate Magona that the women who attended the course were invited, and it is unfortunate that you were excluded. And I indeed sympathize with you because of that, and the Chief Justice made comments regarding those protocols and policies. Thank you very much, Chief Justice.
Thank you, AJP.
Thank you, AJP. Mr. Boshoff.
Thank you, CJ. Morning.
Good morning, Mr. Boshoff.
Are you well?
Commissioner Boshoff. I'm well, thank you.
Yeah, good. So the Western Cape Division, given its proximity or its location, with the seat of Parliament being in the province, Western Cape government, metros, various municipalities, quite a administrative law is quite a significant, potentially forms the majority of civil work, opposed civil work in the division. So I'm just going to ask you two technical questions on administrative law. The first one relates to interim interdicts, the so-called Part A and Part B applications, where Part B deals with the judicial review application to set aside let's say, for example, a tender, an administrative decision.
Okay.
And then the tendency now is to bring in a Part A to try and stop the implementation of that tender, for example. Now, you'll be familiar with the requirements for interim interdicts, and the first being the establishment of a prima facie right.
Yes.
Is it sufficient to rely on the right to review, or the right to fair administrative action, or the right to a fair supply chain process as per Section 217 of the Constitution, in order to establish and satisfy that first requirement?
If I understand the question correctly, so we would be looking at your Part A now.
Yes.
And you've correctly stated your setlugelo requirements would have to be there. But now, I think as a court, you must be careful not to stifle the exercise of the Part B power from the executive. You must look at what is that tender about. Whereas there are interim interdict requirements that are there, it must be, I think, in the interest of justice that you can stifle that power, because at the end of the day, if I understand your question correctly, there is public that stands to suffer, or the executive powers that stand not to be exercised or executed that ought to be executed. So it would have to be, you must prove more and rigid facts or evidence to show and convince the court that actually, whilst you're granting me Part A, grant me rather Part A, the interim interdict, whilst we are going to take maybe years to finalize Part B, which is usually the case. So the court must balance that, because sometimes your Part A is not as simple as granting it, and then things are going to happen immediately with Part B. What does happen in some of these cases, and I think one of the cases, I can't recall now, the Constitutional Court, said you must look at all of these things, that your Part A, if I grant you, sometimes really deterring that power to be exercised in the interim might stifle, obviously, the maybe service provision, in that tender, or anything further that maybe the community needs, in dire need, is maybe water, maybe electricity, etc. So, to your answer, you don't just look at the settlement requirements, but go a little bit further and see if there is any other heavy requirements or reasonable requirements that should be considered.
But are you not now analyzing the balance of convenience in your assessment there? Whereas I'm specifically concerned about the question of establishing the very first requirement, or satisfying that requirement, being what is the prima facie right that you are asking the court to protect here? To protect by way of an interdict. What right, or is it sufficient to say, I am taking this matter on judicial review and therefore I'm entitled to my interdict because Section 33 ensures my right to fair administrative action, or Section 217 guarantees me a right to transparent and competitive and cost-efficient supply chain processes or procurement processes. Is that enough to tell the court, well, we need to look further?
Well, your prima facie right will be a right that you are claiming that you as an applicant is being breached by the administrative action that is being taken or decision that is made. So it can be a right that is, can be easily determined from the facts. At times, as I've said, maybe your access to water, access to your rights from the Constitution, constitutional rights. Sorry, I'm trying to gather my thoughts nicely.
You're on the right path because, in the outside judgment, the court did go about, these so-called clearest of cases where, for example, a community's rights, if the tender is so critical, that it needs to, because there's no follow-up service provider, for example, is in your example, to provide clean water, etc. The court would be willing to then say, look, I'm not going to, I need to ensure that those, things are taken in. So I think let's not take that any further.
All right.
I want to move on to the next question. So-called reactive or collateral challenges. Are you familiar with them? What do you understand in respect of that? And can organs of state raise them in a matter?
No fundi of administrative law, but collateral challenges, I think they have to do with, indirect attack on something that is not about the main issue that is before the court. So you can bring about such an issue before the court because it's collateral. It is not the material issue that is before the court, but the court can, if it's in the interest of justice to do so, can deal with it. Your second one was, can the court,
Can organs of state raise them?
Can organs of state raise collateral challenges? Let us see. If it's something that has to do, let's say, in your first example, a review of an administrative action, only on the principle of legality. Are you with me?
Yeah.
But if it is, they cannot obviously use they can use just administrative action, which is in terms of the Constitution, and only raise it only on the principle of legality.
Sorry, are you saying the organ of state can rely on Section 33 and legality? Because the constitutional right to just administrative action is Section 33 and PAJA, etc.
No, that has to do with PAJA, which they can't use, because
Okay,
the very
right.
decision that will be
Yes.
attacked on PAJA is the same. They
Yes.
would be the decision makers, so they can't use PAJA.
Okay,
So it will just be on the principle of legality
okay.
that the state can use.
All right, I think
Yeah.
let's leave it there. Thank you.
Yeah,
Thank
thank
you very
you.
much.
Sorry.
No, not at all.
All
Thank
over,
you.
my head is all over.
No, thank you. Thank you, Chief Justice.
Commissioner Bello?
Thank you, Chief Justice. Good morning, Ms. Magano.
Good morning, Commissioner.
Yes. You've given us 3 judgments, and it's a pity because they don't do you justice. I know you default to the one went to the SCA and it was upheld. That's the Top Street one.
Yes,
And
Top
then
Stars.
Bwanya went to the Constitutional Court, it was upheld. But still,
But
one has to evaluate you on the basis of the judgments that you've written
Yes, ma'am.
to see your readiness. Now, the self-evident truth is that judges speak through their judgments. And in your case, as an applicant, your judgments are, I have never appeared before you, so I have only this interview and more importantly, your judgments to evaluate you on. Now, both judgments are in 2020.
That's correct.
The Top Street one. And it is it's a hard and painful judgment to read. I don't think it's unfair to say it's not a properly written judgment. I'm hoping that, when you say you're trainable, you have gone back and when you submitted it to us at least, you looked at the judgments and you identified that in 2024 maybe you're better than you were in 2020. And I wish you had given us the 2024 judgment. Now, on the 2020 judgments, and maybe here's where I ask for your comment. Is it not fair, would it not be fair to be concerned that if we were to recommend you on the basis of these or taking these judgments into account, we possibly are sending out a candidate who does require serious training, if we work off just these judgments? Do you want to comment on that? And maybe let me put it more positively this way, that they are a matter of concern for me, these judgments. And I'm, they don't convey clearly your reasoning, your thought process. You come to a decision, it may be the order is correct, but how you get there, how the reader of the judgment need to understand, especially the loser, need to understand why they lost. And it doesn't seem that your judgments, at least the Top Street one, doesn't seem to achieve that. Do you want to comment to that?
Thank you, Commissioner. Commissioner, the issue of the writing skill, as I don't want to repeat myself, it's something that I have tried to work on even outside of my acting stints, as I've indicated before to the Chief Justice. And it said it's really, I would have had, or at least given more of these judgments that I have written before. Perhaps I've chosen not the best. I do understand your concern However, I would ask that you consider that my acting stints have run intermittently over a period of years. And I am confident that with the extra writing skill that I've attained in being a chairperson of the two institutions that I've mentioned since 2020, I've had the opportunity to, which I could not obviously attach my awards because it relates to personal issues, employer-employee relations. I have done much better. Unfortunately, in this career, as a private counsel, you are not having the benefit of perhaps work with someone or someone work with you in upskilling or assisting you in empowering you more. But I have worked on it because I've identified that this is something that needs to be done. And I agree with you, Commissioner. One's obviously thought about a case as well as before reaching a decision must be understood by the recipients, especially those who are affected. So it is something that, as I've said, I'm so open that it be worked on with me, and I think with having the HAPU has recognized that I have the potential. Going back to practice, still standing in the same position would perhaps be a discouragement, and no one is obliged, obviously, the Commission is not obliged to appoint, to recommend me, but I would ask that the Commission would give me that opportunity to be upskilled within, that is inside the Chief Justice Office as a candidate that is appointed or recommended.
Thank you. Thank you, Chief Justice.
Commissioner Mdntv.
Thank you, Chief Justice. Advocate Magona, I just want to, because you see, when you gave answers to Commissioner Boshoff, I understand the second answer. It took a while, but you finally got the gist of it. So no problem there. But I couldn't understand your response to the first question in relation to whether a litigant who comes to court on an application for interim relief is entitled to rely only on the fact of the existence of a right to review that is codified in Section 33, or they have to show more under the outer principle. Could you just articulate a clear answer there?
Thank you, Commissioner. My answer is that they have to show for an interim interdict, the prima facie right, the irreparable harm, the balance of convenience, as well as no alternative remedy. Excuse me. No alternative remedy.
And I understand. I mean,
and when it comes to
yes,
the outer principles would be to to look if there's maybe issues of malafides or whatever, but there must be other further grounds that the court must look at.
no, I think the question is what type of a prima facie right they have to establish to satisfy the outer standard.
Let me just think clearly now.
Well, I mean, we can make an example. I made an example with the previous candidate. The JSC is conducting interview for your appointment. It is exercising a power directly derived from the Constitution.
Yes.
The political party wants to stop these processes because they believe that one commissioner should have been here but is not here. But they want interim relief. And you are now sitting as a judge, and you have to answer that question, and you have to apply the outer standard. What would the requirements be?
That there is an administrative action that is contravening your rights.
No, I understand.
I'm
that,
sorry, Commissioner. Can you repeat that?
I'm saying, well, I just made an example.
Yes.
But it's still the same question of how you apply outer in practice. So the example I make is the JSC is conducting your interview to be appointed as a judge. A political party wants to bring an interim interdict against the JSC proceeding. The JSC is exercising a direct constitutional power. Outer deals with what a court must do when an organ of state is sought to be restrained from exercising power that is conferred on it by the Constitution. And it sets out the requirements for the interim relief. The question of Commissioner Boshoff is limited to the type of a prima facie right that they must demonstrate in order to succeed. So, because he says often people think the mere fact that you have a right in the Constitution is enough, but the law says that's not enough. So what is enough to satisfy the standard? So you are now an acting judge and is coming before you, and you have to ask counsel for the applicant, address me on the outer requirements. What goes through your mind?
What prima facie right is being infringed here? I would ask the party. Why is it that you won't allow the interviews to take place whilst you are pursuing your interim, or rather, what right is being infringed that cannot be remedied at a later stage?
All right. Okay, let's move on from that. Maybe let me just ask a totally different question then on something you've dealt with. You spoke earlier about a judgment you gave which included mootness as a topic.
Yes.
Now, when you are sitting as a High Court judge and you find that a particular dispute is moot, do you have a discretion to deal with the merits in the interest of justice or not?
If you found that
Yes, you decide it's moot, it will have no practical effect. And then the applicant says, yes, my lady, even though it is moot, I would like you to deal with it in the interest of justice. And you're sitting as a High Court judge. Do you have that discretion to deal with the substance in the interest of justice?
I think you would, in the interest of justice.
You would?
I think you would, yes. If it is moot, it does not have an impact on the parties, but it might have an impact on the greater public, on the point itself might still have an impact to the public at large.
But isn't there an SCA judgment that specifically says the High Court does not have the discretion? It's only courts of appeal that have a discretion to decide moot cases. Now, let's move on from that. Just on the issues that, my difficulty is I'm trying to find a way in which I will assess your candidature and trying to ask a few legal questions so that I can be confident that you are ready to become a judge tomorrow.
Yes, thank you.
And that's what I'm struggling with at the moment. The Buanya judgment, I sort of read it. It's sort of all over the place. But ultimately, it made its way to the South African law reports. So I wonder if you compared the judgment that you wrote and the judgment that was published, and so the corrections that were made by the editors.
I have compared a while back, and recently, that was when it was, recently when it was reported in 2021, I think.
Yes, but I'm saying if you sat with your own and just do a mark-up and see that I committed 20 errors, they've been corrected by the editors. Did you do that exercise?
I did, Commissioner,
and then, what was the outcome?
And mine is to proceed in correcting that judgment.
I understand, but I'm saying what was the outcome of that comparison between yours and what the editors published?
Well, the outcome is yes, there were errors. I admitted to that. And I could see, even now, what I didn't want to do is to obviously now amend something that I've signed on. But I think the outcome to your question is that I saw that there were errors, there were typos, should have been diligent in checking if I'm extracting something from another source to make sure that it's clean. So I noticed that. And I appreciate, obviously, the issue of the structure. I did pick up as well. And when I compared to my notes that I had then when I was being trained by Sajay, especially in terms of structure. And that exercise sort of enlightened me that I should have done better, Commissioner. And hence, I thought I need to be writing a lot. Hence, I thought requesting and perhaps hoping to be invited at the time, but, doing the extra work that I've done when I was not invited as yet. So,
yes. When we deliberate, you see, because so far it's only negative things that are emerging from, your CV, and so it's things that say do not recommend this candidate. But I'm looking for the positive things. I mean, what is the thing that you can leave us with that we should recommend you? Because so far the picture is not looking great from where I'm sitting.
Commissioner, I would highlight the rest of the criteria that is needed for a candidature of my nature in these kind of appointments. Commissioner, I would ask the commissioners to consider the fact that one is open to being trained. Commissioner, I would recommend the commissioners to consider the fact that my appointment would obviously perhaps encourage other Black African females to consider approaching the AJP or to consider acting, maybe whilst they are very young. Commissioner, I would recommend that the commissioners, when they look at me, to consider all my other attributes that I've achieved according to my application form. You must excuse me, Commissioner, for not completely recalling your substantive answers, because, as you know, sometimes as judges, we really just go through the rules as we go along drafting these judgments. You refresh yourself. What are the parties have said? What did the parties say to me? What are the heads of argument? What is the law on issues? But that is always, so dealing now with the questions here, and I appreciate that you made examples which were good, but I think the interview sometimes just gets to one that you're not thinking clearly. But certainly, I'm one who's willing to learn and to be upskilled and to subject myself to that.
Chief Justice, may I ask for a follow-up quickly? I mean, it's not a one.
May I just point out that we are running an hour behind schedule now, so commissioners, before you raise your hand to put whatever follow-up or substantive question, just keep that in mind.
Yes. Thank you, Chief Justice. That's a follow-up. Look, Advocate, understanding you and the confidence you have, don't you think that at this stage you can just hold back, just take time to act so that you come forward? Because clearly you would like to be judged, and I can see from those structures, but you just need to polish yourself up. Don't you think that would be the best thing to do in view of all what has been said?
Commissioner, whenever that question comes, I think also from other candidates, it's always, or rather it leaves someone already feeling that, all right, the decision is made already. I would answer you this way, Commissioner.
The decision is not made already, Ms. Mr. Nokesi speaks only for himself.
Thank you.
There are 22 other people here.
Thank you, Chief Justice. I would think Mr. Nokesi and the HAP is here, that sometimes, as you can see, since 2020, I couldn't get the opportunity. I did hear what the HAP is saying. Consider, Mr. Nujesi, that sometimes as a black counsel in this profession, number one, you go back to, yes, maybe acting, there's no guarantee, number one, that you're going to get it, or how the duration of it. Number two, you'll be running the risk, obviously, which has costed me in the past, of that it will cost your practice at the same time. So I would rather that this commission rather consider that this is someone who has the potential. From what I see, I hear from even from the HAP, if we do have someone who has that potential, rather than have them go back to something that we don't know, what might or might not happen, what is going to happen to her when she goes back? What are the potential of ever seeing this candidate again here? Maybe we'll lose them, be in between the cracks. I would rather request you consider that I be trained internally. This is just the element that needs to be corrected, or at least empowered in me, be upskilled internally, which HAP has said is something that is being done.
Commissioner Matolo Dlepu.
A follow-up?
Commissioner Matolo Dlepu.
Thank you, Chief Justice. Advocate Mahan, you know, I'm listening to you, and for me, it's the story for any black legal practitioner. And I'm wondering that if you are going to live here, firstly, where do you get your work? Does the state attorney or Mr. Boshoff give you work or whatever?
Certainly not Mr. Boshoff, to your example. State attorney only, Commissioner, and as I think I've said before, it comes maybe once in a quarter. You get paid in 30-something days, sometimes even later. So you have your 3 or 4 briefs only per year, and you suffer. You think, maybe I should leave, I shouldn't. Okay, let me try and do a little bit of another business or what. It's frustrating, and the work is only from the state attorney, to your question, Commissioner, which also is coming in pieces with all other challenges that come with it when it comes to payment.
Okay, thank you. I think Commissioner Boshoff is listening. So that at least from here.
Can I just clarify for the record? I'm in-house counsel. It's been made very clear to us that we have no line to the bar without the state attorney's intervention. So just to clarify that.
Well, I don't know what that's about, but thanks anyway. Commissioner Mangen.
Good afternoon, Advocate.
Good afternoon, sir. Good afternoon, Commissioner.
You and I know each other.
I'm trying to recall.
Yes. Oh, if you don't know me, it's fine.
The face is familiar, but I can't
Yes.
place.
Yes.
Parliament, perhaps?
Yes.
Please, you said
No.
you had a follow-up question, Commissioner Mangena. May we have that follow-up question?
Yes. There is something that is worrying me regarding the statement that you said. You said you were not willing to apply for this post, and people came to you and encouraged you to apply, and that is why your application is not well prepared, and some of the judgments are not even attached here.
Not willing to apply is perhaps would have been a strong use of words. I was considering and put my decision here and there, tomorrow yes, the next day I no. And when I heard colleagues were saying, you should do it, it's now. And then I thought maybe it is time.
Yeah.
Not being willing, no. There is a pool, once you start acting, Commissioner, your life is never the same. There is always a pull. The bench is like a magnet. You are practicing here, but whenever you go and appear in that court, you have something that is drawing you in. So the dream and the vision in you is never dead. Whether I did it in last minutely or what, it's what I want to do.
And that's the thing. Following up from the questions posed by Advocate Baloyi there, regarding how we should assess your suitability based on the judgments that you have written, would you accept that this application was prepared haphazardly?
Haphazardly in what way?
In the sense that you did not have enough time to prepare for it, including finding judgments that you have written in the past.
I could not find them. I could not find them. I had no access to them. But time to write down and prepare, as you can see, typing the form, attaching the judgments. Yes, you can. I understand the challenges to the quality of the judgments, but there I had time, attaching the necessary forms. But what I couldn't find, Commissioner, if I was not understood, is my original signed judgment, because I only had drafts with me for various reasons. I, changed computers. I recall when I was typing then in 2015 to 2018, we were using Chief Justice laptops, which I had no access whenever I return. And yeah, so for various reasons, I couldn't find the judgments. And obviously, yes, the time was already there for me to having to submit something.
And you'd agree that if you are to step back, you would be afforded enough time to find those judgments, make them available to the Commission, so that your suitability can also be assessed based on your judgment writing skill?
I think, Commissioner, the judgment writing skill question I have answered. I think my suitability also must be considered on all the other requirements. I've answered the issue about my judgment writing skill. I would ask the Commissioner to consider, as I've stated, my, obviously, willingness to be upskilled internally, my willingness to opening myself up, basically, for training. I cannot give assurance that I will find the judgments. I'm sure some, I think after 5 years, I don't know, AJP can correct me, the files are destroyed. I might be wrong. All right, they're available. But I don't know if they will be. I can access them and find them. But yeah, to the upskilling and training, I would still go back to my answer that it would be done internally, please.
Thank you, Chief Justice.
Thank you.
Commissioner Malem? Commissioner Moiman?
I'm fine, CJ.
Commissioner Marumachai?
No, CJ, I will leave my questions. I'm fine.
You still want to have a go, Commissioner Luches?
Fine, thank you, Chief Justice.
Okay. All right. Thank you, Commissioners. Thank you. Ms. Makona?
Yes.
We've reached the end of your interview. Is there anything you want to raise with us before you go?
No, Chief Justice, I do appreciate the opportunity. Chief Justice, I hadn't congratulated you. I've never met you personally after your appointment also. I would want to just take the opportunity to congratulate you for your appointment as a Chief Justice.
Thank you.
It is encouraging and inspirational. Otherwise, there's no further questions from my side.
Thank you.
Thank you.
You're excused. Okay. What time is it? Tea break, comfort break, as I call it.
Chief Justice, sorry to the commissioners. I apologize. This is something that's not usually
is
done.
it the candidate? Okay.
Yes, it's me still. Oh, one thing I wanted to your question, is there anything I wanted to say? It just comes to mind as I'm wrapping up. The commission to also just consider the comments from the various individuals, the various entities, which I do appreciate that have also written their comments on my candidature. I would ask the Commission to also consider those as they're making their mind about the suitable candidates.
We will do so.
Thank you.
Oh, now you've attracted and honest. JP Mlambo wants to ask you a question. JP Mlabo.
Good afternoon, Advocate Mahona.
What have I done?
How are you?
I'm well, thanks, JP.
This is not part of the interview. I just need your guidance. I was listening to your experience as an acting judge and how you could not go ahead with, if I understood you well, with the Sajay program.
Yes.
Now, I just want to know whether you think it's viable to do what I'm going to suggest to you. What we did in Gauteng is we took all the Gauteng candidates and we made sure that every term we will invite them alternately to do a term, but the others who don't do it, only one does a term, the others share a term. That's 5 weeks, 5 weeks. And during that whole period, they are attached to senior permanent judges who are available to them at any given point in time. And the reason for that is that they don't lose touch with their practices, but they don't lose touch with the court. Do you think this is something that can work?
Internally, the thing about once you are taken out of your practice, this is what happens practically, JP. Practically, especially in the Western Cape, I don't know about Gauteng, once you are known to be someone who's on the bench, whether it's a term or alternative terms, the briefs don't come. The fear of the attorneys is the fact that you may not be available for that civil matter. I may need you now, I have to hire someone else, I have to spend so much money, and the briefs don't come. And incidentally, even now, since I've applied in June, I have received absolutely nothing. So it has its consequences. It sounds like a brilliant idea, but it has its consequences. Once you are in the bench, nothing comes your way.
Well,
practice actually stops and dies.
Yeah, well, probably that may be a Cape dynamic because the candidates appreciate that fact that they still have a foot in their practices. And they actually engage me as to how to structure their acting times to factor in what they're doing in their practices.
Yes, JP.
And that seems to be working. So I was just asking if you think it's something that could have traction here, but you seem to suggest there's a different dynamic.
There's a different dynamic. That's a dynamic. It sounds like a brilliant one, but it's just something that happens once you are on the bench, or sometimes now and then you go there, nothing happens. Nothing flows your way. You are completely dependent on what you are getting from such. I don't know if you're talking about pro bono on pro bono basis, JP?
No.
Oh, you get paid.
Stipendiary.
So nothing flows your way at all in your practice. Your practice dies. That's the practice, what happens here. And I've experienced it over the years since I've acted, which has killed my practice. And that's just another story as well.
You must relocate to Gauteng. Thank you, CJ.
Thank you.
Thank you, JP. And thank you, Ms. Makone. Okay, we'll take... Oh, there's another issue. Apparently, our lunch is set for 1:10, and the hotel would like us to go at that time because if we go later, like we did yesterday, there might be hygiene issues. I'm not entirely sure what that story is. It does not make sense to me if the food is freshly cooked, that it would go bad because we ate an hour or two later. But they want us to eat at 1:10. So what do you propose we do?
You can do one more candidate.
Take the candidate and break it at 1:10. All right. Bring the candidate in, please. Mr. Moses,
Good day, Chief Justice. Good day, Commissioners.
how are you?
Nervous, but okay, Chief Justice.
Don't be, we'll be gentle with you.
Thank you.
You have 4 degrees under your belt. A BA Law and LLB you did at the University of the Western Cape, and a Master's in Law and a PhD in Criminal Justice you did with UCT.
Correct, Chief Justice.
And your thesis for your PhD addressed parole in South Africa and included an analysis of local and comparative law in Commonwealth countries.
That is so.
And that became a book.
That is so, Chief Justice.
Right. Just take us through your career very concisely. Where do you start and where are you now?
I have attempted to summarize it in my
Just briefly.
in my CV, which is on page 211 of the paginated bundle. But as I've pointed out, Chief Justice, I have grown up in the rural area of Oudtshoorn, Skumanzuk, where I was bred and born, and part primary school there, part primary school in Oudtshoorn, where I completed primary school and I attended high school, completed high school there, attended University of the Western Cape, completed my studies. Obviously, got involved in student activities, political activities, it being in the 80s. Volatile period in our history, as we all know. But I completed my studies, and pursuant to that, I then was appointed as a prosecutor locally in Cape Town, in the district of Goodwood. That was also in accordance with a state bursary, which was granted to me prior to my studies by the then Department of Colored Affairs, which bursary turned out to be very important for me because that was the last option that I had, and I didn't know what I would do without having received that, Chief Justice, because I knew from my primary school years already that I wanted to study law. And not only that, that I wanted to become an advocate as opposed to an attorney. And that was born out of what I've observed in Oudtshoorn, not only in terms of our socio-political circumstances, socio-economic circumstances, but also in the political situation that prevailed at the time and what I have observed. Also on the family context, which was challenging. So out of that grew the desire and the determination to study law. Back to the prosecutorial aspect of that, while I was, when I enrolled, or when I became employed by the Department of Justice as a public prosecutor, it was daunting and ambivalent, given my active political activities in the past and how to reconcile that with now being a prosecutor in the context of that period, because it was viewed as basically that you're going to work for the same state that has been oppressing us. So it was ambivalent.
You had been involved with the UDF, I understand it.
Yes. But what a learning curve that was, because it's a totally different environment and I had to adapt to that. And it turned out to be a very good learning curve for me because I met other colleagues, I met white colleagues, and I had to work with them on my level and on a senior level. had to execute their instructions, which I did to the best of my abilities. And I concentrated on my work as a prosecutor to be a good prosecutor. And in that time, so I learned to get along very well with my colleagues, white and non-white, with the police, whom we previously only saw as part of the oppression. But they, as a prosecutor, they become the people that must support you in the work that you are trying to do. So you build up a good working relationship with them, and you learn to know them better than just being the police. Then working in the community where I was based, which was Bishop Lavis, Mdntv, its areas notorious for its crime, criminal activity, gangsterism, and drugs. As a prosecutor, I've seen often the results of that in my court, having to deal with it, having to prosecute youngsters, children whose mothers would invariably attend court and would come and plead with me and my colleagues. We were two stationed at Bishop Lavis at the time, to be lenient, and I don't know if you know, but you know, invariably they would refer to the prosecutor as the ondermagistraat, the under magistrate. And it became important to impress upon those parents, the mothers especially, because they would usually come into court and support their children, to try to advise them about their role as parents and the danger of their children embarking on this road. And often I had before the court would start at 9 o'clock, I would have a session or two, if time allows, to do that to the parents in court. And out of that experience grew the desire to do and pursue an LLM in criminology and advanced criminal law, because I wanted to understand the context in which I operate and how I can equip myself better to understand the work that I'm doing, given the environment in which I'm working. And I did that, and it assisted me a lot. So hence I was accepted, and I was enrolled at UCT for that course, which I completed in 1990. And that also led to my involvement. That, together with my being a prosecutor, involvement in NICRO, as is evident from my CV and the questionnaire, where I've also learned a lot, and especially about juvenile crime and alternatives, sentencing or punishment alternatives for juvenile, which we concentrated on as NICRO, an organization at the time, very much so. And that, I think, very much impacted the amendments to the subsequent amendments to the Criminal Procedure Act dealing with juveniles. And I also think, to a certain extent, the work that has been pioneered by NICRO influenced and impacted on the the Child Justice Act, which was subsequently promulgated and implemented. After that, I was appointed as a magistrate. My objective was really was hoping that I would be elected or selected to serve. At that time, it was the Attorney General's office, which is now the Director of Public Prosecutor's Office. But I was never elected or selected to serve there, because that means that you would now be a state advocate and deal with high court cases. So
How long were you in the magistracy?
I beg your pardon, Chief Justice.
How long were you a magistrate?
I think in all about 3 years.
3 years. And then you went on to do a series of other things.
Yes, yes.
Until you joined the bar. When did you join the bar?
That was around 1995. I think I completed pupillage and started
in December 1995.
Correct, correct.
And you are still with the Cape Bar?
I'm still a practicing advocate, but I think in 2021 I resigned from the Cape Bar.
Oh.
So I've been a member of the Cape Bar since 1995 until then.
Okay. Under the auspices of which professional body, if any, do you work now? Do you still practice as an advocate?
I still practice.
That was my impression.
I'm still practicing as an advocate, except that I don't hold chambers at the bar.
All right.
I hold chambers separately.
And what kind of work do you do?
Mainly assisting with legal opinions, drafting pleadings, and where necessary, having to go to court to deal with applications based on the instructions that I received. So it's civil. At the moment, we're busy with a company which had been liquidated and where the applicants have been trying to hold the respondents, or part of them, who had companies at the time personally liable in their personal capacities in terms of the Companies Act, Companies Act, and so those kind of cases, and depending on the cases with which you are briefed by advocates, you deal with them and you try to attend to them.
And what kind of cases did you do in the 23 years you were at the bar?
Chief Justice, it's a wide range of cases. Obviously, if attorneys would know that if you're fresh at the bar, coming from a prosecutorial and magistrate's background, your initial period would mainly be concentrated on criminal work, criminal cases, criminal appeals. And as you progressed, and besides that, obviously, family law, divorces. And as you progress, you deal with civil matters, you deal with applications, you deal with applications, interdict relief. You deal with local government legislation, provincial government legislation. But a lot of my work then also was centered around and was focusing on the academic work that I have pursued and finalized. So I was briefed quite a number of times to assist the Department of Correctional Services in matters against them relating to parole. So those are also cases that I had been involved in. I had also been involved in sometimes issues dealing with contracts, with delicts, road accident fund matters, medical negligence.
The whole spectrum, it seems.
And except maritime law. I've never been briefed in that. But I mean, over 35 years, you can't remember, but you will have to go back and dust off those files to see really what are the kind of cases that you've been dealing with. But it was a wide spectrum of cases.
and you have training in dispute resolution, diversity training mediation, and court annexed mediation.
Yes, yes, that was in the 90s when I had that opportunity, for which I was thankful at the time, because we were also in South Africa grappling and dealing with those issues such as those. So I grabbed that. I was still in the Department of Justice at the time, and fortunately my superiors gave me leave to attend that. And I learned a lot from that. And as I've pointed out, that led to me eventually enrolling and doing that course offered by Equilo at the time, dealing with mediation, which I completed.
You've acted in the Western Cape Division of the High Court and in the Northern Cape.
That is correct, Chief Justice.
In the Western Cape Division for about 4 terms?
That's right, in 2011.
All right, that was a while back.
It's a while back, yeah.
But in the Northern Cape,
that was recent.
3 terms?
It was for 2 terms in total.
2 terms?
Yes, July and then until November.
No, well, I'm looking at something that says it from April to November.
Yes, that's how it means that.
In 2021?
In July that term ended, the first term, my first term, or June, and then the next term started in July until November.
And did you write judgments during these acting stints?
In both divisions, I did, Chief Justice. Because of the time lapse between my acting stint in the Western Cape Division in 2011, I didn't concentrate that much on the cases in this application to the JSC. I listed more of the recent cases that I've done in the questionnaire, which I have also referred to and summarized the respective judgments, or some of them, that I've delivered in the Northern Cape Division.
All right. Thank you, Dr. Moses.
You're welcome.
AJP?
Thank you, Chief Justice. Dr. Moses, your history of activism is admirable.
Thank you, AJP.
You also authored a book on parole.
That is so, Acting JP.
I note that it's the first book of its kind. Can you explain to the Commission?
That is so, and I think that is also one of the reasons why I was accepted for my PhD at UCT, because it was a novel issue and a novel concept. And having completed it, I must admit I was putting in a lot of work, and it was, as you know, a panel evaluating and assessing. That kind of work usually consists of independent, international accredited academia. So I felt very proud when I got the results of the assessment of my thesis. Hence, I was awarded the PhD degree, and subsequently, and also during the time I think that I was still acting in your division, I was requested by Juta to consider writing a book, and I took up that challenge for a couple of reasons, because I have never written a book, and I had the requisite knowledge now to pen what I have researched and what I've studied for in a book, with the objective of not only confining my academic research to the academia, but sharing it with practitioners, sharing it with relevant role players in the Department of Correctional Services, probation officers, practicing attorneys and advocates, but also members of society who are interested in doing that, besides students who would want to concentrate in their studies on that aspect of the law. So I managed to complete the book, and it was launched. And since then, despite many efforts to try to get a revised edition, you know, the pressures of life and the pressures of work always led you to procrastinate. And it's still an idea, but it hopefully, let's see, perhaps with the necessary assistance one could. I'm hoping to update it. But yes, that is what I can say in that regard, Acting JB.
The last time you acted in the Western Cape, you did 4 terms in 2011. You were never invited back? What happened?
I think, I don't know whether you can recall, Acting JP, but towards the end of my last term, I think there were certain vacancies advertised for the Cape Bench. And I applied and I was shortlisted then. And I was prepared, and the day before my scheduled interview, there was an anonymous complaint. And at the time, as devastating as it was, the JSC obviously, in their better judgment, decided not to continue then with the applications for that division. So I was never interviewed for that. But that also meant an anonymous complaint emanated from the Bar Council that any applicant for a position such as this had to wait until that investigation is completed. And it took about more than 2 years for that, after which, well, another colleague of mine also became involved in that, and so on. And after 2.5 years, both of us were exonerated. So at least for that period, I could not avail myself for any such position. And thereafter, I had to concentrate on my practice, which I did. Another opportunity never availed themselves, or itself, whether I was invited to come for another stint. And as you also know, I think the divisions, and also Cape divisions, they try to be equitable as far as acting appointments are concerned, usually inviting organizations, not the LPLA, and to put forward certain names and so on. But yes, I mean, that's in part why I was never invited. I cannot take it any further than that.
I don't think you did yourself any justice with the judgments you annexed to your application. Now, I don't know, am I missing something here?
Yes.
Can you just tell me this QCK case, is the judgment part of the bundle here? Or is this an application for leave to appeal? So the whole judgment as well? The QCK case is here?
It is indeed,
Right.
Acting JP.
So was that case overturned on appeal?
It was overturned on appeal.
And then, Mokotedi, did you attach the case itself? Or is it an application for leave to appeal? I'm just checking.
Mokotedi is also, if you will just give me a minute.
I'm just making sure that I I'm not missing something. Is
No.
Mokotedi, did you add the judgment, or is it an application for leave to appeal?
No, the judgment I've referred to in my, in the questionnaire. I'm just trying to find the specific case number.
But-
Yes, that is number, it's on page 54 to 56 of my bundle.
Right.
The application where I've referred to that, which was an eviction application,
Right.
which after having heard the case, I granted an order in favor of the applicant, which was then appealed. There was an application for leave to appeal that decision.
Yeah.
And I also have referred to the application for leave to appeal
Right.
in
Yes.
my documents.
Thank you. And the Minister of Correctional Services, was that judgment, did it only relate to costs?
That only related to cost in circumstances where an order was given against the applicants, which was the minister, again in favor of the respondents. They were inmates at the time, and the order that was then given was that the department, that's the minister, had to release the inmates on parole, or they were directed to assess those inmates with a view to release them on parole. That order was then, or the minister or his legal representatives then gave notice that they're going to apply for rescission. But the order was given that they must be released on parole, or certain steps had to be taken with cost. So what happened subsequently was that the minister withdrew their application for rescission of judgment, and other factors also surpassed those applications, because the department had, in the meantime, decided to release all those inmates. And so when the case came before court, it was basically moot, because the subject matter had been dealt with, in that all those respondents, who was now the applicants, when it came before me, the applicants for cost, they were already released. And I dealt with the matter in that context.
Thank you, Chief Justice. I have no further questions.
Thank you, CJ. Afternoon, Doctor. Right here.
Oh,
Right, see. That's fine.
Sorry. I'm looking for my little handkerchief, because as you can see, I am.
Yeah, the aircon is, comes and goes.
I'm naturally sweating.
The Western Cape Division is known to have quite a heavy administrative law caseload. So I just want to ask you some questions regarding general admin law issues. The first one relates to supply chain processes, especially bid validity periods.
Yes.
So a government department puts out a tender with a bid validity period that lapses, let's say it lapses today.
Yes.
Yesterday, the advertising department sends out letter to all the bidders that are participating in the process, saying, look, due to circumstances out of our control, we need a bit more time. We need to extend the bid validity period by 90 days.
Yes.
Please confirm your agreement in writing. On the 16th, so bid validity ends today, so tomorrow, it's hypothetical.
Yes.
The department receives positive responses from all the bidders.
A day later.
A day after the bid validity period.
Yes.
But they requested before bid validity lapsed. What is the status of that bid, of that tender?
Well, it's hypothetical, but I would think that if those were the criteria that existed at the time, and that was the DAs, that was a time period that was advertised and which the bidders were given notice of, that at that time, or at the end of that period, that is the period which would have to be taken into account for a determination of that bid by the bid adjudication committee. If there is subsequently transpired that everybody concerned, that the bidders gave their consent a day later, then obviously that provides a ground for the bid adjudicators to consider extending it for purposes of their own adjudication, if it would, I think, assist them in a proper adjudication of the merits of the bids, to consider that consent or assent to a further extension. But the circumstances will have to be evaluated, because if there was, say, I don't know how many bidders there would have been, given the hypotheses, but if there would have been 10 bidders, and the majority of them, 6, 7, agreed to the extension, the other 3 not, I think it would be risky for that process then not to adhere to the original advertised and agreed upon and stipulated criteria.
Yeah.
Because those 3, or those who had not agreed to the extension, might come back subsequently, especially if they were unsuccessful to challenge that process. So it would depend on the circumstances of the case, but I'm dealing with your with your question in that scenario that you've put it
Yeah, but do I then understand your answer that if all of the bidders responded positively, that the bid validity period would have then validly been extended, in your view?
I think there would have been the risk that it would be challenged, the further procedure would be sufficiently less if there was a unanimous agreement to the extension of that period.
Right, you see, because my problem with that response is that there's ample appeal court and quite recent SCA jurisprudence on exactly that question, and the courts have been quite clear that
yes,
at the date of bid validity, if there's no consensus on an extension, then that is the end of the matter.
Yes.
The bid has lapsed, and that is it. All right, if I can just move on to the second question.
So if there is consensus, then that
in time,
yes,
time is consensus,
yes,
but not offer and then acceptance after the date.
Yes, yes.
My second question is, if you would mind explain to us your understanding of the principle of subsidiarity. And perhaps I can...
Principle of?
Subsidiarity. And perhaps I can preface it with an example. So let's say a disgruntled candidate is unhappy with the proceedings at the JSC and asks for the record of proceedings.
Yes.
And they rely on Section 32 of the Constitution as the basis for which they demand access to information and access to the, is that an appropriate reliance? And within the context of the issue of subsidiarity, how do you view that?
Firstly, Commissioner, I haven't considered that issue, pertinently for purposes of this interview. I must concede that, because I had to concentrate. No, of course. I had to concentrate on. But yes.
If I can perhaps be of assistance, so PIA exists, the Promotion of Access to Information Act, which is legislation drafted in pursuance of Section 32.
Yes.
Would a party still be able to rely solely on Section 32 to give life to that, or make that demand for access to information? Or must they do so via PIA and locate their right there, or at least find issue with PIA for not adequately protecting them?
As I said, I haven't applied my mind specifically to that, but based on what you have said, I would think that applicants could still try to locate that within Section 32.
That's fine. No, that's fair. Let's not take it further. Thank you very much. Thank you, CJ.
Commissioner Marumoga.
Thank you very much, CJ. I have an independent question, but perhaps maybe let me start first with the principle of subsidiarity, because I think it's an important question. It's not a question merely of purposes for the interview. It's a general question that I think every practitioner should be aware of, especially if you are litigating. I think the question is, if there is an empowering legislation that deals with the issue, can you assert your rights by focusing solely or claiming solely based on the Constitution directly? Like, for instance, on the example that has been made, if there is Section 32, can you go to PIA straight? If there is a Section 33, can you go to the LRA, and so forth? Can you rely directly to the Constitution? And the Constitutional Court has dealt with this issue in numerous judgments. I think that is the question, and I think that question is important.
Yeah, and I think just from a general point of view, Commissioner, the courts would obviously first determine whether your remedy doesn't lie in that empowering legislation prior to the constitutional provision, because this empowering legislation has been promulgated and passed in view and consistent with the constitutional provisions making provision for that. In other words, you have the broad general principle, the constitutional principle of right to access to information. But the specific legislation passed to deal with that is, for example, PIA. The Constitution makes provision for administrative justice. The national legislation dealing with that is PAJA. So if your right or remedies lies within that national legislation, that would be the first remedy or option that you will have to explore. And I would think, and again, I haven't applied my mind specifically to this, Commissioner, if from that it flows that there is still a constitutional issue to be determined by the Constitutional Court, then that might give space for the Constitutional Court to agree to accepting to deal with it. But that is just in general. I can't deal with specifics because I haven't applied my mind specifically to that.
No problem, Dr. Moses. I'll take the fact that you have not applied your mind to it. I have my separate question. And I think it is really important for us to test the candidates' understanding of some of the technical things that might arise should they be appointed.
Yes.
Assuming that you are sitting as a judge and you are dealing with a matter, with a motion matter, and the pleadings have been, the 3 sets of pleadings have been filed, but any of the parties wants to file a further affidavit or even a supplementary affidavit as a further affidavit. One, is that allowed? Let's assume that it is. And what is the test that the court should apply in order to see whether or not it can exercise its discretion to allow that affidavit and to consider the contents of that affidavit in a matter before it?
So you stated what the general principle is. That's the 3 sets of papers. If the 4th set would be the exception, and that will have to be applied for, that can only be done on application to the other parties. But as to the first part of your question is, as a general rule, that is where it stopped, but it can be allowed within the discretion of the court with the proviso, and I think one of the overriding considerations would be whether there would be prejudice.
I accept that you need to apply for it, but what I'm trying to get at, is there a test? Is there something that they need to convince the court, for the court to consider whether or not to accept that affidavit? Is there a test? Or you just, maybe in your paper, said, look, I apply to file this thing, then you file it, and that's all? Or is there a particular sort of criterion that they need to meet for you to be able to consider your discretion whether or not to accept the application?
So the usual test would be, I think, prejudice, which cannot be addressed via an appropriate cost order, and also whether it would be in the interest of justice to allow such a further application. But obviously, one would, in the context of a court case, you would go and consult the relevant rules and the relevant cases also to guide you, because as you know, nobody of us can claim to know everything. We know the basic principles, but when it comes to the specifics, and especially specifics of cases, then you will have to look at the facts, and you will go to see how the case law can guide you into dealing with those specific facts.
Yeah, but I would think these are sort of tried issues. But nonetheless, I will leave it there.
No.
Thank you very much, CJ.
Commissioner Ngulaito?
Thank you, Chief Justice. Dr. Moses, I just want to, because I couldn't really understand when I read your application at item 1.10, where the following statement is made. The aforestated also demonstrate, in my humble submission, that your applicant is or was at the relevant time both able and capable to deal with intrinsic and complex legal and jurisprudential aspects of law, not only in the High Court of South Africa, but also in the Supreme Court of Appeal, the Labour Court of Appeal, the Competition Appeal Court, and the Constitutional Court, should he receive any such instructions. Your applicant has, over the last 5 years, regrettably not received any such instructions from any of the big law firm, State Attorney's Office in the Western Cape, and the other provinces of South Africa.
Yes.
Inasmuch as your applicant is professionally bound to and constrained by our Professional Ethics Code, prohibiting any solicitation of work from any other person or legal practitioner, your applicant has no control over those who decide to issue and or allocate such instructions in respect of cases to be heard and argued in these superior courts, Labour Appeal Court, Supreme Court of Appeal, Competition Appeal Court, or the Constitutional Court or the High Court, nor does he have any control in respect of briefing patterns in our legal system. And then, this is the point I couldn't really understand. In the circumstances, it is respectfully submitted that the fact that your applicant has not appeared in these superior courts in the last 5 years is not and should not be construed as an inability on his part to perform that work and or to appear and argue such cases in those courts. According to your own application, in the last 5 years, you have not been to the High Court, to the SCA, to the Labour Appeal Court, to the Competition Appeal Court, to the Constitutional Court.
No, not to the High Court. I've been until last week, Commissioner, two weeks ago, because I'm still dealing with certain parted matters. But I have not been in the SCA, nor in the CC, nor in those courts.
Nor in the LAC, nor in the CAC.
No, I haven't been, and I think the simple submission that I'm making there is that despite that fact, it doesn't mean that I don't have the requisite technical or analytical skills to deal with complex and intricate legal issues.
Yes, because...
And I'm saying that because I don't have any control, just like any other advocate in my position, over briefing patterns.
Yes,
I shouldn't and I cannot be
yes.
unfairly, prejudiced by that, because
Yes. Well, I mean, this is a
I would
long
obviously
period.
be able to deal with it. I'm sorry, I don't want to interrupt. I just want to say that.
Yeah, no, that's fine.
I will obviously, as you are able to do, argue your cases, do your research, and do your work in those fora. If you receive those instructions, I haven't been given that opportunity, and it is prejudicial. But I thought I'm submitting that it should not be held against me by this forum, given what I have or demonstrated despite that.
Yes, well, it is a concern because the GCB says that the message of your appointment would be that people who have no practical experience can just be put into the High Court as judges. It is also of concern because your own application, when you are asked to highlight the cases that are significant and to give an explanation, you highlight only 4 cases. And when I look at those cases, I realize that in at least 2 of them, you were led, the one by Otkita SC and the other by Norman Arense,
yes.
SC. And I couldn't find a single one where you were the lead counsel. And the last case, the first one is 2002, well, 2001. And the last was 2018. And these appear at page 19 and 20 of your application.
Yes.
So this is all confirming the fact that actually the GCB is correct when they say what you actually lack practical experience.
I haven't been given notice of the comments of the GCB. I must say, but if you go back and if you have seen what I've done, Commissioner, it can hardly be said that I haven't been exposed to legal practice. I've been in legal practice for 35 years.
Well, that's what they're concerned with, that it's 35 years, but you've actually not been doing work.
Well, Commissioner, the cases that I've listed is obviously with reference to the requirements of the application, where you are requested to refer to specific cases.
No, I understand.
And it doesn't mean. I beg your pardon.
Are you saying the Secretariat did not give you the comments of the GCB?
I haven't received that. Otherwise, I would have prepared on that. I have received, and I mean it is here. I've received comments about certain organizations, people in organizations that have submitted certain comments. I have received a summary by the review committee, but I haven't received those comments of the GCB. But in any event, Commissioner, I would not, with all respect, agree with that submission for at least 2 reasons.
Yes.
What I have set out in my application points to the opposite, and that is that I have been involved in litigation, in the lower courts, in the high courts, and those cases that I've referred to also in the SCA at least. I've been involved in the High Court as an acting judge on the periods that I have referred to. And I'm saying that I've been involved, and I'm still involved, and I've been sitting as an acting judge in the Pardert case as late as about two weeks ago, and I'm going back to finalize that case. And for purposes of this assessment, I would say that that is an integral part of practical experience. And my work on the bench I would think would be of a primary focus for this entity to determine whether or not I'm fit to sit as a judge. And I would submit that the facts which I placed before you would indicate that I am, despite what the GCB might opine, and despite those other shortcomings which you have referred me to and which I have pointed out to the Commission in my application.
Yes, I mean, part of the problem with this practice issue is that when you answered the Chief Justice, you said that you left the Cape Bar in 2021.
Yes.
But you are also not a member of PABASA.
No, but I am a member of NADIAL and I am a member of AFT Commissioner.
No, those are organizations, they are not professional societies. So which bar are you affiliated to?
Well, Commissioner, I have approached it in the following way. I'm falling under the auspices of the Legal Practice Council, and there is no specific requirement or prescript that I need to belong to a bar. I have considered PABASA, but I am also a member, I'm a founding member of AFT.
Where are you practicing from? Because in PABASA, you must hold chambers. At the GCB, you must hold chambers.
Well, but Commission, as I've tried to explain, I am not, since 2021, a member of the Cape Bar, yes. And I'm not constrained by their specific rules. I am guided by the rules of the LPC, of under which umbrella I'm falling as a legal practitioner.
But where are you practicing from? Because you're not at the bar.
I have chambers separate from the bar, but I have left the bar for reasons that's not relevant here. But that doesn't preclude me from practicing as an advocate.
When you say you have chambers separately, I mean, the problem is one of regulation and protecting of the public, which is why we affiliate. We also don't want to affiliate. Where are you practicing from?
I have chambers at the offices of certain attorneys where the one section had been allocated to me.
You're practicing from an attorney's office?
Well, that is their floor space, but then there's a separate space which they've allocated to me.
Allocated by the attorneys?
Because it's part of their space.
I'm asking if it's been allocated to you by the attorneys.
Yes, because it's part of their space.
But isn't there a clear rule that we must be separate from attorneys as advocates?
Well, if you're physically there, it doesn't mean that you're not professionally independent, Commissioner. And I think that is always been an issue with or part of the issue with the Cape Bar and bars, that you are confined to certain spaces. I agree with you that it is generally in the interest of the public, but given the Legal Practice Act
It's
and
not
the absence of
generally in the
specific...
interest. It's a rule that we must not practice in the same place with the attorneys.
Well, Commissioner, I'm saying that my ethical standards as an advocate is not compromised because I don't keep chambers with a bar. I am still independent. I can still protect the interest of the public as well as that of my client, even though I don't have chambers at the bar.
Well, the LPC is here. Thank you, Dr. Moses.
I thank you, Commissioner.
Commissioner Moimong?
No, I think I've filed CJ.
President Molemen?
Thank you very much, CJ. Good afternoon, Dr. Moses.
Good afternoon.
I think in one of your responses, you stated that you still have to go back to the High Court to finalize apartheid matter.
Yes,
Which High Court is that? Is that the Northern Cape?
it's the Northern Cape High Court, and
Yes.
it's a circuit court.
Yes. I'm looking at your questionnaire here, and at page 40, which is 37 of the questionnaire, you indicate that you last acted on 20 June 2021. Is that correct?
Which page is that, Commissioner?
37 of the questionnaire, but it's 40 of the paginated bundle.
40 of the pageant. May I just beg leave to retrieve that from...
Yes. I'll read it out to you. It's just a short paragraph while you look for it. You say there, I was appointed and served as an acting judge in the Northern Cape Division of the High Court with effect from 12 April 2021 until 20 June 2021, which was extended until 30 November 2021.
Yeah.
Now, I'm just wondering if your stint acted on 30 November 2021, which matter are you still finalizing?
That is the matter of State versus Rooping. And I don't know, I'm just being referred to the page by the colleague here. If I can just refer you, Commissioner, to the index, and then there should be an indication to. I have it. The Circuit Court. So, item 17. Or I think item 16 and item 17, paginated page numbers, mine 106 and 107. If I can just find that.
Yes, my question is whether this matter has still not been finalized 3 years after the end of your acting stint.
Yes, no, it has not been. It's in the final stages now. The defense case has only been closed a week ago, or beginning of this month, when I went back. And the matter is now at the stage where final submissions, oral and written, will have to be made. The circumstances of that case is that it was, and I'm not going into detail just with regards to the time period. It's in circumstances where the accused is on warning, and both defense counsel and prosecuting counsel, as well as myself, must travel from different places to the circuit court and are subject to their cases and commitments also with their offices and chambers. And all the time we have to liaise with the office of the JP, the registrars, as well as the office of the DPP, and the local regional court for, firstly, time availability of everybody concerned, court availability,
all right, I accept.
And that would explain to a certain extent, and I can understand your concern, the duration, the length that it has taken. But
yes.
as I said, we are almost at the end of that case.
Thank you.
And
I
that is.
Thank you.
I also just need to. I saw from the commentary of the review panel Chief Justice that they noted that there's one outstanding judgment. So it's not.
I thought it's this apartheid matter.
Yeah, it is not an outstanding judgment. It is a part-out matter.
Yeah.
My outstanding judgment, I don't have outstanding judgments, as I've indicated.
Thank you. Thank you. May I ask my second question, Chief Justice? You indicated that you have done a variety of matters as an acting judge. Did you have occasion to consider an application in terms of which an ante-pillar order was sought?
Not recently, Commissioner. I've dealt with that, perhaps acting stint in the Western Cape.
Do you still recall what the requirements are?
I will have to refer and refresh my memory as far as that is concerned, but I'm not going to venture any agreement. If I apply my mind to that, and I've only applied my mind to that when I was seized at that time, but not recently. Hence, I cannot, from the top of my head,
yes,
refer you to that. But that I know of ante-pillars, yes. And I would obviously be able to find references to that and to go and read up on that and to deal with it if and when necessary.
Thank you very much, Dr. Moses. Thank you, CJ.
We've reached the end of your interview, Dr. Moses. Is there anything you wish to raise with us?
Perhaps just briefly, two things, if I may, Chief Justice.
Yes.
I just want to impress upon this forum why it is important for me to become a judge. For me, it is the next logical step in my learning curve because, as I've endeavored to point out, nobody can claim that he or she is ever fully learned. And I consider myself to be still in a learning curve. And this next step, should I be afforded the opportunity, would provide me with an opportunity to learn, in addition to the experience that I already have gained and the knowledge that I have gained. And I believe in constant learning and being open to learn. It has also come, and I have also come to the realization that having gained all this experience, as I set out in the questionnaire, I can and I'm able to deal with the responsibility that comes with being a judge. And it's not an easy one. It is a very important responsibility. And having done what I have done and what I've endeavored to demonstrate, I realized what that responsibility is, and I'm able and willing to deal with that responsibility, because I'm not, as you can see, as young as I was 10 or 12 years ago when I applied for the first time. I'm experienced, I'm older now, and I've had sufficient exposure to the bench, to interacting with colleagues, interacting with practitioners, dealing with cases, adjudicating on them, to understand exactly what's the role of a presiding officer, the role of a judge, what is the responsibility of a judge, not only in the context of a specific court case, but in the context of the office and the position of a judge. What I can add, apart from my background and history and the experience that I've gained through my formal legal training, as I've endeavored to demonstrate, Chief Justice, and my extra formal legal experience, is to share, impart that knowledge with colleagues, legal practitioners, and the community at large. I can play a role, and I can add as far as that is concerned, because what I've gained over the last years is not, I've demonstrated that in my application. I'm also submitting the CJ that, given the specific skills that I have referred to, and more particularly my research that I've done in the book that I've done and the work that I've done, should I be appointed, I can be of value to the Office of the Chief Justice, or in consultation with the JP, to serve on structures such as the Judicial Inspectorate, or the Correctional Supervision and Parole Review Board, or even the Rules Board, or commissions, all issues that I have expertise in, that I have skill in, and that I have done in the past. I haven't acted, I haven't been in the Judicial Inspectorate, I haven't been on the National Councils for Correctional Services, but in the course of my litigation and assisting clients, I have interacted with them. I know what their challenges are, but the point I wish to make is that I can add in that regard, if should I be appointed. And in addition to that, because I have practiced in the Western Cape predominantly, in the lower courts and the higher courts, I know the legal practitioners there. I know I've acted in the Western Cape Division. I know many of the judges there, the senior judges, and a few of the younger judges. I know the people that work in and around that court, as I know the people working in and around the court in the Northern Cape Division, all of whom with whom I had good relations with, from the JP to the people planning the office to the security officers. I'd always maintained good relations with them. And in the context of the Western Cape, and given my skill in mediation, I can add that value in assisting colleagues within the Western Cape to try to work with a common purpose, try to work towards fostering that sense of collegiality and unity that I know of when I was a member of that bench, albeit in an acting position. And to conclude, CJ, I just want to refer to what I have said in my questionnaire, with regards to my experience, and that is on page 18. I'm not going to repeat that of the bundle. My demonstrated skills, that's on page 19. And the submission that I'm making on page 19, paragraph 1.3 there, that I am given all of that. I'm a worthy candidate to be recommended for a position on the bench. And I am.
We will consider all this material, Dr. Moses.
As it pleases you,
Thank
CJ.
you.
I thank you for your time, Commissioners. Thank you.
You're excused. Are you still tidying up? You let me know when you're ready. You ready? Okay. Good afternoon.
Good afternoon,
How are you?
Chief Justice and Commissioners. I'm, well, a bit nervous, but I'm good to go. Thank you. Thank you very much.
Don't be nervous. You're an attorney.
That is correct, Chief Justice. I've been an attorney for 31
years.
and a few months. That's
My
correct.
goodness. That's a long run.
Yes.
Running a practice in your own account.
Yes, I've run my practice for my own account since 1993, since the day I was admitted as an attorney in December 1992.
Okay. Before that, you studied law, of course.
Yes, it was a bit of a long journey before I got to actually being admitted. I was first at the University of Cape Town. I did a few years with them, and then I got married. And then love was above the law, and I then, and then I took a break in studies. Then in 1985, I then entered into what was then, it's no longer the position, the long-term 5-year contract to allow one to study and do what was called articles of clerkship. That was the terminology back then. And then I did it with a firm in 1985 to 1986. It was a volatile era in our political history. I did a lot of the criminal matters, a lot of the public violence cases. And then I fell pregnant in 1986, and that was a break in my articles. The pregnancy meant a lot to me because I had a previous miscarriage and I really wanted to have this baby. And then I did not proceed and complete the remainder of my period, which was, of course, another 3.5 years left on that contract. But more importantly, by the time I got to 1990, I was itching to get back into the profession. So it's been a long journey. Also, no condemnation was allowed back, at that time. The law societies, the rules were very different.
Yeah. And you had a BBROC from UNISA and a certificate in labor law in your pocket by then.
Yes, I then, I achieved the UNISA BPROC degree, and then I did further certificate studies and advanced diplomas to sharpen my toolkit.
You're an arbitrator?
Yes, when I was placed on the panel with the Road Accident Fund, it was very important for me to understand because then it was not litigation. Remember that the Road Act personal injury law had changed from the token system, the litigation system, to the arbitration pilot project, and I needed to be able to have the necessary skill set, I believed, although I was the panel attorney, as to what it needs to be an arbitrator. And I'm very thankful for that experience because through that experience, I attended an international arbitration in a RAF matter in the Czech Republic.
And you have a certificate in disability medicine from a university I've never heard of. Where is Marshall University?
Sorry, Chief Justice, it's Marshall University in the United States of America. Those who do personal injury law are familiar with disability medicine. And that was also because of being a panel attorney at the outset of my career in personal injury law for the defendant. Often we needed to meet with counsel, and I wanted to be fully au fait with what the medical terminology meant and the disability consequences and the sequelae. So it gave me that competitive edge to read medical legal reports quite quickly. Although I come from a family of medical people, I wanted to ensure that my medical negligence and my medical law was up to notch.
Yeah, and you have many other certificates as well.
Yes,
including one in mediation.
Yes, several in mediation. They were because I was placed on the land reform management panel to render legal services. And again, I ensured that I was fully qualified for that position. I also, I was very happy that being on that panel and me having had these certifications, as well as my mediation and arbitration experience, allowed me to train other service providers on that panel for the Western Cape. It was held in Cape Town, and I did it more than once. In terms of further mediation, yes, I've also done PABASA quite recently, and that stems from my one appointment that I had at the Gauteng High Court, where my role was mostly opposed Rule 43 applications and contact and care. And I thought, again, let me quickly, I'm a daughter of a teacher, so I'm always going to be learning. And I did the PABASA. It was an international mediation course on family law. That was the most recent certifications I did, besides other leadership courses with the Nura Women's Institute in Indonesia, where I passed with distinction in July this year.
Good, congratulations. You mentioned that you've chaired the tribunal in heritage, and I see you've listed 2 heritage bodies here, the Heritage Western Cape and Cape Heritage Trust. Are you referring to those 2 bodies?
No, Chief Justice.
Where were you dealing with these appeals?
Yes, so there is the National Heritage Resources Agency Act, and that is to restore the culture and heritage of our peoples of South Africa. And because I had a very keen interest in it, Chief Justice and Commissioners, you might have noted that I enrolled for an oral history, master's in oral history at UCT in 2011, because I was always fascinated about people telling their story. And I was also cognizant that there were still so many stories to be told about South Africans and our indigenous people. So that then saw me being nominated to the board of Heritage Western Cape. So that's a board which council actually, which sees to any appeals in the built environment. So if a structure is older than 60 years, whether a developer could build and they would then necessarily have to seek the permissions from Heritage Western Cape. It's not just about the built environment. The one matter that I included, and I will get there now, Chief Justice, is about a natural resource where I had to make the determination regarding a natural resource and the right to housing. So going back from Heritage Western Cape, I was soon elevated within the council to serve on its appeals committee. And because I'm a lawyer, I put the job just suited me so perfectly. And then the opportunity was that the Minister of Arts and Culture, it was called then, it's now Sports, Arts and Culture, advertised a position for a tribunal member for heritage appeals directly to the Minister, when in instances where Heritage Western Cape's decision was against an applicant. So I held that position for quite a long time. I've learned a lot. I've always sat as the tribunal chair in that position. I think it's probably 8 years that I served the Minister as his tribunal chair then. And I would sit with an architect, as well as either a historian or a cultural historian, depending upon the nature of the dispute. And one of the judgments which I have included in my pack, I know that the requirements were for at least 3 judgments, but I thought it was very important for me to include this quasi-judicial function that I had as a tribunal chair. A very important case, and commissioners are welcome to ask me questions about it. For me, it was a very important case. In a nutshell, it was a decision to develop housing for low-income socioeconomic groups on the Cape Flats. However, for me, it was the area concerned is regarded as the food basket of the Western Cape. It's where all our greens come from. But under that agricultural land is a natural aquifer. And I could not have heard this matter at a better time than during our drought in Cape Town. And I had to balance those interests of the right to housing and providing housing, which is of utmost importance to citizens of South Africa. However, I had to balance that as against this natural resource, a enduring resource. And in my mind, when I wrote that judgment, it was purely that find land elsewhere. That was my message in a nutshell.
Yeah. Your practice is a general one.
That is correct. I'm very much like a doctor that sees patients with different ailments, and I think that's the best way to describe it. From the outset, when I started in 1992, given my experience in criminal law, remember when I did my articles of clerkship, I did a lot of criminal matters, and so when I opened my practice, I was then able to continue doing such work. But work was non-existent for, one didn't have paying clients to pay Rihanna Khan Parker in Grossie Park, out in the southern suburbs. So I had to enroll with Legal Aid Board, that's what it was called then, and I rendered legal aid work, family law, legal aid matters on criminal briefs, for almost 10 years of that practice. During that time, though, I did have some insolvency matters because the law firm that I completed my articles of clerkship with was Canterfielke, Frank and Roop, and they did a lot of commercial work as well as a lot of insolvency law. So in the period between 1993 and 2006, I picked up some insolvency matters, which I brought to the High Court, and my practice was very general, doing absolutely everything as I do till today, including intellectual property law, although I am not a patent attorney.
You've acted in the High Court since 2004.
Yes.
Mostly in this division to which you're applying now.
Correct, Chief Justice. I am grateful to an organization, a democratic organization called the Black Lawyers Association. At the time, I was a good friend of the retired Judge Yakiso. And he nudged me and said, you need to be on Black Lawyers Association. And of course, I then did so. I was first the secretary in the early years, and then I became the chairperson 2002 to 2003.
The first woman.
When the first woman, now I don't know, Christine Kunta might have been the first woman before me.
Oh, yes.
Yes. So what then happened was, then I got the invitation from the JP at that time to come and act, which I did. I welcomed it, and I did my stint for one term only. I did a fair amount of work, 2 criminal full trials, criminal appeals, and a few civil matters besides motion court and opposed motions.
You were once in the Gauteng High Court, but the period that's listed here totals up to 4 days. What were you doing there?
No, I was invited. Thank you very much to the Judge President for inviting me to come and assist with the burden of the civil court at that point in time. And I happily, again, accepted the invitation, and I agreed to do it pro bono. I was allocated 1 week to do it, although the dates are stated there as being 22nd, 23rd, 24th, 25th, and 26th. My first matter I heard was on the 22nd. I've got it here, the printout. However, the one matter which became a reported judgment in 2019, sorry, let me just get it out, please. Yes, so I was invited to do the week, and I then did opposed motions, more particularly 5 opposed Rule 43 applications, or 4 opposed Rule 43 applications, as well as a contact and care matter. It's the contact and care matter which I then finally heard on the 1st of December. Shortly after that, I contracted COVID, and I kicked myself because I really wanted to deliver that judgment swiftly. I did, however, deliver it within 14 days. It was delivered on the 14th of December 2021, and it is a reported judgment that I've done in that court. That was done virtually from the comfort of my chambers in my office. I was
So you
sworn in
do have a
virtually.
reported judgment?
Yes, I do.
How many?
I've got 3 reported judgments. Yes, I regret that when I had applied for this position, I did not have all that information before me. And hence, when the question arose as to how many judgments I had been reported, at that time, I could not find this particular one. I managed to locate it, believe me, Chief Justice, a day after I submitted my application form. It's case number 1326 of 2020. That's the matter in the...
What was it about?
That was about, I gave a judgment on the voice of the child and the parenting coordinator. I must just admit that after 2003, I didn't do much family law because I was largely seized with the road accident fund matters. And I had somebody in my office that would do my family law matters pretty well. So that was my first challenge that I really had, to write that judgment. And I wrote it, and it became reported. I can deal with the other 2 reported judgments if you would like me to talk about it now.
No.
Okay.
Your last acting stint was ended just recently in September, in late September.
No, Chief
You've
Justice.
listed,
I've been continuously acting. Gosh, now where's the periods here?
Oh.
Yes. I was
April.
invited. I was invited by the acting judge president to come back. To the division. That was on the 17th of July, 2023, to the 15th of September, 2023. All those periods then are in the pack. I then did, that was a full term. I then did a half term from the 2nd of October 2023 to the 3rd of November 2023. The reason for that is because I discussed it with the acting judge president that I needed to get back to practice because December is a time where I needed to, my focus needed to be in the practice. So I'm very happy that the acting judge president gave me the opportunity to do what is called a half a term. I then was re-invited to come back on the 15th of April, 2024, and today I am still acting Chief Justice.
And I count about 9 months for the entire...
It's about 4 terms, 4.5 terms. I've not included my ad hoc week, and I've not included Judge President Mlambo's 1 week.
And I imagine that you've sat in all the courts, civil, criminal, trials, appeals, motions.
Correct, Chief Justice. I've had the good opportunity to sit in all the divisions, criminal and civil. I've also done the pre-trials, the backlog court role in terms of Rule 46A applications. Yes, I've done pretty much everything.
Have you conducted trials to finality?
Yes, I've done trials to finality, probably about 6 of them, Chief Justice.
How many criminal?
Criminal trials, I've done in total across the periods 2 full criminal trials. The one that's in my bundle is a very earlier one. It was a reportable judgment which I did on the minimum sentence. The Waterboer one, I apologize that it's in English and it's called Water Farmer there. That's because on Safli it was in Afrikaans, and I thought, let me rather just get the Safli has a provision there where you can type in what language you wish the judgment to be printed out in, and I then printed it out in English. So that was the one criminal matter, and I did another criminal matter. The second criminal matter, which I did in 2004, went on appeal, but my decision was upheld.
Oh, good. So, apart from these 3 reported judgments, you mentioned how many other written judgments?
To date, as I sit, this morning another one went out, so I have 48 judgments that I've done. The bulk of it has been done, I would say, from April 2024 to date. The 2 reported judgments I've picked up in August and September relates to judgments where I was able to deliver the judgment. For example, the one was, I heard the matter on the 3rd of August. On the 8th of August, I delivered that judgment. That became reported. The other judgment I delivered on the 29th of August. It was on insolvency. I delivered it on the 5th of September, and that was also reported. And there are other reportable judgments which I'm following up to see, where they are in the system.
The GCP seems to have you all wrong, because they raise a concern that you have little acting experience and you have written only 4 judgments. So I'm surprised when you mention 10s now. What do you say to this criticism? Because it leads to a damaging conclusion that because you have this, or you have only 4 judgments under your belt and little experience in the High Court, it is not possible to assess your proficiency in law.
But with all due respect to the General Counsel of the Bar, if they had read my full application, which I had submitted as part to the JSC, they would have seen a list of judgments which I did include, which were 25. That was the list of judgments that I could gather, and I think it's on page 33, if I'm not mistaken, of my bundle. I'm not sure. It's a list of judgments which was accompanied in my application. If Chief Justice can just give me a few minutes, if I can just check where it is in this bundle.
We don't have a few minutes, Ms. Parker, unfortunately.
Okay, be that as it may, I did annex it. It's in my application form that I attached a list of some judgments. There were 25 listed. So I couldn't understand when I saw that comments from the GCB. And it just didn't make any sense that I would be shortlisted on just 4 judgments.
You're a gender activist.
Yes.
You're involved in a number of bodies that have to do with the promotion of women's welfare.
Oh no, absolutely. It comes second nature to me to use my voice at every seat, at every table that I am at, to look at the composition of boards and councils. And that's borne out purely because of my own struggle to get work. It's born out of the pleas of women, born out of people that have left my practice, and my colleagues who complain that despite them having the necessary specialization, they just do not get the paying briefs. So I use my voice wherever I am. For example, I serve on the Legal Aid South Africa. Yes, I've come full circle from being a panelist for Legal Aid in 1993 to 2003. I then became a Legal Aid panelist again in 2022 to 2023. And when the opportunity became available to serve on its board, I applied and I was successful. At that, in our meetings, I would interrogate, for example, the briefing of our practitioners on our adjudicate system. I would ask them for the statistics. And because legal aid is regarded as the flagship of access to justice for South Africa, they really could produce pie charts and bar diagrams with regard to the gender splits, because it is something that I watch very closely. And that is borne out by the statistics in the profession that troubles me. Today, as I sit here, the last figures that I have before me tells us that we've got 36,000 legal practitioners in South Africa. That includes advocates and attorneys. However, when we look at the gender split, you see that the figures don't make any sense. 14,000 of that 36,000 are women, and 21,000 are men. If you break that further down into, black-colored Indian versus white, black-colored and Indian practitioners together makes up 17,000 practitioners versus white practitioners of 18,000. So there's a there's a disconnect. So what I did was, when I was attending a BRICS Law Summit in 2018 in Cape Town, and at that BRICS Law Summit, of course, it involved Russia, China, Brazil, India, and South Africa, I was shocked and alarmed to see the absence of women lawyers, firstly on the panel, and then secondly, attendees. On the panel, there was only one woman. She was from Russia and she couldn't make it. The other person was Janine Myberg, but she was called to chair the meeting. And in a breakaway session, I had noted that in that particular breakaway session, we were about 60 candidates sitting in that section, in that meeting, and there were only 3 women. And that began the light bulb started flashing, that I can now understand why women are complaining that they are not getting the work, because they're simply not visible. And that then led me to create platforms for empowering and training women to be recognized and to and also for nomination to the judiciary when positions come up. I've used that voice in each and every board that I serve on, that's before each and every commissioner. For example, at the South African Heritage Resources Agency, there we are concerned about recognizing the heritage, the rich cultural heritage of our indigenous people in South Africa. I'm the only woman serving on that board. And when I asked the CEO and the chair, how is it that I am the only woman amongst all these men in 2023, I was told women do not apply. So, we sit with those very niche areas in law, which are areas in law which are going to be dominating, I believe, our legal landscape going forward. Connected with that South African Heritage Resource Agencies is, of course, the tangible heritage and the intangible heritage. And I'm more concerned about that intangible heritage that we've not covered. Coming to perhaps the South African Geographic Names Council.
No, let's not get there.
Thank you.
I just want to know what will happen to your directorships in these bodies if you are appointed.
Yeah, I've always imagined, I need to just premise this with this first. I've always wanted to be an entrepreneur. A position of the judiciary was never on my horizon, I must be honest. In 2004, when I had the taste of it, it was still not on my horizon. I enjoyed it, but I couldn't see myself. I felt I was too young at that point in time. So I saw myself as being the foremost women-led law firm in the country. Part of that dream came true in 2019 when I expanded my footprint out of Cape Town to Kimberley and Gqeberha. Unfortunately, that didn't last very long. So that was always my vision. But I'm mindful that as time goes on, we develop, and I think I've done my fair share of running my business. I've mentored many through that practice, besides mentorships outside the practice. And I do believe that a new challenge is where I should be, and if I can add to the rich jurisprudence of South Africa, perhaps developing the common law in terms of all my heritage experience, I believe I would then be making my mark. So I'm quite happy to hand over the directorships. I have able people who are able to take it forward. I must just add that to serve at the Western Cape High Court from April to date means that my practice still continues. Of course, I have no connection with my practice because I understand what my ethical responsibility is as a judicial officer. So I've developed other people who can then take over the reins if I am successful.
All right. Acting Judge President Goliath.
Thank you, Chief Justice. Mrs. Parker, you've been acting at the Western Cape High Court for some time. How did you find the experience and the support provided by the judges in the division?
Thank you very much. I firstly need to say that it was a very different experience. 2020, I can't compare 2021 because that was, I did the entire, all my matters were heard virtually. But if I compare 2023, 2024 to 2004, it's a completely different experience to 2004. And I need to say that because way back in 2004, there were very few people of color at the Western Cape High Court. I could not walk into a judge's chambers and get advice or direction. There were very few women, probably only 3 black women at that point in time. Come 2023, I knew some of the judges, some that came a long way, and then, of course, there was a range of new judges. I understood what the protocols are in terms of me coming in as an acting judge. I would go to the judges and introduce myself, tell them that I'm new in the division. I've always been welcomed with open arms, AJP. I've never had any, the slightest contestation from a judge in the division. And then secondly, the AJP, you've always told us in our judges' meet for African Women in Law, launched their report and spoke about the bottom rung. That bottom rung needs to be fixed before we can accelerate to positions of leadership. So my transformation would continue. If I'm appointed as an acting judge, believe me, I would continue. There is one aspect where I have already started thinking. I was approached with regard to the training of judges, because aspirant judges, because there's a problem that we have, and I hope the minister's here, I can't see so far unless I put on my spectacles, that many women would want to be trained to be judges. However, they cannot afford to leave their practices to attend training. That's problem number 1. Problem number 2, that the training that is available to them, I think it's only done over 2 to 3 days. Acting Judge President, you would know. And that is certainly not enough. You can't train an aspirant judge in 2 to 3 days. Yes, I was one of those products, but I do believe that it needs to be a funded project, and that stipends need to be paid for aspirant judges. Then we're going to get more women. What are we currently sitting at the judiciary? 282 men judges versus 115 women judges. So the scales are definitely not up. So short answer to you, Commissioner, it's work that will always be under construction and in progress.
Thank you, Ms. Parker. Thank
Professor
you,
Marumachai.
Thank you very much, Chief Justice.
Sorry, before you have a bite, Prof, there's a follow-up question from JP Mlam.
Ms. Parker, I just wanted to correct you. The women aspirant judges program is year-long. It's not 3 days.
Yeah, yes, perhaps I'm incorrect. I was referring to the training that where aspirant judges are invited to be trained, and I've always seen it as being over a
Yes,
very
there's
short
one-
duration.
There's one
Yes.
that happens
Yes.
every January, but that one is both women and men. The Women Aspirant Judges Program is year-long.
I was not referring to that one then, JP Mlambo. I was referring to the very short duration. It's wonderful that we have those platforms, but women can't leave their practices, and they need to pay for their flights and their accommodation. That is what I was told when I suggested some candidates to go for judicial training. But I will accept the longer program that is offered, and that's wonderful.
Professor Marumake?
Thank you very much, Chief Justice. Good afternoon.
Good afternoon, Commissioner.
My first question is in relation to the debate that you had with some of the commissioners with regards to the TAC1 rule. I was a bit confused, but I see that this is the issue that came before the Supreme Court of Appeal and the Constitutional Court, and in respect to municipalities. And my question is, I mean, I've just seen briefly what these two courts have said, but I just want to understand from your side, because the Constitutional Court is saying that TAC1 rule is a subspecies of estoppel, right? And they provide a reason why they are saying that. Can a TAC1 rule, either in its common law understanding or in its sort of codified form, in as far as the Companies Act is concerned, be used in the context of municipalities? Like, if we understand it as a proper common law rule, is it something that can be used? Because the people in this case, they were saying, no, actually we should take lessons from how it is used. But can it be used in the context of municipalities?
Commissioner, if I'm going to venture an answer, then it's going to be guessing. So let me rather not do that. And believe me, that's the first thing I'm going to do when I leave this room, is to go and read up on the Turkin rule.
Okay. No, that's fair enough. My second question is, and I think it is important sometimes to really assess the candidates who wants to be judges with respect to the uniform rules.
Yes.
And really get a sense of how especially the most popular ones, because this is not an exam really to test whether you know or you don't. Just want to see as to whether some of the tried issues are on the person's fingertips. Normally, in various divisions of the High Court, a lot of matters are brought on an urgent basis. Sometimes we hear words like semi-urgent. So there are always those kind of distinctions, but the rules, when you look at them, it's like a matter is ordinary or the matter it's urgent. I just want to understand what is the test for urgency, because sometimes you go to court on an urgent matter and the judge says, no, this is not urgent. Sometimes on the same facts, another judge says this is urgent. What is the actual test for urgency?
Thank you very much for that question. It's a very important question, because if you sit in the motion court and urgent courts, that's always foremost in your mind, Rule 612B, that the founding affidavit must specifically, clearly set out what renders the matter urgent and why substantial redress cannot be made in due course.
Okay. No, thank you.
Thank you.
Thank you, CJ.
Commissioner Moimang?
Thank you, Chief Justice. Greetings to yourself, the Kwaga, this side.
Good afternoon, Commissioner.
Just one question from my side. From your observation, does the Constitution stand in the way of land reform? Or do you think that there is adequate provision, or do you think that it makes space for adequate provision for judicial control to ensure that there is equitable redistribution and restoration of land?
Sorry, Chief Justice, if you can just repeat, I couldn't hear the last part clearly.
Are you of the view that there is enough space in our constitution for judicial control to expedite the issue of land redistribution and land restoration?
Yes, a very, very important question. Land is always close to people because our identity is inextricably linked to land. The Constitution makes provision in terms of advancing people's rights to land. And there are various provisions if we are talking about in the domain of land claims or ESTER applications or labour tenants. Yes, there is a mechanism that's very much in place for land claimants to assert their rights in terms of them having been dispossessed of their land or of their rights if they were labour tenants, and the same goes for farm workers. I think there is enough. We battle with issues with regard to, firstly, getting landowners to acknowledge that there was a dispossession. That I've been involved with, so I'm fully aware of the difficulties that one has with that, and that is specifically related to the compensation, the difficulties that one has with landowners pushing for market valuations rather than looking at and understanding that land reform is to redress the inequities of the past, that when the land was acquired, it was acquired in terms of a particular apartheid policy, where a tract of land was given to Mr. X with a land bank loan at favourable interest rates, and then we grapple. So through our jurisprudence coming through the Land Claims Court, there are cases that deals with land reform in that respect, and I think that we can't even. There are several other land claims where people still wish to make claims, but they cannot because of the judgment that was given down by the Constitutional Court, that the backlog cases first need to be adjudicated on. There's only so many judges that hear those matters, and perhaps if we could capacitate the Land Claims Court with additional judges, I think then we would be able to get our citizens more satisfied. But the longer we take, and more people die before they see their land or their compensation, I believe does us an injustice.
Thank you, Roger Parker. Thank you, Chief Justice.
President Molemen. Thank you very much, Chief Justice. Good afternoon, Ms. Parker.
Good afternoon. I just got.
Over here.
Sorry. Thank you. Okay. Thank you. Good afternoon, Commissioner.
Yes. I'm looking at your questionnaire, and I see that you state that your exposure to criminal litigation is 5%.
Yes, that was now. It's not. Yes, I think it is 5%. Yes, no, correct.
Yes, so
yes,
as at the time you completed
yes, it is 5%.
Yes, your proportion of litigation, criminal law litigation was 5%.
That's correct.
And I think you indicated that you conducted only 2 criminal trials throughout your acting stint. Is that correct?
That is absolutely correct. 2004, I did 2 long-duration criminal trials, but in practice, recently, 2022 to 2023, I was back on the Legal Aid Board's panel. I did criminal work, and historically in my practice, I would pick up private clients who, and that's what the 5% reflects.
Yes, I'm talking now in terms of what you have done while acting as a judge.
Only 2.
Only 2.
Besides criminal appeals. And
yes, I'm talking about criminal trials.
Only 2.
You have attached a judgment here, but the judgment that you have attached is only on sentencing.
That's 2004. Records are not available. I tried to get a list of all my cases, which I did in 2004. That is what we could find on SAFLI because it was marked as reportable, and that is all that it shows on there. We have been trying through my registrar at the division to go and access the archives because I was keen to see my various judgments, which I cannot add to my judgment list, which I did in 2004. Unfortunately, it was before the capturing of the digitization as it's done now. Unfortunately, it's lost.
The concern that I have is that you say that your exposure to criminal law is only 5%, and then you attach only one judgment, and that judgment is also only on sentence. So how do we now fairly assess whether you will be able to cope with the conduct of criminal trials, especially considering the fact that AJP Goliath indicated yesterday that most of the cases in that division concern multiple accused, and as a result, they are regarded as more complex. And the judgment, the one judgment that you have attached relates to a single accused.
Sorry, yes, my apologies. I could not find, my registrar only found the second file, couldn't find the Waterboom one at all, except for what is on SAFLI, but she managed to find through the criminal registrar's section at the court, or the criminal clerk, my second my second criminal matter which I did, and she found it purely because that matter went on appeal. So she gave that to me last week, and that full judgment together with the sentence is now in my possession.
It's not before us.
No, I was not aware that I could supplement my papers, Commissioner. If I had known that, I would have sent it.
I hope you understand my concern, because I think you'll agree that criminal law is a very important aspect of the law, because eventually if you sentence a person to imprisonment, you have taken away their liberty.
Absolutely. I fully agree with you, Commissioner.
Okay. Under what circumstances would you go into would you order that you go into a trial within a trial?
Yeah, a trial within a trial in a criminal context?
Yes.
Yes, that is where there would be, a trial within a trial, I would think would happen in the instance where certain allegations are made against the co-accused, and then I would have to hear that specific issue. Yeah, I'm not exactly, perhaps my answer is not correct. Let me not guess it. Thank you.
Thank you very much.
Can I follow up,
thank you,
CJ?
Can a criminal trial, a trial within a trial, be conducted in any other context than in a criminal trial?
No, I've never seen it happen in civil matters, but I'm aware of it happening in criminal matters.
Oh, no, I was just responding to...
Yeah, no, I'm thinking clearly now, so only in criminal matters, yes.
All right. JP Mlambo.
Good afternoon again, Ms. Parker.
Good afternoon, JP.
In your acting stint, have you ever sat in a full court and scribed the judgment?
Yes, I have. I have done in an appeal, yes. I've done it in 4 matters, of which 3 of the 4 I was the scribe.
I see. Okay. Do you understand the the plus-con events rule, and under what circumstances is it applied?
A very important rule in motion proceedings, that an applicant would be granted relief when a respondent admits the averments made by the applicant in its founding affidavit and does not contest any of those averments. In those instances, the applicant will be successful So it's the admitted facts in the founding affidavit together with, where the respondent admits the facts in the founding affidavit and the uncontested allegations made in the founding affidavit. If that is the case, then, only then, in terms of the Plaskon-Evans rule, will the finding be made in favor of the applicant.
There was another follow-up hand. Who was it?
No, CJ, you asked the question that I wanted to ask, so I'm
All
covered.
right. Is the follow-up? Okay. Commissioner Nkaito?
Yes, thank you. I did have a different question, but I do need to explore the Plaskon-Evans understanding. Because I'm not sure if it's about granting relief or whether it is about resolving disputed issues, or whether you appreciate the distinction.
Yes, it's about resolving the disputed issue that I will find in favor of the plaintiff if the averments
there's no plaintiff.
I mean, by the
Plaskon.
applicant, sorry,
Yes.
my apologies.
Yes.
If the averments...
So you mentioned one where the facts are common cause, but that's not where Plaskon-Evans applies.
No.
So then, where does it apply then?
It applies in the instance where the respondent just has not made out a case, has not responded to the facts as found in the by me in the applicant's
But
affidavit.
that's where the facts are common cause. So applicant says, this is what happened. The respondent says, I admit that that is what has happened. So that's common cause.
Yes.
So I'm talking about where there are disputes of fact. How does the Plaskon-Evans rule apply?
Yes, when there's a dispute of fact, then, yeah, I would not be able to find in favor of the applicant in that circumstances. I would have to consider whether I need to refer that matter to oral evidence on perhaps a specific issue with regard relating to that disputed fact. I could also give directions with regard to how that oral evidence should be heard and who should be subpoenaed. Of course, I can grant absolution from instance as well. Yeah, that's what comes to mind.
Grant absolution in an application?
No, not in an application, no.
All right, anyway, let's move on. That was not the question I had raised my hand to ask. I was taken aback when I saw the comment by the GCB that there was a day bonus, a personal cost order against you. I thought it's GCB. All right. I'm corrected that it's the AFT, not the GCB. I thought it was the GCB.
It is the GCB, Commissioner.
Yes, all right, then I'm correct. That there was a personal cost order against you in 2019, which you did not disclose when you applied, when you had a duty to disclose it. Can you explain why you did not disclose it?
It's an error of judgment on my side, and I apologize profusely for that oversight. It didn't even cross my mind at that time when I completed this application form. So I am grateful to the General Counsel of the Bar. AFT also mentioned it in their response that I ought to have disclosed it. But in terms of the question that was asked on the questionnaire, I did not regard that order against me, that I was in any way dishonest. It could happen to anyone. It happened in my practice, which is unfortunate. I took responsibility. I acted on it. I paid that debt, and I put remedial action in my practice immediately following that judgment.
No, I'm just asking about why.
Yes, why I did not.
You did not disclose it. That's the first concern of the GCB.
Yes, I apologize. I should have disclosed it. I didn't. In hindsight, it was my error of judgment, probably because I didn't regard it as damaging my reputation. I didn't regard it as bringing the judiciary into disrepute.
The second thing I was taken aback by is how you explain the basis for the day bonus, because you say it was because you failed to index and paginate, which then forced me to go to the Ebenezer judgment to read why you were mulcted with a personal cost. And I realized that what you said is an under-disclosure. It is a series of lapses in litigation against a series of notices that were given to you by Judge Mir, which you ignored. It was not just failure to paginate and index. And I'm very worried about what you did in your response to the GCB, because it seemed to me you were still not taking responsibility.
I think I did, with due respect, if you look at, Commissioner, if you look at my response, which was very short because I only received these comments a day before the closing date. I'd said it was a lesson learned which made me stronger and more vigilant in my supervision of staff. I respectfully submit that it was a human error, which is regrettable. I can assure the Commission that this experience will not detract from my judicial duties in any way, and that since the order was granted, I have put strict controls in place with my staff and took the necessary remedial action. That lesson has made me a better person.
No, the problem is the explanation you give why there was a personal cost order is paragraph 6, where you say the pagination and indexing were not done timeously, which led to Judge Mir granting an order against me. That is what I have a problem with. The explanation you give why there was a cost order does not tally with the reasons in the judgment why there was a personal cost order. An index and a pagination ordinarily, in fact, I thought this is an unreasonable judgment because a failure to index and paginate would not attract a personal cost order, which is why I went to the judgment and I saw that actually this statement is an under-declaration because it is a series of lapses against a series of warnings that led to the personal cost order.
It's regrettable, Commissioner. It's an unfortunate phase in my practice. First time it happened in so many years.
No,
and
but it's the explanation you are giving to us that I'm worried about. Because I can understand that in your practice you will make a mistake. I've made many mistakes. But the issue is you are now before us, you are called out on it. And the way you are responding to it leaves me very, very worried.
But perhaps if I can reply that I was given very little time. I was told that this was due, I think it was the next day or the morning when I made the decision. First I was told that this was not an objection. It was a comment and that I did not need to respond. I then wrote to the Secretariat and said, "Are you sure?" Secretariat came back to me and said, "Yes, we normally only write to candidates and call for their response if it is an objection." I slept on it. I woke up the next morning and I decided that I still needed to address it, which I did in the morning, and this was then sent off. Perhaps I should have been more, perhaps I should have elaborated in more detail, which I did not do, and I also apologize for that.
Thank you, Chief Justice.
Just a follow-up on
Yep.
part of your exchange with Commissioner Mdntv. In what kind of proceedings and in which circumstances may absolution from the instance be granted?
Absolution of the instance?
You mentioned absolution from the instance.
Yes, in civil matters, when the plaintiff just had no case before me, I would grant absolution from the instance.
All right, thank you. Minister?
CJ, so I just have a follow-up on the exchange with Commissioner Mdntv. Ms. Parker, sorry, the Commissioner dealt at the end quite extensively with your under-disclosure, but I'm equally concerned about now having had the chance to reflect on this. You still seem to play down the severity of such a cost order. I mean, it is commonly known as one of the most dismissive actions a judge can take not disfavor, but disdain for how matters were conducted before it. It's not something that's issued because somebody filed papers a day late, or it's usually done and reserved in the most extreme cases of legal, I suppose, delinquency. And I'm concerned that you downplaying that is also, I don't know what to make of that. And I would just like to, well, I suppose I'm pointing it out, and you're free to reply to that.
CJ, I have a related follow-up. May I follow up on that? Yes. Ms. Parker, good afternoon.
Good afternoon.
I thought she was still answering.
I'm doing a follow-up on that.
Had she answered already?
She hadn't yet started.
Oh,
I just wanted to, so that she answers once.
Okay,
Maybe I'm
okay.
being inarticulate. I'm sorry.
Okay.
I'm sorry. Yes, Ms. Parker, perhaps just to complete the picture, you were punished with this cost order, de bonis, because of a postponement of trial that was set down for 3 weeks. So it was a serious matter. It wasn't just filing, it wasn't ignoring notices. I've had a look at the judgment. The matter had been set down for 3 weeks according to the judgment, and it had to be postponed because it wasn't trial ready. Now, the concern from your declaration, but also your responses now, is there seems to be a lack of candor over and above the concern of you seem to default easily to, well, I paid, I put in place systems in the office, but the fundamental issue is the appearances of lack of candor in your disclosure about this, and whether you appreciate the seriousness of it. You may comment if you want to.
I do appreciate the seriousness of it. If I had been more prudent, I should have included it in the first place when I had applied to the JSC. I should have then addressed the full issue with regard to how the order was made against me, and I should have also addressed the issue with regard to the acceptance that it is my error emphatically. I didn't do so, and I cannot take it any further than that, except to say that on the day, the matter was going to be set down for January, end of January, and a few days in February. It wasn't for 3 weeks. However, when Judge Meir had called for a meeting to discuss the fact that the files were in a disarray, at that stage, I did have issues with my service provider, including the state attorney, who did not give me mandates timeously. Judge Meir, in the judgment, said I should have brought that to the attention of the court. At that point in time, it was very difficult to tell a judge that the person that's giving me instructions aren't giving it timeously. I had, in the period December to January, lined up the cultural historian, the historian, the valuer, the agriculturalist, the actuary as well, to be able to get the matter trial ready. However, it was the landowners who rightfully complained that the files were in a disarray because the indexes just didn't match their papers, and we are talking 47 volumes. I've accepted the responsibility for it. When the judge president had postponed it to the 18th of April, I think that was the date, she had asked me to please file an affidavit, which I did, setting out the difficulties that I had and the challenges. That was not acceptable to Judge Meir, and I accepted that. I immediately told my clients that I would not be able to act for them any longer. And a new service provider was then made a provision for. I handed over the files, and within a month later, the issue of dispossession was settled. And I would like to believe it's that hard
CJ,
work.
Commissioner Hassan, apologies for the interruption. I think There's just, it's an important follow-up because it is related, Ms. Parker, sorry, over here, to paragraph 54 of the same judgment where AJP Mir says, in my view, the conduct of Parker substantially materially deviated from the standard expected legal practitioners, etc. And it talks about a serious dereliction of duty which prejudiced all the parties. So I won't read that whole paragraph, but I think it's important to emphasize that. And also, you're speaking now, Ms. Parker, around what happened after. In paragraph 9 of your response to the comments from both AFT and GCB rather, you said you were, however, relieved that when you learned that the matter was settled shortly after the order against you, and you'd like to believe it was the hard work you put in regarding the appointment of experts who saw it come to fruition. And I have a concern with that statement because I think it does lack accountability. I accept the argument that you've been making, but to say that in a response almost says, well, even though I did this really terrible thing, even though there's paragraph 54, which is extremely damning from a very senior judge in the country, and then to say, well, it was settled shortly because of my hard work, I do have concerns with that. And I really wonder if your remarks, I mean, do you think they have an impact on your reputation, on your integrity? Thank you, CJ. Sorry to have interrupted.
I didn't, yeah, perhaps I should, I put in the paragraph 9. Paragraph 8 and 9 was basic, it was basically just to reflect on what I had put in. I accept I should have, perhaps my error that I did was just to give this response was too brief. It should have had far more meat to it. Particularly that I received the objections, the comments so late. As bringing my reputation into disrepute, and I think it stems from that. If that is how it is viewed, and I agree with Commissioner Bishop, it is a serious order, but I didn't see the connection with it bringing my reputation into disrepute. I accept that the negligence was, as a result, was in my hands.
Minister. Thank you very much. Good afternoon, Ms. Parker. I just want to check in the letters of support, there's Khoi Cultural Heritage Development, which says you have played a pivotal role in the achievement of something. It's not fully descriptive, but with regard to Norfolk Skral community. Are you assisting the community and how?
Thank you very much, Commissioner. Yes, I am. It's still a matter which is at my firm, of course, because I'm acting. I cannot be the legal representative, so I've given it to another person in the firm. When I'm done with my acting stints, I would go back and be the legal representative. That's an action which I've defended against an eviction of several families. It's called Knoffelskral in the Grabouw area. Where I defended the case, where I am, my firm, well, I defended it, but now, of course, I'm acting, I can't be involved in the matter, so I'm referring it as I am defending that community against the Department of Forestry and Fisheries. It's sub judice at the moment.
Okay, I was asking it understanding that it is sub judice, but I just wanted to understand the role you were playing and you are possibly playing now. In light of the very same, and maybe if you could be able to differentiate time-wise for commissioners, when did you start to assist and when did you cede to another? So one is certain that there is no crossroads that you are playing in this matter, at least.
Thank you.
So I don't want the substance of the case.
No,
I just want the procedure and the process.
Yes. Commissioner, I would never, I will be failing in my judicial duty to sit as an acting judge and still consult with clients and draft pleadings. I don't do that. This case came to me before I became an acting judge, where I was asked to defend communities in Knoffelskral. They intend to bring the land claim in due course whenever the Constitutional Court is satisfied that the backlog is done and the gates can be opened for new claims. They were faced with eviction. They believe that this is their ancestral land. They're in indigenous Gainakwa tribe, Commissioner.
Chief Justice, I'm sorry to sound like when did you start acting? And when was the case referred?
The case was referred probably at the beginning of 2023, and I only started acting in July.
Good afternoon, Ms. Park. I'm sorry, how do you pronounce your name?
Pangaka. Good
Pangaka.
afternoon, Chief Justice.
Are you
and
comfortable?
congratulations on your appointment.
Thank you.
And good afternoon, Commissioners.
You comfortable over there?
Yes, thank you.
Right. You have a BA degree from UCT?
Yes, BA law.
And then BA law?
Yes.
That's not what your questionnaire says. You just said BA. And an LLB from the University of the Western Cape?
Yes, LLB from the University of the Western Cape.
All right. You were an attorney between 1995 when you started your articles until 2002.
Yes.
And then went into the magistracy. Your form says you were an additional magistrate from 6 May 2002, and then lists the ranks through which you went in the magistracy. But then it stops in March 2015 when you were a regional magistrate, and speaks about your acting stints as a judge. Does that mean between March 2015 and 2021, you've remained a regional magistrate, or you stopped working because...
No, I am, apologies for
You're
that.
still a regional magistrate.
I am a regional court magistrate, and I listed, simply listed the acting appointments in 2021, 23, and 24.
So it's March 2015 to date?
Yes, to date.
All right. Okay. And you've acted periodically since 2021 until this year?
Yes, that's correct. I am currently acting.
Or you are acting as we speak?
Yes.
In this division to which you seek employment?
Yes, in the Western Cape High Court.
You've applied. All right. And how long have your acting stints, what do they amount to?
They amount to, in total, it would be 8 terms, and again, currently 8 weeks. On my calculation, it comes to about 1 year and 8, or 1 year and almost 9 months. So that's the total period from 2021 to currently, as at today's date.
All right. When did you start acting?
I started
during
acting
this last stint? You say you're acting now?
Yes, I'm acting now.
Since when?
So I started acting in April of last year, so the second term of last year. And I continued acting, but the first term of this year was not a full term.
All right. You went back?
I was in the regional court, yes, when I'm not acting.
You don't have any parted matters
No,
in your regular job?
No. So in my latest note, if Chief Justice, if you received it that I sent, I think over the weekend, I do indicate that I currently have no more regional court matters. At the time of my application, I had a divorce parted, which was argued during the recess, and I then delivered judgment a couple of days later, and that matter's finalized. So that was my last regional court matter.
What kind of work did you do as an attorney?
As an attorney, the majority of the work I did was criminal, but I also did civil work, family law matters, and administration of deceased estates. But the bulk of it was really criminal
work. So that's your area of expertise.
It was during the period that I was an attorney.
In the High Court, you do all the work?
Yes. So I've been fortunate also a few terms ago to have been given an opportunity to do pre-trials, civil as well as criminal. I think the only work I haven't done in the High Court would be shipping and tax, but I've been exposed to quite a variety of matters.
You've sat in motions, opposed
Yes.
and unopposed, and civil trials.
Yes.
And appeals.
Yes.
Okay. And written judgments.
Yes, I have 84 written judgments over the period that I started acting in 2021. I can't give you an exact figure on my extempores, but it would be over 20. But it's 84 written judgments.
And they cover the spectrum, civil and criminal.
Yes.
I see that you spearheaded the introduction of civil regional courts.
It was with the regional court president, myself and two colleagues, the one colleague being Judge Lekuleni at the time. So we were invited to act in the regional court at the time when the new regional court, civil courts commenced. And we had civil experience, and we also had experience in divorce matters. And I think hence we were requested to spearhead and train existing regional court magistrates who had criminal experience in divorce matters.
Do you have any judgments, outstanding judgments reserved for more than 3 months?
I have one at the moment that I'm busy with.
Older than 3 months?
It's a few days after 3 months, and I'm delivering it in this month, in October.
All right. Acting Judge President Goliath.
Thank you, Chief Justice. I've observed your career trajectory. It appears as if you have quite substantial experience within the magistracy following your period as an attorney.
Yes, Acting Judge President, I've been, on my calculation, if we count from 2002, it's about, I think, 22 and a half years as a magistrate. The last 14 years, if I count my acting period, it would be acting in the regional court, that is. So the last 14 years would be in the regional court, acting as well as permanent, yes.
So you started out 2021, and then you went back to the magistracy, and you came back 2023 and 2024. How did that impact on your development as an acting judge?
I would definitely, so in 2021 I had 3 terms, and I recall in my first interview, some of the comments were that I needed more experience, and I'm very grateful to have been given that experience since last year. And so I've been exposed to, I think, a wider variety of matters, and been given the opportunity to apply myself in some complex matters. So it has definitely provided more experience and growth as well as an acting judge.
How many reported judgments do you have?
I have, I checked recently and I now have one more, so I have 7 reported judgments. One I have to qualify is a judgment that's co-written with Justice Henny. There is another matter, another judgment where AJP, you and I sat together, but you were the scribe, so I have not included that in my total of 7.
Were any of your matters overturned on appeal?
Thus far, no. 3 went on appeal, as I've indicated. In 2, I granted leave to the SCA. Both appeals were dismissed. And in another matter, I refused leave. The SCA was petitioned, and that court then granted leave to the full bench. And the full bench heard the appeal, and judgment was delivered, I think, in February, and that appeal was also dismissed. So I'm not aware, on my research, as well as with the assistance of the researcher at court, I'm not aware of any current appeals pending in respect of any of my judgments.
What was your experience with regard to the support provided by the judges in the division, the support provided to acting judges?
I think, if I can put it this way, I think the judges, all the judges at the Western Cape High Court should be commended. They have assisted me, and not only me from my observations, other acting judges. They are always available to assist. I have had occasion where, for example, on a motion court day in the morning, something has cropped up and I needed to run something by a judge, and the judges avail themselves. So I think it's exemplary, and for anyone who starts acting there and who continues to act, all the judges have been of assistance, whether you sit with them in appeals or not. So I've had a very good experience, and that experience continues.
You were involved in SAJA training?
Yes. I can't recall if I volunteered or if one of the regional court presidents had put my name forward. It was quite a while ago. And I was a facilitator for SAJA, particularly during my regional court years, and mainly in respect of civil procedure, civil matters, and matrimonial matters and divorces.
Thank you very much, Chief Justice. I would just like to place on record that there was an issue raised regarding 2 late judgments. Myself and the ADJP were apprised of the circumstances, and I wish to place on record that the circumstances were extraordinary, which resulted in 2 late judgments. Thank you, Chief Justice.
Thank you, AJP. She had an emergency family situation, as you understand.
Yes, that is correct.
No, thank you. Mr. Boshoff?
Thank you, CJ. Good afternoon.
Good afternoon, Commissioner.
So the Western Cape Division is, given its location, it's burdened with quite a heavy administrative law caseload. So I just want to ask some questions on that front. Let's say an unsuccessful candidate were to approach the Commission and say, I want access to your records and your deliberations, etc. But instead of relying on PIA, they rely directly on Section 32 of the Constitution, which guarantees the right to access to information. Would that be appropriate? And let's say we refuse. This commission still refuses. The the candidate were to go to court, and they then, would it be appropriate to rely solely on Section 32 rather than PIA as the source for their right?
I would say in the circumstances, they would first have to exhaust PIA. I would say that they would not, let me perhaps put it, there's a tier in terms of which there are principles, there are remedies, there's legislation available. So if PIA is the legislation available for them, then that would be the first avenue available to them, as opposed to the protection of their right in terms of the Constitution sort of immediately. So that would be my answer to your question.
Yes, no, thank you. And courts have commonly referred to that as subsidiarity.
Yes.
Yes, all right. My next question then is, a private developer has a piece of land, the municipality identifies it and sees, listen, we would like to purchase this land from you because we have human settlements need. Let's talk, they make a price, they come to an agreement, conclude an agreement. Then subsequently arises that, it comes to the fore that the municipality, there was no council resolution in terms of, as required by the MFMA, for example. And the municipality now says, sorry, we want out. The developer or the landowner then runs to court and says, I want to hold the municipality, I want the court to enforce this agreement, and I'm relying on estoppel. Because as an innocent third party, or they can't raise their own shortcomings, and if that were to fail, then I'm also going to rely on the so-called Turquant principle, because as an innocent outsider, I'm entitled to act, on a bona fide reliance that they've complied with their internal processes, etc. Would a court entertain such an approach? Or maybe that's poorly stated. Would such an argument hold in law from the developer now?
I think the Turquant rule is there to protect the third parties, or a third party, in respect of the conclusion, let's say in this instance, of a contract with the developer. It would therefore mean that they can assume that the developer has...
Sorry, just remember, it's the developer invoking this now in court.
The developer is invoking it.
The developer is saying, I don't care what you complied with and didn't comply with. I assumed in good faith you did comply with it. Therefore, I'm relying on the Turquant principle. I'm asking the court to enforce this contract because of my reliance.
I would say that the Turquant rule is available to them in the circumstances in light of the circumstances that you have raised.
Can I perhaps then just clarify that? I'm anticipating my fellow commissioners follows. Put more plainly, can a court, through estoppel or the Turquant rule, enforce an action that would otherwise amount to an unlawful act by the municipality, or something ultra vires, beyond their powers normally?
No.
Okay, that's fine.
That would be my answer.
Thank you.
Commissioner Matthews?
Ms. Pangak, Parker.
Yes, good day.
Thank you for coming.
Thank you.
I understand that you have done a lot in terms of mentoring and assisting juniors in the bar. Can you elaborate on this?
May
And your commitment to transformation?
Yeah, Commissioner, may I just ask, are you speaking about juniors in the legal profession?
Yes, yes.
So I can start by saying the following. I think my commitment started way back when I was a candidate attorney in the 90s, 1995. At that stage, at Legal Aid, I was at Legal Aid for a while, and I then assisted two more junior candidate attorneys, if I can put it that way. And at the time, in the criminal courts where we were based, Afrikaans was the language that was spoken by accused persons in court. So I had assisted them. I assisted them in the drafting of guilty pleas, consultation with their clients, and to such an extent that these colleagues were able to adequately then conduct proceedings. I'm not saying that there were no interpreters, there were interpreters, but it was in a period where English was not the language of record yet in courts. And if I were to move a bit forward, and these colleagues of mine have now themselves become, I think, magistrates, and the one colleague I know had acted as a magistrate, and they were not from the Western Cape. And as a magistrate, what I have done, and it's something that I continue doing, I think the passing on of skills and upliftment is something that occurs within the courtroom. So I would have candidate attorneys who have just obtained the right of appearance in the regional court, and it's a civil regional court, for example, and they would, for example, come with a few questions that they would ask a divorced client. And in many instances, it would not be sufficient. And before I can finalize a divorce, I would obviously need to know that and be able to find that a marriage is broken down irretrievably. And so I would assist in that fashion. And on many occasions, these candidates would remain in the courtroom. And I would later on be informed, well, we've learned a lot from you simply just sitting in court and learning about civil procedure and matrimonial matters.
Okay, thank you. You have answered my question. Thank you,
very
CJ.
much.
Commissioner Godson?
Thank you, CJ. Good afternoon, Ms.
Good
Bangalter.
afternoon, Commissioner.
You list as one of your reported cases a matter involving Mr. Kulu and his law firm.
Yes.
It's the contempt of court matter, which was based on the misappropriation of large sums of money
Yes.
from the Department of Environmental Affairs. Now, you were tasked with this very sensitive matter early on as an acting judge, and you concluded it without fear or favor. Given the preceding Mulahutsi judgment, which had at that stage already shone the light on the judge president's conduct in favor of his attorney, did you have any apprehension that finding Mr. Kulu guilty of contempt may have an adverse consequence on your professional career? And I say this because in the context that Mr. Kulu had at the time also pursued JSC complaints against the judges who had made rulings against him prior in that litigation, including Constitutional Court Judge Owen Rogers.
Yes. So, Commissioner, you are quite correct that, if my memory serves me correctly, I started acting in January 2021. I was the urgent duty court judge for 3 days in a row, and that matter landed in my lap. I was acting for about 5 weeks at the time that matter came before me. And I think if I could put it, and I don't mean any disrespect colloquially, there was a lot of noise about it. I believe, if I recall, it was reported, it received media attention. And if you read my judgment, you would also see that at some stage in the proceedings, I had been informed that I can't hear the matter, something to that effect. That aspect is dealt with in the judgment as well. At the time, to answer your question, no, I did not have any fear or idea that this would affect my further acting prospects. I dealt with the matter, obviously aware that at the time this was the Judge President's attorney, he had represented him, and I, for want of a better word, divorced myself from outside noise, from any media reports or anything to that effect. I do all my judgments at home as far as possible, and I had practically locked myself up and without any outside noise. I then delivered the judgment, and of course, at that stage, I believe there were comments and feedback, and people had come to me with their own views about the judgment. If I can describe it further, that was a moment where I must say that when the judgment was sent out, I had this idea that yes, it could possibly affect my acting potential at some stage. But I went ahead and did my job and what was required of me. Who was involved or not involved was not an issue for me. And because everybody is treated fairly and the litigants in that matter were all treated with respect, as I always do, I think it was only afterwards that when I heard people's views on this matter and the fact that I delivered such a judgment, some were of the view that, well, this is a very brave thing to do, being an acting judge at the time in this particular division. And I actually didn't really appreciate it at the time. But whether it affected my acting prospects then, I can't really say. I was later on invited to act again. Sometimes I think there comes a time, and I can only speak about my own career, where you walk into court and you know for a fact that you are going to dispense justice without fear, favor, or prejudice. You are going to uphold the rule of law, as I did in that matter, and you are going to uphold the provisions and the principles of the Constitution. But there's perhaps a slight, I don't know, you know that there's going to be some kind of effect, potentially. There was an indication of, oh, I will be reported to the JSC for delivering a judgment like that. And so I had to do what I had to do, and I had to acquit myself of my judicial responsibility, which is what I did. And I would like to think, as somebody had said to me, an advocate at the time, that what I did was actually courageous as a judicial officer, and particularly, I think, an acting judge in that division. It's not how I saw myself, but that was one of the comments. So I hope that answers your question.
Thank you, Ms. Bengal.
Thank you very much.
CJ, just a follow-up on that? Sorry, just very briefly. I can't remember, it's, I tried to check now, but it's coming back to, there was a leave to appeal application, yes. But was it ever prosecuted?
The leave to appeal, and I checked because I think one of the commissioners asked me on the previous occasion about it. So the judgment and the orders were against Mr. Kulu and then his firm. So I had refused leave to appeal, and I went to the SCA. The SCA refused leave in respect of Mr. Kulu, but it had granted leave in respect of BXI, his firm. My further understanding is that the appeal had then lapsed. That is, when I completed my questionnaire for this interview, that was the latest information that I had.
Thank you.
Thank you.
Commissioner Marumagay?
Thank you very much, CJ. Good afternoon.
Good afternoon, Commissioner.
Earlier on, when you were speaking, you referred to one of your judgments that was taken on special leave to appeal, but leave was granted to the full court of the High Court.
Yes.
Yes. I'm not going to ask you about that judgment.
Okay.
There's a principle that comes out of that scenario that I want to ask you about, that arises directly from the rules.
Sure.
Rule 4913, you don't need to know this, I'm just giving you context so that you understand the question.
Sure.
Rule 4913 of the Uniform Rules of Code, it dictates that when somebody has been granted leave to appeal, they need to furnish security for costs, or they can be exempted upon request to furnish those securities. But when the judge that leave to appeal is sought from refuses leave to appeal, and then they have to petition the Supreme Court of Appeal, and then the Supreme Court of Appeal grants leave to the full court. In that situation, is the person who's successful at the Supreme Court of Appeal and who was not successful at the High Court with a single judge obliged to furnish security for costs? I'm not sure, do you get the question?
Do you mind if I ask you just to repeat the last part for me,
The last
please?
part is, once leave has been refused by a single judge
Yes.
in the High Court, and then the person is not happy with that decision, then petitions the
Yes.
Supreme Court of Appeal, and the Supreme Court of Appeal grants special leave for that person to appeal to the Supreme Court of Appeal. Then the Supreme Court of Appeal says, we are not going to hear this appeal. Go back to the full court, which should then hear the appeal. Under those circumstances, is the person who is successful at the Supreme Court of Appeal obliged to furnish security for costs?
I would say no. I think the outcome, one would need to determine what the outcome is of the appeal. So in those circumstances, I would say no. He's not obliged to pay security for costs at that stage.
Okay. No, thank you very much. Thank you very much, CJ.
Commissioner Hassan? Is it
Thank you very much, CJ. I'm over here. Thank you. I want to ask two questions. The first is, what is the difference between reading in and reading down of a statute by the court?
I would say that reading in would be a question of interpretation. Adding, or perhaps not adding, but depending on the circumstances that one's dealing with, I would say that reading in would be where one interprets the statute in a certain way, depending on circumstances which prevail in a particular matter. Reading down, I'm not entirely sure, but I would say that reading down would be where you are excluding something from the statute or from an interpretation process.
May I?
So may I follow up on this?
Sure.
Can I have, I'm not too sure if I get too correct. Of course, we are correct that this is often referred to in the interpretation of a statute where you are invalidating or you are saying a statute. So, would I be correct to say reading in would mean you read in some words that are not there, where the intention of the statute you can understand, but there are some words that are not, there are gaps in the statute. Is it not such a situation?
I would think, but I would think that one would need to qualify, and that it's not to an extent that the meaning of the statute or the section is changed. That would be my understanding of it.
No, let me follow up with this because I'm not sure what is going on now, Ms. Pangaka. You see, there are various remedies that a judge can give in a constitutional challenge, correct?
Yes, thank you.
And the power comes from Section 172 of the Constitution, correct?
Yes.
Sometimes you can say that I hereby declare that Section 20 of the Sexual Offences Act is unconstitutional. Parliament must fix it. And you do nothing else, correct? That's one possibility.
That is a possibility.
Yes, and then sometimes you can say, no, I don't have time to wait for Parliament to fix it. I need it to be fixed now. Correct?
Yes.
And then in those circumstances, then the judge will provide his or her own words in the statute, how the statute must be understood from that day onwards. Correct?
I follow you, Commissioner, yes.
And then, so there is a term for that. When a judge is doing that, there is a term for it. So, and it's self-explanatory. He's reading into the statute his own words. So isn't that reading in?
In the explanation that you've given, I would have to agree with you,
Yes.
Commissioner.
Now, there is then another scenario. The judge looks at the statute and says, no, I don't want to make any declaration of any invalidity, but I want to interpret it narrowly so as to limit its scope or limit its impact or limit its effect. I'm not adding anything, it's there, but I'm defining what it means. And doesn't the judge have the power under Section 39 of the Constitution to do that?
Yes, and that, I would say in terms of Section 39, the judge would also have, depending on what it is, extending the common law. If it is
No,
not.
let's forget about the common law
Okay.
now because we have to answer Commissioner Hassan. So when the judge is now interpreting narrowly the scope of a section, there is also a technical term for that. Isn't it reading down?
Then the judge would be reading down.
Yes, so then isn't that the answer to both of those questions?
Yes, thank you,
Which means
Commissioner.
that you understand both of them. Thank you.
And colleagues, what Commissioners Nokese and Nokai Toby have just done is what takes time. When a candidate gives an incorrect answer, whilst the exercise is educational, you want to put them through the paces and give them the right answer, and that takes time. And you complain that we delay things. Thank you.
CJ, may I ask my last question? Quickly?
JP Mlambo.
CJ, may I ask my second question just before? Through you?
Okay.
Thank you. My second question is whether the court is entitled to reject an expert opinion, and if so, under which circumstances?
Yes, the court is not bound by expert opinion. Ultimately, the court is in the best position to make a determination insofar as evidence-led where an expert is called. I think one must take into account the nature of the expert evidence given, the particular area of whatever the subject is that the expert is testifying about, how the expert logically came to his or her conclusions, and what basis and what material, if I could put it that way, the expert has relied upon. But ultimately, the fact that one calls an expert to come and testify does not necessarily mean that you are bound by the expert's testimony and that you have to accept it. I can also probably add that, you know, how the witness fares in the witness box and under cross-examination is also a determination that you must take into account. Thank you.
Did have my question, CJ.
No, you've exhausted your quota, I'm afraid. We still have two candidates to interview.
I accept.
Commissioner.
I'm not going to say anything. Thank you, Chief.
Thank you. Thank you, Ms. Pangaka. You're excused.
Thank you very much, Commissioners. Thank you.
Usakuthela amanzi. Good afternoon, Ms. Khalakhala.
Good afternoon, CJ.
Are you well?
I'm well, and how are you?
I'm fine, thanks. Have you been here before?
No, I haven't.
You have not applied before?
No, I haven't.
Okay, then I must know you from somewhere else. You look very familiar. You obtained a BUris degree from the University of Transkei and then an LLB from the University of the Western Cape.
Yes, CJ.
And then started a legal career in 1997 as a prosecutor.
Yes.
Worked your way up there through the district court, regional court, until you were a regional court prosecutor.
Correct, CJ.
Then a control prosecutor, district and regional courts. What does that mean?
You control the district court, the prosecutors. You guide them in respect of the matters that they be dealing with. Our situation in Khayelitsha was unique because there was only one control prosecutor for both the district court as well as the regional court. So I had to do controlling of both the district court as well as the regional court.
And Khayelitsha was where you had helped establish a sexual offences court.
Yes, CJ.
Then you became a magistrate in late
Yes, in
2005.
2005, yes.
And rose through the ranks there as well until you became a regional magistrate in 2015,
Correct, CJ.
which you still are now.
Yes.
You have where? In the Western Cape?
I'm in the Western Cape in Wynberg Regional Court.
All right. And you acted in the High Court between April 2022 until September 2023.
Yes, CJ. And I went back last term, so I'm still there this term as well.
Oh, all right. And how long does your acting stint amount to then?
It's, when I checked, it was about 65 weeks.
65 weeks. All right. And during that time, you've done civil work and criminal work and everything else in between?
Yes, I've done mostly civil work and a bit of criminal work.
You did do civil work in the regional court as well?
I did do civil work in the district court as well as in the regional court, and I'm still in the civil court in the regional court before I came to, I went to the High Court to act last time.
Okay. You've written judgments in the High Court?
Yes, CJ, I have.
How many?
And I calculated it is now 67 judgments that I've written.
Any of them reported?
3 of those have been reported.
Okay. Well, I don't want to assume anything. You've sat in motion courts?
I've sat in motion court.
Civil trials?
Civil trials. I've sat in
civil appeals,
full court and full bench appeals. And I've also dealt with pre-trials. I did opposed and unopposed motions, and chamber work, of course.
You said you've done just a bit of criminal work in the High Court.
In the High Court, I did a bit of criminal. I did about a few criminal trials. I think this one that I'm busy with is the 4th one. I've done criminal appeals, dealt with petitions and criminal matters, and yes, and reviews.
Do you have any outstanding judgments that are older than 3 months?
No, CJ, I don't.
Okay. And you reckon that you are ready for permanent appointment in the High Court now?
Yes, I do. I believe that I'm ready. The time that I've spent there had readied me.
All right. Although the GCB thinks that you're a bit thin on civil law, well, they don't say that. They say the candidate's experience of civil law appears to be more limited, whatever that means. What do you have to say to that?
I disagree in that regard. I have been exposed to civil law in the district court. I've dealt with motion court in the district court, opposed and unopposed motions. I've also dealt with trials. And when I got the opportunity to act in the regional court for 1 year and 6 months, I went into an office where there was only one regional magistrate. And at the time, that meant that I would deal with criminal law as well as civil law, inclusive of divorce matters. And when I went to the regional court permanently in 2015, I continued to deal with criminal work as well as civil work. Since I came back from the High Court last year in October 2023, I dealt with a civil work. I'm the only person that deals with the civil court in the regional court in Wynberg currently, until I was invited once again by the AJP to come and act last term.
All right.
AJP.
Thank you very much, Chief Justice. Ms. Khalakhala, I note from your CV that you have attended a substantial number of in-service training and courses during your, in the performance of your work as a magistrate.
Yes, AJP.
How did you find your time at the Western Cape High Court in terms of the support provided to you by the permanent judges?
I must say that initially when I arrived at the High Court, it was a daunting experience. And when I arrived there, I was fortunate to be received by senior judges who were helpful to me. And although the workload was more than the usual that I know, and the complexity of the matters was also more than that I was used to in the regional court, they assisted me and held my hand, and I'm grateful to that, because now I believe that I have acquitted myself in the regional court through that in the High Court, rather, through the assistance that I received when I arrived in the High Court.
But you were there in 2022 and you came back subsequent to a short break.
Yes, AJP.
How did that assist you when you came back in terms of your growth as an acting judge, when you came back after 2022?
Of course, when I came back, it was not the same as it was initially when I went to the High Court. So when I came back this time around, the work was more familiar, and I would say that I was more used to the kind of work that I was exposed to. And I also got to do more work, like I said earlier on, that I also dealt with pre-trials. So that was only when I came back last term that I had to do pre-trials.
You were also involved in subject training. Did you train magistrates?
Yes, AJP. I had an opportunity to train magistrates. I think it was 2019, and it was in respect of sexual offences, because in the regional court for some time I had been involved in sexual offences. And when I was asked by the regional court president at the time to assist in that regard, so I got involved in the training.
You had exposure to both civil and criminal work during your acting stints?
Yes, AJP, I have been exposed to both criminal work as well as civil work. I've been exposed to, I dealt with crime in respect of trials. I dealt with murder trials. I also dealt with rape trials. And currently I'm busy with a matter where the Poker Act is involved. So as I said earlier on, the total number of trials that I've dealt with, including the one that I'm doing now, is 4 in the High Court.
Am I correct that none of your judgments were overturned as at yet? Or what is the position?
As far as I know, AJP, none of my judgments were overturned. I even tried to speak to the Chief Registrar to find out if there are any of my judgments that I might not know of that had been taken on appeal. So she told me that she couldn't find any of those.
Thank you, Chief Justice.
Thank you, AJP. Mr. Boshoff?
Thank you, CJ. Afternoon.
Good afternoon.
Are you well?
Commissioner, I'm well, and how are you?
Yeah, very good, thanks. So the Western Cape Division has quite a heavy administrative law caseload, given its location with seat of Parliament in the province, etc. So I'm just going to ask you, my first question is going to be kind of an administrative law question, and then there'll be a second question. So it has to do with procurement law and supply chain. So, and in particular bid validity periods. So, say for argument's sake, a provincial department puts a tender out, and its bid validity period ends today, the 15th of October. On the 14th of October, they realize, look, the bid evaluation or the bid adjudication committees are a bit pressed for time, they need to deliberate more, whatever, for whatever reasons, they need to extend the bid validity period. So they write to all the bidders, seeking their consent to extend the validity period. On the 16th of October, so the day after the bid validity lapses, well, as advertised, on the 16th of October, they receive positive responses in writing from all the bidders saying, yes, we're perfectly fine with that. In your view, what is the status of that bid? Has it lapsed, notwithstanding the consent on the 16th, or has the 16th breathed life into this bid?
I think I would venture to say, Commissioner, that the consent, which I would say is unanimous in respect of all the bidders, would then breathe life into the bid.
Okay, and then my next question is a general civil procedure question. And it's just, what is your understanding of the current test relating to the appealability of interim orders?
In my view, interim orders appealable are not appealable rather, in that there is still to be a final interim order, a final order that must follow after the interim order was granted. So it will only be the final order that will have to be appealable. Because if we are going to let the interim order be appealable, or the interim interdict be appealed, then we will be dealing with that matter in piecemeal fashion, which is not advisable.
Can I just a follow-up on that? And what if the issues at stake in the subject matter of the interim order of such importance, or the rights affected, so that the interests of justice dictate that, well, maybe a higher court should relook this because the possible harm that would be caused is so severe if it's just left until... Would you think that would potentially offer an alternative?
I would think that if that would be in the interest of justice, and then that order should be appealable.
Okay. Thank you very much. Thank you, CJ.
Okay. Any questions for the candidate commissioners? Oh, it does not appear that we have any questions for you. Any more questions for you, Ms. Kgalagala?
Thank you, CJ.
You are free to go.
Thank you.
Good afternoon, Ms. Van Zyl.
Good afternoon, Chief Justice. Thank you for the opportunity of being here.
It's our pleasure. How are you?
I'm nervous, but I am otherwise well. Thank you, Chief Justice.
It's good to be nervous. You are a product of GovSys. You obtained your BUris cum laude and an LLB there, and then
Yes.
did your LLM in corporate law with UNISA.
Yes, I did the LLM while I was working already. I was working at that stage at the Joburg municipality.
You tutored at UCT for a brief spell.
Yes.
Then worked for the provincial government for another brief spell as a legal admin officer.
Yes.
And then worked for Joburg municipality as a legal advisor
That
for
is-
another shortish spell.
Yes, just after I finished my LLB, Chief Justice, I wanted to spread my wings a little. I came to Cape Town and accepted the position as a tutor at the law faculty at UCT, which was very interesting. And already at that stage, I saw how important it was to inspire students, young people. But thereafter, it was a brief spell. I received an offer to go to the Western Cape provincial government as a legal administration officer. That was for also a fairly short period, just over a year. And from there, I went to Joburg municipality, and there I was for about 2 years before I joined the bar.
All right. But then you decided to join the bar in 2001.
Yes, while I was at the municipality, we very often had interesting local government matters to deal with, amongst others, and we would invariably give those matters over to counsel and attorneys, and I was feeling like I was missing out and inquired about pupillage and decided to go to the bar.
And you never look back.
No, I've enjoyed practice.
What kind of practice have you been running?
It is a fairly general practice, but you would have seen from my application form, I did some criminal law at the beginning of my career, a trial and some appeals. Thereafter, it seemed to morph into a fairly administrative law-laden practice, obviously with aspects of constitutional law that attach to that. I have also done a fair amount of general civil work, contract, commercial work, delect. I've done some arbitrations, tribunals, various tribunals, heritage work, planning, disciplinary hearings. Labor law, again, is a field of the law in which I've only practiced a limited number of times there, so that is also not a big part of my practice. So I would say probably commercial, general civil, and administrative law are the broadest facets of my practice.
All right. And you are an arbitrator as well?
Yes. I've sat as arbitrator in more than one case. I've also obviously taken part as a party, as a representative in arbitrations.
And you have written, was it articles which have been published in LOSA?
I've not written articles published in LOSA, but I have updated 3 of the titles in LOSA.
All right.
Yes.
And you updated interdicts as well?
Yes. That has not yet been published.
I see that. All right. So you want to become a judge now?
I do, Chief Justice.
You've acted in this division in which you seek employment.
Yes, I have. I've acted for basically 60 weeks. That comes to 6.5 terms. That was 3 terms during 2022, 3 during 2023, and then for a month this year, July, August. I'm currently acting as well since the 7th of October. I'm acting until the end of the year.
Okay, and you've had opportunity to write the judgments whilst there?
Yes. I have written 112 judgments by now. There is a list of judgments attached to my application form, just setting out or giving an indication that they cover a fairly wild field. They have been mostly civil, of a civil nature. I have also, however, done a criminal trial, about 9 bail appeals, of 9 criminal appeals, of which I was the scribe in 6 of those appeals. I've done 7 bail appeals, a bail application, countless reviews, automatic reviews from the magistrate's court. I've had a fair spread of work, and very interesting work, for which I've been very grateful.
Yeah. Have you done any criminal work in the High Court?
I have, as I've mentioned earlier, I've done criminal work at the beginning of my career. So it is a long time ago. I acted or represented an accused in what was at that stage something that was very topical, a cash in transit heist. That was a long-running criminal trial. And when I started in legal practice as well, the Legal Aid Board didn't have in-house legal counsel to deal with their criminal appeals. So I did countless criminal appeals on Friday mornings.
All right. And I take it you would have done, you've sat in the criminal court, in the High Court.
I have, Chief Justice, you mean that as a judge?
Yeah.
I've completed 1 criminal trial. I think I mentioned in my application form at that stage, sentence was still to be handed down. I've done so on the 25th of June. That was a 2 accused murder trial in which the minimum sentence legislation was involved. And then, apart from that trial, as I've stated, I've dealt with 9 criminal appeals of a wide-ranging nature, 7 bail appeals, bail application, reviews, criminal reviews from the magistrates' courts.
All right. And you reckon that is enough experience?
One can never have
well,
enough...
I ask because one of the professional bodies has expressed concern about the fact that you seem to have little criminal law experience.
Yes, thank you, Chief Justice. That is, I've read that comment and I've thought about it. It is a very valid remark, but one never stops learning in this job. That was one of the things that impressed me when I first started acting, and I have always tried to tackle whatever I'm allocated head on. I enjoy criminal work. I would like to do more of it, and I believe that with the litigation and general experience that I have, I will be able to deal with criminal matters as and when they come my way.
Okay. There is something else this professional body expresses concern about. They say you have no human rights background and no interest in helping previously disadvantaged communities.
Yes, I've read that.
Is that a fair comment?
I've read that too, and I've thought about it, and I have perhaps not expressed myself clearly enough in my application form. I'm sorry if that is the case. My community, and I think that the comment comes from the fact that I had indicated that I believe in being helpful in my community. Well, my community is South Africa as diverse as it is, and I mean where I practice, where I live. And I have had many opportunities, whether professionally or in my personal capacity as a private citizen, to assist and mentor and uplift. It is true that I am not a member of any organization that goes out to do upliftment work, but I have in the course of my career tried to be available where I can to mentor especially young women, and I'm glad to see that there are so many young women at the bar these days, but I could perhaps even start at my involvement in tutoring at UCT. At that stage already, I could see that there is a need to assist persons who might not have had the educational background that I had, to uplift them, teach them, mentor them, so that they can become fully fledged members of this profession. And I'm glad to say that quite a lot of the people that I met there are respected legal professionals at this point. I've also at the bar mentored 5 pupils. I have been a member of the bar advocacy training program for a long time, sat in countless moot courts on Saturday mornings. I also have an open door approach, and it appears to me that young people, younger practitioners feel comfortable in approaching me with questions. It happens time and again, and I do it gladly, questions about how to approach a matter, looking at pleadings, assisting with the way forward in a matter, sometimes saying, look, you have to settle this. So it's even, I might even point to something that happened the other day while I was acting. A young attorney came to my chambers because I needed to give her directives in relation to an unopposed matter. And after I had assisted her, she told me that she found me to be very kind and helpful, and if she asked whether she could ask me again for advice, to which I said yes. And she said that she would like to be like me. She aspires to be like me in my position one day. So that was extremely humbling. And it shows that if one is kind and open and helpful with everyone who comes across your path, in that small way, one assists in transformation of the mind as well, apart from transformation on a practical racial level. I've also, in my private capacity, I've had the privilege of paying the educational expenses of a young woman who is writing matric this year, and we are looking at college options for next year. And I'm very pleased to say that a door has opened for her. She has options, and she can go out into the world with opportunities that she would not have had I not been able and fortunate enough to assist her.
Thank you, Ms. Van Zyl. AJP?
Thank you, Chief Justice. Advocate Van Zyl, considering the fact that you have written, did you say 112 judgments?
Yes, AJP.
Yeah, I can attest to the fact that you have an excellent work ethic, a very good work ethic. How did you find your acting periods at the Western Cape High Court in relation to the support provided by permanent judges?
Excuse me, AJP, by permanent judges?
Yes, you were there 2022,
yes,
2023, yes. And 2024. What was your experience, and in terms of your relationship with permanent judges and the support provided by permanent judges?
AJP, I was pleasantly surprised at the very, very collegial way in which I was treated. I mean, I'd never acted before 2022. I didn't expect to be treated as an equal, but I felt that I could take part in discussions, I could ask questions. The permanent judges were exceedingly helpful if I felt that I needed assistance on any aspect. And that really made me feel welcome at court. When I go into that building, I feel as if I'm at home. I feel at home there.
Is my impression correct that your strength lies in commercial work?
I would say commercial work as well as administrative work. Civil work, certainly, maybe to put it a little more broadly.
Do you have anything you'd like to say about the workload at the Western Cape High Court? Because the tap never closes.
No, it doesn't, AJP, but that is one of the things that makes the work so interesting. There is work of a wide variety. I enjoy tackling each and every new file that comes across my desk. I am happy to serve the people of the Western Cape. I'm happy to serve the bench in getting that workload down as far as one can. I'm certainly trying to do my best in making a contribution to assist.
Is it 9 reported judgments that you have?
Yes,
Is that
AJP.
the number?
Yes, AJP.
And with regard to any of your matters, were they ever taken on appeal?
Yes, AJP, I've mentioned it in my application form. There was three of them that I'm aware of. The first one, it's on page 21. Let's just make sure. Yes. The first one was a matter in which I granted declaratory and ancillary relief to allow applicants to work as acting sheriffs for a specific period. That matter was taken, I granted leave to appeal in that matter. It was taken on appeal, but ultimately the full bench felt that the issue had become moot by the time that they dealt with it, and they therefore dismissed the appeal for mootness. The second judgment, in which I also granted leave to appeal, was a summary judgment application, in which I had granted summary judgment basically on 3 bases. The full bench held that on 2 of those bases, I should have granted leave to defend because it felt that a tribal issue had been raised on those. And then the third was a judgment that I sat in as a tax, I sat as a tax court under the Tax Administration Act. It was a matter dealing with the interpretation of Rule 32 of the tax court rules. The full bench upheld my judgment. In other words, dismissed the appeal. I do understand that that matter is before the Supreme Court of Appeal at the moment, but it is pending. I do not know what the status thereof is.
Thank you, Chief Justice.
Mr. Bosho?
Thank you, CJ. Afternoon, Ms.
Afternoon.
Mansell.
Afternoon, Mr. Bosho.
So, at risk of preaching to the choir, you would know that the Western Cape Division has quite a heavy administrative law caseload. So I'm just going to ask you 2 broad questions dealing with admin law principles.
Yes, Commissioner.
So the first one deals with interim or so-called Part A and Part B applications Part B is a judicial application for a judicial review of an administrative decision. And then pending that, the applicant then also launches a Part A when it seeks to interdict the furtherance of that administrative decision. So for practical terms, to make it easier, I suppose, let's say it's a tender, an award, so to halt the implementation of the contract, they bring an interdict. There's been a few cases on it, but there's a growing tendency of litigants or applicants to then try and rely on their very right to review, the Part B. They rely on that right to review and the Section 33 right to fair administrative action to establish a prima facie right in order to meet the requirements for an interim interdict. What is your view or your assessment of that and your view on how courts have dealt with that?
Well, there are two aspects, if I understand the question correctly. The first is that one cannot in any event rely directly on Section 33 of the Constitution because of the principle of subsidiarity. In other words, because PAJA has given content to the right to fair administrative action, one goes to PAJA for that relief. But apart from that, in any event, the right to review, that is a right that one has that doesn't need to be protected by an interdict. And that accordingly doesn't give rise to a prima facie right under the principles or the requirements for an interim interdict. One will have to show that that there is some substantive right that will be irreparably harmed should it not be interdict. But that is most certainly not the right to have your review heard in due course.
Okay, thank you. And then the second question is, and I think by way of example, a landowner is approached by the municipality. They show an interest in the land for human settlements development purposes. They negotiate terms, and then it results in the conclusion of a sale agreement. It then subsequently comes to the fore that the municipal council had failed to comply with prescripts empowering provisions in the Municipal Finance Management Act. There was no, let's say there was no council resolution, which was a key empowering requirement to conclude that transaction. As a result of that, the municipality wants to wash its hands of the contract. The landowner goes to court and says, I want to rely on estoppel. I want to ask the court to use my reliance as an innocent third party or an innocent contracting party to enforce this contract and force this contract upon the municipality. In other words, the question is, would a court be within its rights to enforce a contract in circumstances where underlying it is action ultra vires the powers of the municipality, if that makes sense?
It makes sense. Thank you, Commissioner. Well, the first aspect is that one cannot use estoppel to confirm an illegality. And then one goes to the doctrine or principle of legality. All states, including, in this case, municipality, the actions of the municipality must be in accordance with the principle of legality, must be lawful, and within what the municipal powers are, for example, within the context of the MFMA. So, unfortunately, for the third party, he or she would not be able to rely on estoppel in order to enforce that contract. I suppose that, because as I've said, if the municipality's actions are unlawful, that is the end of it.
Just a nuance on that now. Let's say, for instance, it wasn't the case of clear lack of power. They had ostensibly the power, but they hadn't complied with some internal process or something. Would that potentially change the situation?
May I ask, Commissioner, if inherent in that question, the fact that they haven't complied with some internal procedures still rendered the conclusion of the sale unlawful? Because it sounds to me like a reliance on the Toerkant rule, and in that case, that would also not assist the third party.
No, I think we don't need to go any further than that. That's where I was heading with it.
Oh.
Okay. No, thank you very much. Thank you, CJ.
Commissioner Matthews?
CJ, good afternoon, Advocate.
Good afternoon,
Yeah,
Commissioner.
I was not going to ask you a question, but there is this case of SOHCO, Property Investment NPC versus Temet.
Yes.
You know that case?
I remember that case.
This is a case concerning eviction.
Yes, yes.
Now, on the main case, this regarding costs, this is what to say, paragraph 163. There was no reason for costs, including the cost of two counsel, not to follow the event, even though it is unlikely that SOHCO will be able to recover any costs. This is a case based on par. You say, I mean, they don't have money. That's what they say. They cannot afford this cost.
Yes.
But
yes,
nonetheless, I order costs, including costs of two counsel. I'm asking you this question based on the comment against you that you do not uphold the constitutional values. Don't you say that this impact on access to justice?
Thank you for that question, Commissioner. In that case, it was a case in which there were various technical defenses to the application for eviction, and there were many nuances to it, and in my discretion, in the exercise of my discretion, although it appeared to me that the persons who stood to be evicted would probably not be able to pay a cost order, it didn't seem to me to be a case in which I should, only for that reason, deviate from the general rule as to costs.
I mean, the whole issue of land, I mean, that is land occupation and the right to housing, human settlement. This is a contentious issue in the country. And in this case, clearly, these were people, ordinary people, that have been some in those flats. Some have ended because they have no shelter. That's why in your leave to appeal subsequent, you say the municipality must provide to them
yes.
emergency temporal.
Yes. Yes.
Really, did you not have a discretion to exercise regarding costs? Is it not that the cost, in question consideration, of course, has a discretion?
Commissioner, I hear you, and I accept the point. In my consideration of that matter as a whole, of the way in which the litigation had been dealt with and the various aspects that had to be decided, I felt that in the exercise of my discretion, I followed the general rule in relation to cost. But if I have to deal with the same sort of matter again, and there may be other principles involved, other facts, I might well reconsider that.
Yeah. Lastly, in the leave to appeal judgment, again, you make a funny remark because you say, in light of the lapse of time, sorry, just before that, regarding 1% cost, as in the main application, there's no reason for cost not to follow the result, even thought it is unlikely that we'll be able to recover costs and then go on. But very important, this is what.
Yes.
What is before you is the leave to appeal.
Yes.
You decide to dismiss the leave to appeal, but you grant other substantive reliefs where you say the municipality must provide temporal accommodation and you provide a timetable by when these people must be evicted. That was not even before you.
Commissioner, that relief was in fact part of the main judgment, but because of the time that it had taken for the leave to appeal process to be finalized, I extended the time period within which that had to be done in the application, or in my judgment on the application for leave to appeal.
And the essence of my question. The question is that the relief you grant, what was before you was the leave to appeal. That was what was set down.
Yes.
Now, when you give your judgment, you go beyond, you grant some orders where you say the city council must, before a particular date, must give them temporal shelter, they must be removed. You haven't even asked if the municipality would be able to do those. That's what I'm bringing to you, that you grant, you just end on a frolic of your own, because there is no application, you have no basis to do this, even if the application was had late or there was a delay, but you didn't have evidence.
Commissioner, I had the evidence that I obtained in the course of the argument of the main application. If I remember correctly, the reason for the additional, it was an extension of the relief in a sense, if I could remember correctly, in the judgment on leave to appeal arose from the commando judgment in the Supreme Court of Appeal, which indicated that because there was a time lag between the original judgment and when and what would have had to happen to the evictees at that stage, and the judgment given in relation to leave to appeal, there were certain aspects that needed to be tweaked, and additional time had to be given for the municipality to assist. So that was the reason.
Chief Justice, I have no further questions. Thank you.
Commissioner Mangan?
Thank you, Chief Justice. Good afternoon. It's still afternoon. Good afternoon, Advocate. Yeah, just to follow up on this question of the costs,
Yes.
There is also something that bothered me. In the case of Waynard versus the municipality of the City of Cape Town and two others, this was an application for an interdictory relief pending the rezoning. And the municipality, as the first respondent, had actually appointed a senior counsel and or two counsel. And on the costs, you allowed cost of two counsel on a matter that I think it was very simple, which did not require two counsel. And following up on the question that was posed by Commissioner Nojes,
Yes.
it creates an impression that when it comes to costs, you favored the city or the city council.
Commissioner, I most certainly didn't favor the City Council. The City Council was entitled to the cost. Wynand was an application for an interdict with wide-ranging aspects to it, constitutional aspects to it. I certainly thought that the dealing with it justified the use of two counsel, and for that reason, I gave the costs of two counsel. But you would have seen that the municipality asked, or the city asked, for costs on a punitive scale, which I did not grant.
No,
But
so-
it was certainly not in an attempt to favor the municipality. The municipality won this hands down.
And certainly, and that is actually the cause for concern, because the applicants had actually sought to assert their constitutional rights, their right to privacy, their right to property, relying largely on Section 25. And one would have thought that given the fact that this was an interim relief, you would afford them an opportunity to have their matter argued, even if you were to grant costs, and considering that it's an interim one. Those costs, one, either you would have said that the cost would be cost in the main action, or you would have reasoned adequately why you discount the fact that they were advancing constitutional rights, because we know that costs have a chilling effect on litigants. And
Yes.
because the impression created by this judgment and the lack of reasoning on the cost aspect says that they were really being intimidated never to even think of bringing or continue with their Part B of the application for final relief.
Thank you, Commissioner. I'll answer that. I think that the judgment speaks to a large extent for itself what the applicants did. They were seeking an interim interdict, but what was clear from the outset was that, in effect, they were intending to seek a final interdict, stopping the municipality, prohibiting the municipality from ever deciding on a rezoning application. That is not, that takes us back to constraints on the exercise of a municipality's executive power, but be that as it may, the applicants also relied directly on, for example, Section 33 of the Constitution and on Section 195 of the Constitution. They simply had a case which had no merit whatsoever. Now, they did not argue the BioWatch principle in front of me, but I remember thinking about it. BioWatch has a proviso to it, so to speak, to say that even if there are constitutional aspects involved where cases are patently without merit, and I wouldn't have gone so far as calling this case frivolous, but it was without merit, then there's no reason to depart from the general rule that the party bringing, or the unsuccessful party, should pay the costs.
Thank you, Chief Justice. Thank you, Advocate.
Thank you, Commissioner.
President Molenaar.
Thank you, CJ. Good afternoon, Ms. Van Sen.
Good afternoon, Commissioner.
You stated in your questionnaire that criminal law constitutes 5% of your practice. And I think you also stated that you, as an acting judge, you conducted two criminal trials. Is that correct?
Commissioner, no,
Let me rephrase. How many criminal trials did you conduct as an acting judge?
I conducted one criminal trial.
One. What was the duration?
It started mid-2023 and concluded mid-2024. I gave judgment on the merits in February 2024 and judgment on sentence in June.
How many accused persons were involved?
There were 2 accused persons involved. It was a matter where robbery with aggravating circumstances, murder, and defeating the ends of justice.
Have you attached that judgment?
I've not attached it to this. No, I haven't.
If I may ask, why not?
It wasn't a reported one. I understood that reported judgments had to be attached, or 10 of them. Also, it was a judgment that, although it dealt with a fair spread of criminal law issues, I didn't think that there was anything particularly new about it, if I could say it in that sense. I learned a lot from it, but it was a properly reasoned criminal judgment. The accused were found guilty on the basis of circumstantial evidence. There were applications for Section 174 discharge after the close of the state's case. I dealt with that. Minimum sentence legislation was applicable that I had to consider in the course of sentencing.
Thank you. And under what circumstances would you order the holding of a trial within a trial?
If there is a dispute, for example, about the admissibility of certain evidence, such as a confession or certain admissions, other evidence, any aspect without a determination upon which it would hamper the continuation of the trial if one doesn't have a ruling on that aspect before carrying on.
How is it conducted?
Excuse me, I do not
How
understand.
is a trial within a trial conducted? So the trial has begun and you consider it appropriate to hold a trial within a trial. What happens in the trial within a trial?
As far, I confess that I haven't done one, but it is conducted as far as I am aware, and I would have to do research this, as a mini trial within the bigger trial. In other words, one hears evidence about the limited issue at hand from both parties. They can call witnesses if necessary, and then one makes a ruling based upon what comes out of that.
Thank you, Ms. Van Zyl. Thank you, CJ.
There are no more questions for you, Ms. Van Zyl. Oh, I didn't see that hand.
Sorry, CJ. Thank you. Advocate Vinsal over here. Thank you.
Thank you, Commissioner.
Yeah, always easier to do it that way. Advocate, I just want to ask you a little bit further on the transformation matters. And I think it is important because so often we think that we can't make a difference in our everyday lives, right, yes, to the systemic change. And we must be very clear, in order for us to reach the goals of what we want to create South Africa to be, both in a general sense but also in a legal sense, transformation has to be an active process.
Yes. Yes.
Yeah, and I'm glad you agree with that. Because most of the candidates before us today, if you read their paperwork and you've asked them, they've dedicated their entire lives and careers to the transformation of the legal fraternity. And I'm a little bit concerned that, have you done enough to advocate for transformation in the space? I understand that there have been the mentorship of black pupils. You've mentioned a few, but those are assigned. That's important to note. And I think the greater issue here, CJ, is that helping one or two people is not going to systemically change anything. And when you are interviewing for a judicial post, particularly a judge in the Western Cape, I think we do need to see a track record of transformation. Do you have any response?
Yes, I agree with you. I don't think that one can ever do enough. One asks, what is enough? And one can always do more. But as I have mentioned, I have consistently, and not just once or twice, but consistently assisted women of color, through my profession, with what I can give, as I've indicated, I'm very approachable, and that makes people and young colleagues confident enough to ask me at any stage and for any advice. And I think in that way, I have certainly contributed. It is a daily process. It's eating at the bigger pie in small bites. And it is also important. It's important how one treats people, because as I've mentioned, there is transformation stems also from how one deals with people. For example, also how one deals with unrepresented persons, which happens often in court, explaining to them their rights so that they don't feel that they leave the court without having obtained justice or a sense of justice. And then, again, as I've mentioned, at least for one young woman, I have opened doors, and I'm grateful to have done that.
Just as follow-up, CJ, how many Black African women have you brought with you into the space? And I say this because when you have a seat at the table, it's not enough. You need to create a streamline for others who are disadvantaged to enter. And I appreciate individual effort, but I'm trying to show you that we need to do a little bit more. But let me understand, how many Black women have you brought with you?
I'm not sure that I understand Black women.
How many
brought with
Black
me.
African women have you actively, through your practice and through your judicial work, empowered actively? Not passively, actively.
Well, obviously my pupils, I have two of them. Then bringing people into the space actively, and I hear what you're saying, but giving advice, helping them with their cases, helping them with their pleadings, it's difficult to say offhand how many, but I have certainly supported and encouraged, even when people were feeling that they needed to leave the bar, throughout my career. I have tried to.
Okay, thanks. Just in closing, CJ, perhaps there is worth, Advocate Fanzal, to joining some of these organizations and bodies in the legal fraternity, so that you can couple whatever minimal efforts you might be doing to actively empower the Black majority who are disenfranchised in our country. Thank you.
Yes, thank you, Commissioner. I think that my efforts are sustained, and they are, I wouldn't call them necessarily minimal. They may not be organized, but they have made a difference to many people.
No, Chief Justice, let me leave it, because I was also going to talk about transformation, but I think that maybe let me ask, because I was trying to find a way of rescuing the problem, if there is. See, because the AFT from the Western Cape says that you look like you're a good advocate, but we must ask you about transformation, because they themselves, the Black advocates who practice there, are not aware of any role you've played in transformation. Now imagine if the Black advocates in your division don't know what you've done for transformation. We are 3 times removed. So there are many things you can do for transformation.
Yes.
I no longer accept the excuse that, no, I couldn't do anything. So you could join the organizations, you could be in committees, you could be in training, you could be in pupillage, or you could do what Commissioner Hassan is asking, which is, when you are in a brief, you motivate for the inclusion of a Black person. I've looked at your own cases. It's an impressive list. And you've been with top 6 from Cape Town. but I don't see anywhere where there are any black people that you've included yourself with. You could also do things outside of the profession. So there are so many things. But I think the anxiety is you're not coming clear about the tangible things. You talk in nebulous terms about your commitment to transformation, not in tangible terms. So if you could just give us examples, 3 examples, 4 examples, 5 examples that demonstrate your practical commitment to transformation and not in a very generic, high-flowing sense.
Thank you, Commissioner. As I've indicated, I've had black pupils. I have also
Could you just
served-
stop the issue of pupils? Because it's a compulsory requirement of every advocate that they should have pupils. That's not your contribution to transformation. You are forced to have a pupil.
I enjoyed having pupils as well. I was for many years a member of the bar's advocacy pupillage training committee, and in that capacity, I assisted many a black or pupils in general in advancing advocacy techniques. I have also shared fees or reduced my fees in 2 matters so that a black junior could be taken on. One was in a long-running application proceeding in which there was a parastatal involved. The other was in review proceedings against a municipality. And then, as I've mentioned, in my private capacity, I have put someone through school.
Thank you, Chief Justice.
Thank you, Commissioner.
Chief Justice, I think I'll let this pass because I don't think the candidate understands really what transformation is all about. And my problem is that she actually said she read people, she taught people about their rights. That's your job. You are a legal practitioner, you need to do that. But I think I'll leave it there. It's quite sad that you don't understand what transformation is all about. Thanks.
Thank you, Commissioner. I must say that I do not agree that I do not understand what transformation is. I've tried to, in the way that I conduct myself, in the way that I deal with people, promote transformation on all levels. And it's a work in progress, and I'm committed to that.
Commissioner Leganyen.
No, Chief Justice, thank you so much. Good evening, Judge Van Zyl.
Good evening, Commissioner.
I'm sorry to say Steenkamp. Van Zyl. I just want to check if the 2 cases that you mentioned, 1 or 2 cases of transformation, do you still remember the names of those people that you assisted?
Yes. One was Cecil Sagari, who is now a very successful advocate at the Cape Bar. The other one was Adrian Monsiger, who has, in fact, acted in the division recently.
Chief Justice, thank you so much.
Thanks, CJ. Just a closing. So as I understand it, in those cases where you undertook a fee-sharing arrangement, those were quite actually some weighty matters which actually gave those fellow juniors exposure to work that, from my own experience at the bar and subsequently, is quite jealously guarded between seniors and juniors who do get that work.
Yes, it was full-on administrative planning law. The other was about aspects of petrol or fuel setups, the safety circles around it.
And,
So it was important matters.
And what was their contribution to these matters? Did they assist in drafting and consulting and what?
They took part in every part of the proceedings, assisting with consultations, drafting opinions.
Yes, and in fact, if I'm not mistaken, Acting Judge Monsinger actually recently wrote a judgment on the whole reliance on prima facie rights and the right to review in interim interdicts. So clearly, I mean,
You got
there's
something out of it.
Yeah, but I'm trying to say is it has potentially, at least in some way, assisted in the building of further administrative law practices at the Cape Bar, seemingly.
Most certainly, Commissioner.
Thank you, CJ.
The mic is off. You're excused, ma'am. Thank you so much for making yourself available.
Thank you. It was a privilege to be here. Thank you, Commissioners and Chief Justice.
Going to become a judge, and that is a very, very big position. There are many things that judges can do to promote transformation. On the extreme side is Judge Motta, who basically refuses to hear a case until a black person appears. And then on the other side of the spectrum, something I used to do when I was active, both teams come with all white males, and maybe there is a black female on the margins. But to ask the attorneys and the advocates, why are there no black people in the teams?
Yes.
Often, by asking the question, you bring shame to the team, and when they next appear before you, there is in fact a black person. You can do that without spectacle. You can do it privately. You can do it at a pre-hearing meeting. But I find many judges don't do that. They just accept all-white teams. And then they come to the JSC and they protest about the lack of transformation
Indeed.
and a sense of disempowerment on their side. So maybe if you can just give us 2 or 3 things about what you will do. If you're going to follow Judge Mota, fine. If you have a different strategy, outline it.
Thank you, Commissioner. One of the things we do have available to us is, in our division as in the others, is that prior to hearing a matter, the parties file a practice note which sets out the names of the counsel and the attorneys. So if one of the things I would certainly consider doing then is prior even to the matter presenting in court, one could call a meeting with the practitioners appearing. And if it is in case of an all-white team appearing in a matter with no black juniors, call the counsel in and say, it appears to me that the racial composition of these teams is unacceptable.